historical level is at page
Wait, you
30.
agreed with what Judge King just said, that Bruin didn't change Heller, correct?
I agree that Bruin didn't change
All
Heller,
right.
correct. Yes, and so at page, but just as Bruin didn't change Heller, what it did is clarify that many courts had misinterpreted Heller in several ways. One of those ways was applying a tiers of scrutiny analysis, which Bruin made clear was not correct. And another way was with respect to what arms are protected, when Bruin repeatedly said that Americans have a right.
And if Bruin didn't change Heller and our Colby decision, our primary holding
Yes.
was based on Heller,
Right.
then nothing about our primary holding in Colby has been altered.
That is incorrect, Your Honor, just as the
How is
alternative.
that incorrect?
The alternative holding in Colby was to apply intermediate, so this is the point I'm
But
making,
that's
was
the
to apply
alternative holding.
intermediate
Do you
scrutiny.
agree that the primary holding was not addressed at all in Bruin?
I do not agree with that. Bruin,
Show me where in Bruin Colby primary holding was mentioned.
at pages 21, pages 32, and pages 47 of Bruin, it said Americans have a right to possess arms that are in common use.
And did it mention Colby?
It didn't mention Colby, but
Okay,
that
so it didn't.
undermined,
All right.
the
Did
reasoning
it mention
of Colby.
M16s and the like,
It
which
did-
are, those are quotation marks around from Heller. Did it mention those?
It didn't mention M16s and the like, but what it clarified was the test, just as with respect to intermediate scrutiny. It said that every court that had applied intermediate scrutiny had gotten it wrong. We're not changing Heller. We're applying the standard we applied in Heller. And just as it clarified the standard of review, it also clarified the
But in
test.
Colby,
for
that was
protected
the
arms.
alternative holding. I mean, I agree with you that the test in the alternative holding was changed in Bruin, but that was not our primary holding.
Well, no, the test was not changed in Bruin. Bruin said that Heller demanded a test rooted in history and tradition. So nothing from Heller changed with respect to the standard of review. So unless you were prepared to say.
And that's the alternative holding in Colby. That's what I'm getting at. The primary
Correct.
holding was not
And I'm saying the
impacted.
primary holding was undermined just as much as the alternative holding. Because
And
the
how-
court,
Go ahead.
because the court made clear in Bruin that the Second Amendment protects the right to possess arms that are in common use. And in Colby footnote 10 explicitly refused to engage in a common use analysis, the very analysis that Bruin said establishes constitutional protection.
Now, you're seeking to enjoin this enforcement of this statute in its entirety, aren't you?
With respect to semi-automatic rifles, yes.
Well, okay, but the statute has a great many weapons that are listed there, quite a large number.
Yes.
And I was struck by the fact that what you're seeking here is a rather sweeping injunctive relief against the statute in its entirety. And the implication would be that none of those weapons that are listed in the assault weapons ban can be regulated by the state. Every one of them is beyond the scope of any kind of public regulation. And so it's quite dramatic, really, when you're saying here, 25, 30 weapons, some of which appear to be quite dangerous, others may be less so, but you're saying they're all off the table. The state can't do anything about any one of them. And it seems to me that this resembles a facial attack, and that you're not willing to wait for an as-applied challenge to a particular weapon or whatever. You're just going to go over the whole, going to go for the whole thing. And what I'm asking is, why shouldn't facial attacks under the Second Amendment be disfavored, just as facial attacks under the First Amendment are disfavored? We don't like facial attacks that seek to void statutes in their entirety. And yet it seems to me that's what you're lodging here. Something that's quite sweeping and quite dramatic and sweeps a whole lot of different weapons off the table and say that they're beyond the state's power to regulate. Why should we go at it in this dramatic fashion at the outset?
First of all, we're not saying it's beyond the state's power to regulate. We're saying it's beyond the state's power to ban. And second of all, it would be no different than, these are all firearms of the same basic type, semi-automatic rifles. It would be no different than in Heller if instead of DC saying no handguns, had listed out every model of handgun and said, you know, you can't possess any handguns, and here's how we define handguns. Here's every model of handgun that is available. And so in a facial attack is maybe disfavored, but the point is you apply the constitutional test. And here Bruin has set forward the constitutional test. And when you apply that test to semi-automatic rifles, it cannot be sustained. But if in the alternative, if we focus primarily on AR-15 type of rifles and AK-47 type of rifles, if the court wanted to limit relief to those two, we wouldn't complain
Constitutional
about
text
that.
Test, though, may, even though the end means end scrutiny under that we formerly used is no longer, and there's a
Right.
much more of an emphasis upon historical precedent. But if that's the case, then why aren't you drawn back into the challenge that my friend Judge King relayed earlier, and that is historically, the state has been able to regulate in some way firearms with a high lethal potential.
Well, Your Honor, what
That's the history of it.
Heller said the history was dangerous and unusual. And if you actually look at the historical regulation of firearms, to the extent any have been banned, the issue has been that there's a
Heller
risk.
talked about M16s and the like, weapons of war
Well, what Heller
are
said,
not
sorry, Your Honor.
covered.
Well, what Heller said was
Weapons of
those
war.
I'm sorry to keep interrupting. I apologize. But what Heller said was those weapons could be banned not because they're useful in military service, but despite their utility in military service. The dispute in Heller was between, are the covered firearms, is it limited to weapons that are useful in warfare, which was one position. The other position was, is it firearms that are in common use regardless of if they're useful in warfare, which is the other position. Nobody argued
These
that
are
firearms.
dramatically different weapons that are before us in this case than the handgun statutes and handgun regulations that were at issue in Bruin and Heller. This is a whole jump up. It's a different order of magnitude, is it not?
It is not, Your Honor. These are relatively underpowered rifles, but what's interesting,
Underpowered,
yes,
an AR-15 can fire 300 rounds a minute.
well, the
a
Army says
semi-automatic.
45 to 60 rounds a minute in effective
Underpowered.
mode. But in terms of underpowered, in terms of the
AR-15.
power of the,
I mean, there are handguns, and, they're used in the military too. The
correct, Your
pilots
Honor.
of our fighter planes have a handgun with them.
But it,
Uh,
yes,
But we're talking about M16s and the like, and the AR-15 is the M16.
it is not what the.
It is the M16.
It is not in the
semi-automatic.
constitutionally dispositive sense. What the Supreme Court said in Heller is that
They named
M16,
the M16.
And they said that-
Justice Scalia
Yes.
said the M16 or the like, and the like.
and the like
And the
was
like. And
firearms
this
that
is
are
the like.
highly unusual in society at large. And these firearms are the opposite of highly unusual in society at large. And the reason is what in Staples, the Supreme Court 30 years ago said that the line between what has traditionally been a lawful possession and what is not is semi-automatic versus automatic fire. And the reason.
Mr. Patterson,
Yes.
I'm sorry, I'm over here, right in the middle.
Okay.
So you just got to a point that I wanted to
Yes.
ask you about. So under your theory, if Congress had never gotten around to banning fully automatic rifles or machine guns, and they had become popular in common use to the extent that apparently AR-15s are, the state couldn't regulate that kind of a weapon.
Well, again, we're not talking about regulation. There could possibly
Or
be
ban it.
some types of regulation,
Or
but they
ban it.
cannot ban firearms that are in common use.
So
Correct.
a state
If-
could not ban a machine gun assuming that there'd been no federal
If they
ban.
had been in common use, but they had not, I mean, we had
What about a
Te-
bazooka to use for recreational purposes?
any firearm that is in common use for lawful
A tactical
purposes.
nuclear weapon. used
Well,
for-
a tactical nuclear weapon is, I mean, it's a,
So there's no limit. Essentially, once the cat is out of the bag, the Second Amendment trumps all. That's your position.
that's not my position. That is Heller's position and Bruin's position, which says that arms that are in common use are protected, period. And you can see
Let
that.
me make sure I understand what you
Yeah.
answered Judge's question. Is it your position that the ban on machine guns is now unconstitutional under your populist theory?
No,
Why is it not?
because machine guns are not in common use. Under the Hollis versus Lynch in the Fifth Circuit, it has the number that are
Can
potentially.
the action cause the action? If they're not in common use, does that not flow from the fact that they are banned?
Well, that's one element. There was a charge.
And if it's merely the popularity of it, just having a lot of them would make it constitutional under your theory. Is that correct?
It's not merely the popularity. Popularity is sufficient, but not necessary for constitutional protection. That's because it's a state burden. They have to show they're both dangerous and unusual.
Can I ask you a
Yes.
question? I'm just trying to imagine that I'm like legislative counsel to a
Yes.
state. Like, what day does, so say they pass a ban on machine guns. right
Yes.
now, okay. And then Congress lifts its ban, and so now
Yeah.
machine guns are in more popular currency. Is there like a day I could give my client as to when a formerly constitutional law becomes unconstitutional?
You have to look at the use of that firearm to
I
see
feel like my
what they
client's gonna
become.
say, I need more than that. Like, I have an obligation as a state legislature not to have unconstitutional
I
laws
think
on the books.
anytime
Tell
you-
me what day I have to repeal this law.
I can't tell you the specific date, but
Well, it's more- it
anytime
must be
there's more than.
700,000, right? Because that's about. how
No,
many
there are
machine guns
176,000 civilian machine guns. That's Hollis versus Lynch. That's after 1986. They have been banned for civilian possession, and that's how many
circulating. So I
are
can
in
tell my
civilian
client
hands.
176,000 were good. I don't know about 177.
Well, I would say anytime you get above a million, that starts to be in common use. And for
million?
example, Heller 2, the DC Circuit, at
What
that time,
percent, if there's a million, what percentage of Americans is that?
that's not a large percent of
I would
Americans,
say
but
not.
it is something that is in common use. It's still in common use with the DC Circuit
So
and
under
Heller.
1% can be common use.
Well, it's actually the state's burden to show that they're dangerous and unusual. And what Heller said is highly unusual in society at large.
Can I give you a
And-
hypo why I think that can't possibly be right, that it has to be both dangerous and unusual?
Sure.
Okay, so imagine that someone invents a new type of technology
Yeah.
that makes handguns dramatically more useful in some way, right? Some
Mhm.
like massive improvement in the characteristics of handguns.
Mhm.
And so this becomes extremely popular extremely quickly. Every single manufacturer starts manufacturing handguns with this feature. Millions of these handguns are
Yeah.
sold. And then it turns out 3 years later, handguns manufactured with this feature have an unfortunate tendency after a few years, the part degrades. It blows up in the face of the person who fires the weapon after a couple of years. Are you seriously telling me that the states could not, in response to that new information, ban that type of handgun? It's perfectly safe it's perfectly safe to the user when you sell it, but after a couple of years, the part degrades. And it's now going to blow up in like a non-trivial number of situations in the face of the user. Could the state ban that type of handgun?
Well,
Despite the fact there are now millions
potentially
of them on the
because the
market.
analysis is today, and presumably people that have these, once they learn they're going to blow up in their face, are not going to be using.
Could the
those
state say, I'm not
firearms.
going to rely on a product recall. I'm going to ban them. I'm going to order a mandatory recall and I'm going to make possession of them illegal.
Well, the test that Heller says is everything that is in common use is protected. So if people persisted in using those for lawful purposes, despite them
It
blowing
doesn't
up
say
in
that
their
the
faces,
M16s and the like are protected. It says they aren't.
it says they aren't because they're highly unusual in
You haven't
society
read
at
the rest
large.
of it. You need to read the rest of it.
No, because they're highly unusual in society at large. That is why they're unprotected. Again, the dispute, the Second Amendment was put in the Constitution, as Heller said, to preserve the militia, which was valued for things like putting down insurrections and repelling invasions. So the notion that a firearm could not be protected because of its military utility, Heller said we look at the prefatory clause to do kind of a sanity check on how we're interpreting the operative clause. And the notion that a firearm could be banned because of its military utility would make no sense in terms of the reason why the Second Amendment was put into the Constitution. So
I think
Heller,
there are firearms that are more more useful, most useful with the military. Most useful with the military. Machine guns, nuclear weapons, M16s, and the like of M16.
Yes. And so what Heller was making a defensive
What's the
point.
M16? It's the infantryman.
Correct. And Heller was making a defensive point
Weapon.
because the charge was if you can't have M16s.
Have you
then
ever
we divorce-
fired an M16?
Excuse me, Your Honor?
Have you ever fired an M16?
I have not, Your Honor.
Well, I have, and
Yes.
we used them when I was in the Army Reserve, and that was way back, way back.
Yes.
And we took shots at the targets for whatever we hit. There was nothing left. The kick was so powerful that when the bullet struck the human being, it splintered them into all sorts of different pieces. There was very little left of the human being, and that was a much earlier model of the M16. Since then, it's been perfected and perfected and perfected to an even more lethal weapon than the one that I use. And if we are establishing a precedent that says no matter how dramatic the advance in technology, no matter how lethal the weapon, it's all beyond the state's capacity to regulate in some way. I mean, as the chief's question posed, where is the limiting principle to all of this? Where does it stop? If this considerable list of weapons, and I don't purport to be familiar with all of them, but I assume the Maryland legislature was. And if it's what can be regulated?
Your Honor, these are not unusually dangerous firearms. If we look at the re-ballistics report that the state cited, these rifles have less than half of the power of M1 Garands, which are expressly accepted
So
from
you
Maryland
would-
statute
so
that
you
are
would
entirely legal.
disagree that these weapons were designed for military use?
I disagree that these weapons are uniquely destructive or lethal. They're relatively,
Were they designed for military use?
the AR-15, absolutely not. No
So the
semi-automatic.
AR-15 was not designed for military use.
The AR-15, as it's sold in its civilian form, was not. The
What
fire-
was it originally designed for?
The firearm that was designed for the military is a select fire firearm that can fire in automatic and burst fire modes. The AR-15 cannot do that. It was designed for the civilians. It's the civilian version, what the Supreme Court said in Staples.
It's the
It's a
civilian version
civilian
of the
firearm.
M16, which is the standard infantryman weapon that Judge Wilkinson
Yes.
used when he was in the Army.
Counsel.
Yes.
The AR-15 is the civilian version.
I don't,
If you're welcome
is
to
that?
follow Judge King, I'd like to follow up after that.
Yes, one response. The reason why machine guns didn't gain popularity and can be banned is because they fire indiscriminately. You can't fire accurately after the first round. And that's the same thing with respect to trap guns, is that they fire indiscriminately. They might kill a robber, they
And
might
the
kill their
AR-15
daughter.
is more accurate than the M16.
Exactly, and
Right,
there's
because
no-
it's semi-automatic. You can aim it better. And the infantrymen fired mostly that way because they select their target.
Correct. And there is no history in this
Yeah.
country of banning firearms because they're
They know what
accurate.
they're doing. They're trained.
Counsel, at the beginning of your argument, you talked about the plain text as Bruin uses that term. Is it your view that plain text is different than ordinary and normal meaning of a term?
Yeah, I think ordinary normal meaning incorporates the limitations and historical limitations. Plain text, what Bruin said, is just naked text, like you're looking at the dictionary. What does this word mean?
So.
It's the ordinary, yes, the ordinary normal meaning of that word, just the word alone. And so with respect to arms, what Heller and Bruin both said, when you put the textual elements of the Second Amendment together, it protects the right to possess and carry weapons in
Right.
case of confrontation. And so there's nothing in the plain text that would allow you to distinguish between one type of weapon versus another type of weapon.
So I'm trying to make sense of Bruin as a whole. And it talks about Heller first using history to determine the characteristic of the right and determine that it's an individual right.
Correct.
And then using history to determine the contours of the right.
Correct.
And then using history to determine the constitutionality of regulations.
Mhm.
And so I'm wondering if it's not fair to read the contours of the right as part of the plain text. Sounds like you're saying though plain text is not ordinary and common, ordinary and normal meaning. It's something more narrow.
Well, it is ordinary and normal meaning, but just ordinary and normal meaning of the words in terms of if you were speaking the English language at the
But
time this
lots
was
of times
adopted.
when we look for that sort of inquiry, we don't just look at dictionaries, we look at historical references and things like that. So it seems like you're, and maybe Bruin does this, I certainly, it doesn't use ordinary normal meaning, it uses plain text. And
Correct.
maybe that's what it's doing. But if so, it's drawing a distinction from how we normally look at the ordinary and normal meaning of words.
Well, I think it's the ordinary and normal meaning. So I think there's a difference between the ordinary and normal meaning of the words and the original understanding of the scope of the right. Because the scope of the right would include the historical limitations, but those historical limitations do not come from the words themselves. Those come from historical practices.
The limitations, are limitations the same thing as regulations? I mean, it seems to me that's a different subject matter. What are the scope, what are the contours of the right is maybe a limit of the right, but that's different than the regulation of the right. Or
Well,
do you
the-
think those are
I think those
one and
are
the same?
essentially one and the same. And I agree that there's a distinction, but the distinction is you look at the historic regulations to determine the limitations on the scope of the right. And you can see this is what Heller did in part 3 of its opinion. And that's when it looked at the dangerous and unusual test. And if you look at the plain text analysis of Bruin, it's a few short paragraphs.
Let me follow up on the plain text
Yes.
question that Judge Quattlebaum posed here. The Bruin Court, which is really the reason we're here, because but for that, we wouldn't be here.
Right.
It changed the analysis. Okay, it got rid of the means in text. That's gone from code. We know that. Everybody agrees with that. So then formulated 2 steps. The first step being in the plain text, and then shift the burden over to the governor to deal with the historical aspect of it. But within the Bruin Court, in determining what is plain text, it set forth 3 different inquiries that you had to make. And the first being the question of whether, as Judge Agee pointed out, whether part of the people, are you part of the people? Well, in Bruin, there was no question. He was a law-abiding citizen. They were part of the people. Then it asked whether it was in common use. Well, that was not a question in Bruin either, because they said, okay, you don't have to ask that here because this is a handgun. We know that's the quintessential weapon that is in common use. So in that case, it focused on the proposed course of conduct. But the question or at least what seems to come from Bruin is the court did that analysis first to determine at step 1, does it meet it? In your instance, you say, yes, it does. So therefore you go to the historical analysis. But if you don't find it in step 1, in other words, if it's not in common use, if it's not part of the people, or if it's not a proposed course of conduct, you don't get to the historical analysis. Is that correct?
Well, Your Honor, I'm glad you focused on that discussion on page 32 of Bruin, because many have read it the way Your Honor's reading it, but actually I think it favors.
I'm reading it just like what I was reading to you is what is in the text. I wasn't reading,
No,
I wasn't
correct.
interpreting it.
Okay, the interpretation, what the court said is no one disputes that these people are law-abiding responsible citizens. No one disputes that these arms are in common use. So that means we don't have to evaluate those matters at all, not as a matter of plain
In
text.
that case, because it was not disputed
Right,
in that case.
right,
In
but-
this case, the question of whether it's in common use is in dispute.
I'm making a
This
mess
is not a handgun. That was a handgun. This is an AR-15. The very question that's been alluded to by my
Correct.
colleagues here in the differentiation of the types of weapons. If you're talking about a handgun, Bruin didn't need that.
correct.
Everybody in this room knows a handgun is in common use. What we don't know is whether an AR-15 is. So that's the first determination that has to be made, is whether that's a weapon that's in common use. If it is, you have one way to go. If it's not, then you have a different way. But you
Well-
don't reach that question, the question of the step 2 of the historical analysis, until you do that first step as they did in Bruin.
Well, AR-15 is the most popular rifle in the history of the nation, so I'd say we do know that. But anyway, I'm making an analytical point, and I see I'm over my.
You're escaping that. You're escaping the question.
Right.
I mean, we could get into what's more popular or not. You can talk about how many rounds. There's nothing in Heller, Bruin, or McDonald that talks about number of rounds. If we get in that business, we're going to have the conversation we've been having today of whether or not you fired one in the military, how many rounds it shot, who can talk about how sophisticated a weapon is. That's not the inquiry. I mean, Bruin made it pretty simple. It set forth, as you said, 2 steps, plain text. And then to do the plain text, you got 3 inquiries there, 2 of which were not relevant in Bruin because it's a handgun. And these were all about it. In the instance here, could you characterize the individual here as a law-abiding citizen? I mean, maybe so, I don't know. Or in common use, then you have that question as to whether the machine gun is. But that's the question we have to answer first before we get into this historical analysis.
Your Honor, I see I'm over my time, but I would like to respond just as a matter of analytical in terms of Bruin. That discussion of Bruin, that was not a plain text discussion. What the Supreme Court said is we don't have to analyze arms or people at all as a matter of text or history because these people are law-abiding, responsible citizens and these arms are in common use. So then we can go to the plain text of carry. But the court didn't come back to the history.
The issue in this case, I'm here.
Sorry, yeah.
The issue in this case seems to be what Bruin holds. There's been a lot of questions about policy and logic and reasonableness and speculation about technology, but it seems to me our task is to apply Bruin. And Bruin makes pretty clear that you start with the plain text to determine the prima facie right. And this is what it says about the plain text. It says the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. That's the end of it. It actually adds something more. Thus, even though the Second Amendment's definition of arms is fixed according to the historical understanding, that general net definition covers modern instruments that facilitate arms self-defense. But the text, it reads to be all instruments that are bearable arms, ones that you can carry.
Correct.
And then it says the common use issue is part of the historical, and it makes that explicit too. It says we found it fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons, that the Second Amendment protects the possession and use of weapons that are in common use at the time. That was the second step. Now, it seems to me our task is simple in this case if we're going to read faithfully what Bruin said. And Bruin said, all bearable arms, all bearable instruments create a prima facie case. In this case, the weapons described are bearable. Nobody disputes that. It seems to me what we ought to do is basically articulate that and send it back and let Maryland come forth with the historical analysis as to whether it's in common use, whether it's dangerous, and all those other things that are being disputed as almost matters of policy here.
Well, I agree with everything Your Honor said, except that very last point, which we think it's simply an impossible task for Maryland to show that these are dangerous and unusual
I don't know. The test, ultimately, Bruin says the test is what is in common use
Correct.
today, in the present tense.
Correct.
And so that analysis has not been conducted.
Well,
By the district court. And it seems to me that if the weapons are in common use today, the question is going to be whether common use, we get to the debate that Judge Harris raised. Is it in common use? What is common use? There's this decision just came out from the Central District of California where they found that 24.6 million AR-15s are not in common use. That was the holding the district court made. It was sort of an interesting calculation, but it seems to me that's what's at issue here. And we ought to follow Bruin, whether we like it or not. I mean, there's a lot of political pressure on a court, a third branch court. And as a consequence, we sit here and debate all kinds of arms as if we're some kind of a subcommittee. And when we're in bank, we do act like a subcommittee. I understand that.
Counsel, can I ask one more analytical point? I know your position is that we could do that analysis here and there's a debate about remand or not. Regardless of whether common usage is a step one inquiry or a step two inquiry, if there's a determination that the weapons here are commonly used, when you look at Bruin's discussion of common use at step two, it seems like the determination of common usage almost is the end of the historical analysis.
Correct.
The state there put forth 3 colonial regulations, and Bruin says first, well, 3 might not be enough. Then it says those regulations actually support the use of handguns. But then it seems to say, even accepting that they might be analogs, if they're in common use today, that trumps that history. Am I reading Bruin right in that regard?
I wouldn't say it trumps the history, but the historical tradition is that dangerous and unusual firearms can be restricted. So once something's in common use, it's outside of its historical tradition, and you're correct, that's the end of the case. And in terms of how Bruin would approach this, we know what the author of Bruin would do, because in his Friedman dissent, he said when there were 5 million of these 5 million owners of these firearms, they were in common use.
That may be right. That's
yeah.
kind of us reading tea leaves
Yes.
about one judge or not. But just
Yes, analytically,
that's how Bruin seems to read
correct.
common usage as it applies even even if you look at it.
Well, because the history, what Bruin is looking for is historical principles.
Mhm.
What is the principle that allowed regulation? And what Heller held is that the principle that allows regulation of firearms is if they're dangerous and unusual. And so if they're in common use, they by definition do not fit within
That's
that
the other
history.
side of that coin.
It's the other side of that coin. What Heller said is firearms that are not typically possessed by law-abiding citizens for lawful purposes is the flip side of in common use.
Mr. Patterson, can
Yes.
I ask about you focused, I think, almost exclusively on common use in the context of confrontation and self-defense. Is it your position that if a particular weapon is not amenable to use for self-defense, but might be amenable to use for recreational or other purposes, that weapon could be regulated?
Absolutely. It's any lawful purpose. Not that it could be regulated, that it would be protected. It's whether it is possessed. What Heller said was the state needs to show it's not typically possessed by law-abiding citizens for lawful purposes. Self-defense is, of course, a paramount lawful purpose, but there are many other lawful purposes. And what the record shows here, all the user surveys that have been done show that people.
So the Seventh Circuit's decision where they focus primarily, if not exclusively, on self-defense as the purpose, the sort of paramount purpose, if not sole purpose, is just wrong.
Correct. That is incorrect because Heller said lawful purposes.
Let me ask a clarifying question, at least my understanding, just to be sure we're on the same page on the first step, the plain text that Judge Niemeyer alluded to. And I believe it started out with the question of first inquiry being from the language, it could be any weapon. Well, that cannot be true unless they abrogated the holding of Heller, because Heller did put a limitation on it. It said that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes.
Yes, those weapons are
So there
protected.
is a limitation. It's not any weapon.
Well, yes, any weapon at the plain text. Those weapons are within the plain text. They're presumptively protected.
But my point being is there is a limitation. It's not any weapon. It does not protect those weapons not typically possessed by law-abiding citizens. There are qualifiers here. Law-abiding citizens for lawful purposes. That's Heller.
That's the
Unless
historical.
you tell me that's over, that Bruin got rid of it.
I'm not telling you that Bruno got rid of it. What I'm saying is that's what Heller said is that's the historical tradition. So as a matter of plain text, yes, even those arms are
But
presumptively
it was a
protected.
limitation in Heller on the right to keep and bear arms. That's what it was.
Yes, it's the historical
And it
tradition.
regarded the sorts of weapons that could be protected.
Yes, and that's from part 3 of Heller, which says, okay, we've put together the textual elements. They protect the right to keep and carry weapons in case of confrontation. That's what the plain
I'm just
text.
seeking agreement here. We're not, it's not any weapon. There's a limitation on it. But from Heller, it cannot be any weapon when you start out with plain text. You first have to determine that law-abiding citizens for lawful purposes under Heller.
No,
That's correct, isn't it?
No, Heller said prima facie, as a matter of plain text, every weapon is protected.
Okay, let me read
Every
it again.
bearable-
Let me
every
be- I
bearable-
want to make sure I
bearable
get this point.
bearable
Heller
arm.
says this language here. The Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. You are telling me that means nothing.
I'm telling you that that's not just talking about plain text. At the plain text, that it's only presumptive protection. The Second Amendment does not protect those weapons because of history, the historical limitation on the scope of the
So
right.
that's no longer true.
Yes, it's true, as a historical limitation on the scope of the right. That's what ultimately is protected.
I'm sorry, now I'm
Yes.
confused because I thought you said to Judge Quattlebaum, not if they become commonly used.
So at the textual step of Heller, all weapons are protected presumptively. It's the prima facie presumptive bare text. And you can't distinguish one weapon from another at the plain text. As a matter of historical limitations, weapons that are dangerous and unusual can be banned. But weapons that are in common
Until they
use
become
necessarily,
Okay, but I thought Heller was clear, you can ban an M16. They didn't say until it becomes commonly used. So I thought that had to be going to kind of the initial scope of the right, because there was no suggestion in Heller. I thought that if actual machine guns become commonly used, they will suddenly get Second Amendment protection, but you disagree.
I disagree because if you
No,
read,
Bruin emphasizes 2 or 3 times, it used the word all instruments that constitute bearable arms. That's what's a prima facie. That doesn't mean it's protected as a right. It's prima facie. You get into court and the burden then shifts to say all instruments, all bearable arms constitute bearable arms. Now it's up to the burden shifts to show the limitations. The court was clear to point out that the prima facie was limited,
correct,
but it shifted the burden on the limitation to the state.
you're exactly right, Your Honor.
And to me, it's just, it's in black and white. And if we don't like Bruin, we shouldn't be on the court, but we don't have to like what the Supreme Court does, but we
Bruin
have to follow
didn't
it.
Change Heller.
Correct, but Bruin
Absolutely didn't
clarified
change
Heller. It
And-
clarified
And
it.
Justice Alito wrote a separate concurring opinion that said it doesn't change Heller a bit. And Heller resolved the issue as to M16s and the like.
You're right, and in that
And set it off
paragraph, in that paragraph, it said,
M16s and the like.
in that paragraph, it said what the distinguishing factor of those firearms were, and it's that they're highly unusual in society at large.
All right, thank you, Mr. Patterson.
Yes, thank you.
Mr. Scott?
Mr. Scott,
Thank you, Your Honor. May it please the court.
may I ask you just preliminarily, I don't understand what the district court would be expected to do necessarily on a remand. Is it, I worry that a remand would drive the district court crazy. Is the district court supposed to go weapon by weapon through the different things that are listed in the assault ban and say, well, this one is in common use and this weapon is not in common use? And so I'm afraid that a remand would tie us up for an indefinite period of time when there is I think, a sense of, if not urgency, expedition in getting this matter resolved. So am I correct in thinking that your preferred position would be to affirm?
That's correct, Your Honor. We believe that. the
That's,
district
that's,
court should
that's
be
what
affirmed.
that's what I thought. So let's follow up on that for just a second. That you would, that affirm avoids the briar patch that awaits the district court on, on remand. It would be a hard thing to extricate ourselves from. We'd have another appeal and on and on and on and on. So the Supreme Court, and I think that I find a good bit of agreement with Judge Wynn's view in terms of the common use as a preliminary question. But at the same time, the Supreme Court has given the Court of Appeals some latitude in terms of the sequencing of proof. And so you saw that in a case like Pearson v. Callahan and all the rest. So I'm not sure that the Supreme Court in Bruin straitjacketed us into marching through this step and this step and this step. I think it gives you some latitude. As Judge Diaz pointed out in the Seventh Circuit case, as I think I looked at it briefly, it's at least possible to say, oh, you can assume the arguendo that, even assuming arguendo that these weapons are in common use, they are still the subject of permissible limitation because of the historical practice of firearms regulation. Would that be fair?
Yes, Your Honor, I agree with that.
And the historical practice of firearms regulation has been whenever new technologies have arrived on the scene, the states have not been defenseless in the face of technological advances. And if you hold the states powerless as technology devises more and more lethal models to these weapons, we are putting our society at gradually increased increments of risk.
Yes, Your Honor, I agree with that.
And so I see the advantage here that it can be resolved by looking over the whole history of firearms regulation in this country, and the almost invariable lesson has been that if there are leaps in lethality of weaponry, the state is not obliged to just sit back and accept supinely what the increasing dangers brought about by firearms innovations pose. It isn't, as I'm trying to encapsulate your argument, it seems to me that was what you were going for, not necessarily to tie us up in the infinite exercise of a remand, but to affirm this and then let, if there's a particular weapon in the future that shouldn't be in that list, then you go and you raise an as-applied challenge to it. But to right at the outset, enjoin this whole statute in its entirety, which is what your worthy adversaries are seeking, is going to be an extraordinary step to enjoin this whole thing.
Yes, Your Honor, particularly in light of the fact that this court already
But I
held.
hope I'm catching the thrust of your argument.
That's correct, Your Honor, and I think it's particularly important to point that out in light of the fact that.
Well,
this
can
court
I
is-
explore that a little bit with you? Oh, I'm here.
Yes, sir.
On a remand, if I understand Bruin, we start with the plaintiff's challenge based on a prima facie right. And the prima facie right relates to all instruments involving bearable arms that can be carried. And then the state has to come and demonstrate, as applicable here, whether the arms being regulated are dangerous and in common use. One of the arms, the most prominent arm being regulated here is the AR-15. And my question to you is, has the district court made a determination as to whether AR-15s are today in common use?
No, Your Honor, the district court didn't reach that issue.
I understand that. So the question is, either we make that determination, which we're not well suited to do, or we have the district court. It has to be done under the Bruin analysis to justify the regulation. And as a consequence, it seems to me, regardless of whether it's troubling for the district court or a briar patch, or troubling for us or a briar patch, that's our task. And either we do it or the district court does it. And it seems to me what suggests the remand is that the district court is better suited in its role of taking evidence and hearing argument and exploring this and answering the critical question that it must under Bruin, whether AR-15s, for instance, are in common use.
Except, Your Honor, that this court already held in Colby, and it's the state's position that the primary holding in Colby is still valid law and was not overturned by Bruin. And under that,
we're here today to determine that. We're not bound by our former decisions. We're not bound by our former panel decisions. We are confronted with applying Bruin to this case. And even though Bruin said it didn't change Heller, Heller is certainly the foundational opinion. But if Bruin says something more clearly about Heller, we have to apply Bruin. That's our task. And you agree that after you get by the prima facie plain text consideration, then the burden shifts to the state to show that in the present tense, that's what Bruin says, whether it's dangerous or in common use. And it seems to me that may be debatable. I don't know. But I do know that everybody seems to agree that there are 24.6 million AR-15s in circulation now. And the question would be whether that is common use. And as you know, the Central District of California said, no, that's not common use. And they did a bunch of calculations and came to that conclusion. Whether they're right or wrong may be something that the Supreme Court's going to have to answer. But at this point, no one's made that determination. And it seems to me that the prudent thing for an appellate court is to send it back to the district court. Now, what's wrong with that?
well, because I think this court's already, now, I'm not suggesting by any means that this court couldn't change its mind and
have we determined that the AR-15 is not in common use or is in common use?
I think Colby held that the AR-15 and the other weapons banned by this law are in fact the equivalent of the M16.
I understand that holding, but that is not what I'm asking you. I'm asking you, did we or any other court with respect to this statute determine whether AR-15s are in common use?
That analysis does not appear as with respect to how it's articulated.
And that's what Bruin demands, right?
No, I don't believe so. Not unless you get to the second step of the
Well, the
analysis.
first step is very broad. I've read you the first step and they made it clear and they repeated it. The Second Amendment extends prima facie, that means just the starting point, to all instruments that constitute bearable arms. Now, it seems to me it's not hard to conclude that an AR-15 is a bearable instrument.
Right, but then but if you look at Heller, Your Honor, Heller
No, this is
specifically
Bruin.
says, I understand.
And Bruin is stating the principle, it's clarifying. It didn't follow Heller 100%, you know.
well,
That's the conundrum.
they
What Judge
said-
Niemeyer is pointing out is where the difference lies. If you read Bruin, a case that's dealing with handguns in New York City, and then you think that it took care of everything in Miller that dealt with sawed-off shotguns and Heller, then yeah, you'll get there. You will skip right over that first step and go into historical aspect of it. But Miller made it clear. Miller tried to say, it said to some extent the militia, and then it went into the historical aspect of it. But ultimately Heller clarified Miller and it said, well, we're not talking about a militia here, because if we do, machine guns are going to be in, that regulation is out the window. But it did went on to say that the type of weapon at issue is what is at the point of the Second Amendment protection. And so for that proposition, we look to the Second Amendment to the 10, because it does not extend to all weapons, it extends to only certain types of weapons. Now, if you pull from Bruin, from a handgun case, that now every weapon, including machine guns and shotguns, are now off the record, even though we've already said those off, you're going to get there. You're going to get exactly where Judge Niemeyer is. You're going to slide, and that's going to make it harder and harder, as Judge Wilkinson has alluded to. It's going to make it harder and harder for the states, for governments, for the people to enact rights to protect themselves, because you got to skip over that first. You got to accept a grenade and all kinds, and I won't use that. That's too much of a mass weapon, but machine guns and everything. And then you get into this esoteric analysis on the historical aspect, but it's in step one. And if you get it in step one, which I believe is done here, then you're there. And that's the reason that Covey is still good law. It may not be binding, because an en banc court can always rule against an en banc court, but this court made the pronunciation, and the only part of it that's abrogated by Bruin is the means in test, not the rest of it. It looks all good to me, what we said in Covey, and it seems like that question is answered here today. We can keep sending it down, as Judge Wilkinson say, and do what Judge Niemeyer wants, is go through every one of these and keep going back and forth on it. But the plain text of it covers this answer at step one. We don't need to go to step two.
Yes, Your Honor, I agree. And the Colby decision is based on a very robust factual record. There was an extensive record in that case, which the court analyzed in its opinion.
Bruin was a handgun case.
Right.
In New York City, telling people you can't have a gun, you got to show you have some good purpose of doing it. And the court says, no, that's not it. Miller is a shotgun case. We've got machine gun cases. I mean, all kinds of cases are coming up. But Bruin, to pull from that language that it then wipes clean all of the cases that dealt with certain types of weapons, I don't think that's the case at all.
Well, in fact, Justice
Can I
Alito in
ask
his.
you a-
Yes,
way
Your
over
Honor.
here?
Yes,
Can
Your Honor.
I ask you just a procedural question about this common use for a lawful purpose? If that is a preliminary question, and then you move to the historical analysis, what's your position? What happens? What is the court looking for at the second step, the historical analysis? If the court decides, yes, this is in common use for lawful purpose, therefore we move on to step two, what do you think happens at step two?
Well, I think Bruin requires that there be some sort of a historical analog.
But what
to
is the
law.
court, what is the government trying to prove at step two then? Judge Quattlebaum pointed out that in Heller, it seems that common use for lawful purpose ended the inquiry. When the court concluded handguns are in common use for the lawful purpose of protecting your home, that's all we need to know. Therefore, the state cannot ban them. But you're saying there's another, the state can still rescue its regulation by proving what?
By proving that the law is consistent with the historical tradition of firearm regulation in the United
And
States.
what would that be? Would that be a historical tradition of banning weapons that are in common use for a lawful purpose? Or what would it?
Well, in
what
this
exactly
case,
are
I
we
think it
looking
would
for?
be, it's regulating and or banning dangerous weapons that are extraordinarily
But aren't
dangerous.
those the same thing?
Yeah, that can't be. Those are doesn't Heller tell us that guns that are, or weapons that are in common use for lawful purposes, by definition, are not unusual and dangerous weapons?
Well,
So it seems, and if it comes from that tradition, that's what Heller says. And it seems to me, whether or not, to follow up on Judge Rushing's point, whether or not it's at point 1 or point 2, if there's a finding that the weapons are in common use for lawful purposes, and I know that may be disputed, but assuming it is, you would have to have a historical analog for something other than the regulation of dangerous or unusual weapons. Do you have one besides that?
But Your Honor, I think.
Could you
whether-
answer, I mean, I know you, could you just answer me if you have a analog other than regulation of unusual and dangerous weapons? My analysis may be wrong, but assume I'm right. Is there another, why? Is there another analog that you would point to?
The analogs that we pointed to in our briefing include laws that ban, for example, trap guns, which were considered to be dangerous and unusually dangerous. And so that's the historical analog. Whether you do, whether to suggest, the plaintiff's position is if the gun is popular, it cannot be banned. It can't be banned at all, regardless of how dangerous it is. And that's not consistent with Heller. Heller explicitly says M16 and military type weapons are either they're not, and it really doesn't matter, either they're not covered by the textual definition or, and therefore excluded from Second Amendment protection, which is our position, or they are consistent with a historical tradition of regulating and or banning dangerous weapons.
I got it that you think Colby remains, tenable law, and that's something we have to decide. But I think I heard you say that at the end of the day, all your historical analogs are the regulation of dangerous and unusual weapons. So, is that correct?
Dangerous or unusual.
Okay, well, I'm not, that's the issue too, but
Yeah.
whatever, however we resolve that, and if you assume that common use for lawful purposes is a determination, ipso facto, that it's not dangerous or unusual, then there's no other analog you can point to.
Well,
There's no other why. There's no other historical analog on the why axis that you can point to.
well, I think what the courts have done when you look at the analogs is that you look at both the how and the why.
I'm asking for why. Is there another why besides regulation of dangerous and unusual weapons?
Is there another why?
Another analog that goes to a different why.
An analog that bans a weapon not because it's dangerous, but for some other reason.
Correct.
Your Honor, I can't point to one.
Okay.
But I don't think, obviously, we don't agree that that's the dispositive
Yeah,
question here. The courts have made pretty clear that if, for example, machine gun, what's the historical analog for banning machine guns or bazookas or shoulder-fired nuclear missiles? Are we going to say, well, if you can't point to a historical analog that type of weapon,
I think there's
another reason other than the fact that it's extraordinarily dangerous, then you can't regulate it. That doesn't make any sense.
I think that question presumes that there's been a determination that those weapons are commonly used for lawful purposes.
Well, again, I think Bruin made clear that the test is in common use for self-defense. And I think that's the test that controls here, not
Mr.
whether it's in
Scott.
common use for law.
One thing
Over
that
here.
concerns
Yes,
me
sir.
here is that, in my friend Judge Niemeyer in wanting to remand this case is drawing the judiciary further and further into the position of that we become the draftsman of a substantive code of firearm regulation. And I'm just not sure that judiciary by and large is a bit process focused. And I'm just not sure that going weapon by weapon and saying, yes, this is regulatable, this is not, whether we have completely taken over a legislative function and are being asked essentially to draft a code of firearms regulation. And the other thing, it seems to me what you're asking as opposed to what your opponents are asking is you're not asking for, you're just asking for one state to be allowed to go its own way in ensuring the safety of its citizens. You're not asking for Montana to impose an assault weapons ban. You're not asking for Maryland values to be transported to Montana, but by the same token, Montana values and Montana's challenges shouldn't be imposed and imported into the state of Maryland. I mean, the way our federal system is supposed to work is that each state should be within reason able to determine what's best for its own citizens. That's at the heart of the state's police power. Since time immemorial, we talk about the state's ability to ensure the safety and welfare and well-being of its own citizens. And to then say that a state is handcuffed and powerless to respond to these technological innovations that's an extraordinary step. And that is what they're asking. And as I understand it, and the amicus briefs lay this clear, and your brief lays this clear, the historical record here, whether you go back to brass knuckles or whether you go back to Bowie knives or whatever, whenever there's a new danger presented, states have been given some latitude in responding to that. And to sort of go to this counter-historical theory is really quite dramatic. You see what I'm saying?
Yes, Your Honor, I do. Again, when Bruin talks about, when you do look at the historical tradition, Bruin makes clear you have to consider technological changes and dramatic societal concerns. And that's
But not
exactly
really,
what
not
this
really.
is.
My good friend, Judge Wilkinson talks about power of states. This whole thing really started in terms of Heller, really, in terms of dealing with cities that knew what violence was with handguns and the death and try to regulate it. So it doesn't even start from a premise of trying to states having power to cities to protect themselves from known violence. It's just saying how broad the Second Amendment is. And it's broad because, there's no right to an education in Rodriguez San Antonio School District, but there's a right to bear arms. We have to, whether you like that or not, that's what we're dealing with. So that's not the question. Every firearm is dangerous. That's not even a problem.
Your Honor, but some are more dangerous than others.
Well,
And this court has already found that
and
these
the problem
weapons.
is when the court names an M16 and carves it out, that's fine, but the test they give us doesn't give us good reason to take that weapon, a weapon like AR-15 out as well. I mean, for example, the purpose is to have, for you to defend yourself, right? Isn't that the
Self-defense, that's the core right. That's the
So
core right.
self-defense is not based on the type of weapon, is it? It's based on my defense to me.
But Your Honor, these weapons are not particularly well suited for self-defense.
They're not. If 5 or 6 people broke into your home, you tell me our AR-15 wouldn't help you out.
The question is, are they well suited to self-defense? A
Would it
handgun
not be
can-
well suited?
You can't, it's one thing to carry a handgun around as self-defense if you feel like you're a paramedic and you're going into a dangerous neighborhood.
No, I'm
and you
talking
wanna
about
carry-
my home now. That's the most precious place. You mean to tell me if 5 people were breaking into my home, our AR-15 would not be very helpful for self-defense?
Well, an AR-15, if it's properly stored, is going to be in a safe.
If it's properly stored, well, a handgun, if it's
And
properly
a
stored.
handgun, I think, would be much quicker. You'd be able to store it in a place where you could get to it much quicker if you had people.
Those arguments have nothing to do with the Second Amendment.
Well-
We're talking about a constitutional right that's defined by the right to keep and bear bearable arms. And the court said that in the abstract, that is without limit. And the limits are imposed, are recognized as part of the right, but the burden of showing the limits is on the state. And despite what you said, the court has said again and again, it has to be dangerous and unusual. And they quote that again and again. And that's your burden to show that it's both dangerous and unusual through some historical analog. And so your argument that you don't have to reach that because Colby held that it's not an instrument of self-defense doesn't follow the Bruin text. And I don't know why we want to diverge or second guess the court so blatantly. It seems to me that the standard is our exploration here ought to be what Bruin said and held. And it was just as clear as a bell in my judgment that it had a two-part test defining the right with limitations. But the two-part test started with an unlimited presumption, whether it was a bearable arm, and then said the state can regulate that if it's dangerous and unusual. Now, there may be other analogs, but I think Judge Quattlebaum asked you, and you probably fairly recognize that that's the only analog that would be applicable for the regulation that's before us.
Yeah, Your Honor, the suitability of these weapons for self-defense is relevant here because weapons which are not in common use for self-defense are not protected by the
You're
Second
just
Amendment.
missing the whole point. The whole point was any instrument that's a bearable arm is presumptively protected, presumptively. And then it comes on your burden to show that it's not suited or whatever you want to argue. But my point is we're just ignoring the Second Amendment. And the court went 3 or 4 times, explained the text, and at one point even said it's unlimited, the text. And you keep wanting to put in limitations. And the text simply says the right to keep and bear arms shall not be infringed.
Well, the Supreme Court has made clear that weapons that are not in common use for self-defense are not covered.
They did not say that. They said that as part of the historical analysis. That's the limitation. But they did not say that in the first step. They said just the opposite. They said just the opposite. They talked about it. They said the first step does not have limitations built in, but the state has the burden of showing them, and it recognizes that they're valid. So if the state comes in and says it's dangerous, it's ill-suited, it's not in common use, it's you don't have to store a handgun, you store a AR-15. If that's legitimate, you can make all those arguments. But it seems to me you start off with a proposition that with the plain text. And what you're trying to do is to load up the plain text with in common use, and it doesn't say that. But even if it's in common use, they've pointed out it's over 20 million AR-15s. And now it seems to me you might have to argue that that's not plain use. And maybe you can make that argument. My whole point, though, is that if we're going to follow the instructions given to us by Bruin, it seems to me that what we would prudently do is say the plain text entitles the plaintiffs to get into court, and then you have to demonstrate one of the limitations which you have a right to do and which exist. The court recognizes they exist, but it burdens on you. And you conceded that you have not yet addressed, the court didn't address, whether AR-15s are dangerous and in common use.
Yeah,
That's the key
that issue
distinction.
was
That's the
not.
key distinction of where we are, what Judge Niemeyer has alluded to. In my view, he is simply saying, step 1 is superfluous. Anything you bring in is okay. Then you go to step 2. That's not my view. That's not the view I think Bruin brings. So even though we can state it as he does, as though Bruin absolutely says this, that is the differentiation of the point of view that we're at now. Do we go to step 1? Does it mean anything more than just show us what you got and all of a sudden we go to step 2? Or do we do like Bruin and look at the 3 different means by which one can say that's not one of the weapons that fits on the plain view because it's not in common use? You don't have the people aspect of it. The citizen is not satisfied for the course of conduct aspect of it. But if you take Judge Niemeyer's point of view, that's a question that you can answer, but you should answer it with the condition that's his interpretation of Bruin, and which is a good interpretation, but there's a different interpretation of Bruin. And that's the decision we have to make today.
Yes, Your Honor. I see my time is up unless.
Well, I have a question.
Yes, Your
If
Honor.
you don't mind. So I think the questions today illustrate that you could take parts of Bruin and parts of Heller and write an opinion either way, and I suspect there will be. But to go back to the plain text standard that Bruin articulated, here, I take it there's no question. The state does not contend that the plaintiffs here are not part of the people.
Not based on the allegations in the complaint, which is all we have to go on at this point.
So both Heller and Bruin spend a lot of time talking about law-abiding, responsible citizens. So where does that come into play in this step one, step two dialogue?
It's the state's position, Your Honor, that that the text as to whether the plaintiffs are included in the people and whether the conduct and or the weapon at issue are within the definition of arms takes place at the first step of the analysis. And that's how Bruin did it. If you read the opinion, those are the first two issues.
So where
that's
does the
discussed.
court address, it may not be applicable in your case, but that doesn't really answer, where does a court address this constant refrain of law-abiding, responsible citizens?
At the first step.
So in your view, that's part of the plain text analysis?
It's part of the analysis as to whether or not the plaintiffs are within the definition of people in the Second Amendment.
Thank you, Mr. Scott.
Thank you.
But to be clear for you.
Never mind.
The business of law-abiding citizens in Bruin was a non-issue. These were law-abiding, upright citizens in New York. They simply wanted a handgun. We're not talking about that is an issue. So I don't know how it was discussed so much. They sort of glossed over. And then they glossed over the common use because handgun is in common use. So when you get beyond that, and all of that was within the step one, then they turned to the historical aspect, but they didn't get to it because they got it. They went to the second part to get to it because they made that determination for the step one, then went to the second step.
Thank you.
Thank you very much, Mr. Scott. Mr. Patterson?
Thank you, Your Honor. Just a few points. I'd like to start out on this plain text point. I think a First Amendment analogy could be helpful. If I'm talking about obscenity or fighting words or defamation or something of that nature, that's all speech. That's within the plain text of the First Amendment. But it's within a historical exception that those items aren't protected. It's the same thing here. Heller says all firearms, all bearable arms are arms. So all those things come within the plain text.
But you do agree that Judge Pagey alluded to the words right of the people, plain text. You have to determine what it mean by the people. That's certainly not something you just gloss over.
You don't gloss over it, but what Heller said is similarly, like the First Amendment, all speech is speech. All Americans are people. That's all the plain text analysis
No, I don't
does.
think that's right. If you go back to Heller, the people was defined by its context in the Constitution, and the Constitution used people, 8 or 9 times.
Correct.
And the Supreme Court concluded that that referred to citizens in the United States, adult citizens who had rights. We, the people, even went to the preamble. So people was a constitutionally understood term. It was not something that they were just making up out of the dictionary.
Well, that's why I said all.
Who are part of the political community.
That's why I said all Americans. They use political community, national community, and Americans as citizens.
My only point is that it was not a dictionary definition of people, which constitutes all the people. It was a constitutionally understood term that was included in the Second Amendment.
And it's consistent with the dictionaries because if you look at Webster and Johnson.
No, it's not, because women didn't have the right to vote and slaves didn't have the right to vote. I mean, it didn't include all the people.
Well,
It included the adult citizens at that point.
I actually disagree, Your Honor. I think the people said we're all people, all members of the national community.
We, the people, come together. Did that mean women came together and conveyed rights from the states to the federal government?
Women were part of the people at the founding. I agree with you that many did not consider slaves
debate
part of the
that
people
in
at the
terms of-
founding.
Talking about a useless argument. We're going to go back to that in terms of what it meant as people.
Right. So the question today would be, who are the people today? That would be the question of what we would
Well,
look
the
at.
people
for
is what
plain
is
text.
people meant in the Second Amendment.
Right.
What did the Congress mean? What did the Constitution mean when it used the right of the people to bear arms?
Yes. And what,
It seems to me, my only suggestion to you was that that was addressed at length in Heller, and it was not addressed as a definition of all the people, human beings. It was addressed as what people meant in the Constitution.
not all human beings, as Webster and Johnson said, it means the polity, the people who make up a nation. That's who the
Reading
people,
your,
that's who the people are.
briefs and everything, is you almost assume a categorical status for Heller and Bruin. And as I read those two opinions, there's an element of caution that runs through them, whether it be in a footnote or wherever. But the court, in both cases, is careful to underscore the limitations and what the decisions don't apply to. Judge King earlier mentioned the exception explicit of M16, but those cautionary notes had to be very carefully negotiated within the court. And they set forth important limitations. And so I think what we're trying to do is to take that language from the Supreme Court and the language of limitation, which is there in both opinions, and see if it applies here. And the case for having it apply is twofold, it seems to me. Number one, we're talking about weapons that represent a gigantic leap over what was done before in Heller and Bruin. That's one point. And then another point is that the historical flow is really, and Bruin's emphasis on the history is really quite dramatic here, because you can go back centuries and find that as new dangers and new firearms presented themselves, states responded by different forms of regulation. And to begin at this late date to restrict the ability of states to respond at a time when technology is advancing at a more rapid pace, not a less rapid pace, than at the time of the founding, it seems would turn the historical values on its head. And it's important to look not only at what Heller and Bruin said, but in what they refrained from saying. And they refrained from enunciating any principle that would handcuff the states as new advances in weapon lethality appeared on the horizon. And that is the unprecedented step that I feel like we're on the verge of taking. I think that the Second Amendment challenges in many instances have overread what Bruin and Heller actually said and the limitations explicit that those two opinions impose.
I see that my time is up. May I respond?
Absolutely.
Okay. So, Your Honor, a few points there. Heller and Bruin did leave a lot open, but one thing they did not leave open is that arms in common use are absolutely protected, and that it is a feature of the Second Amendment that it keeps protection, keeps up with technological developments. And it would not make sense. Again, the purpose, the right was put in the Constitution was to protect the militia. And again, what Heller said basically is you can look at that purpose as a sanity check, and it would not make any sense to the founders of this nation to say, okay, as firearms technology develops, we're going to deprive our militia of that. That would not make any sense. And there is zero history in this country, they have not pointed to it, of banning new firearms technology. There is zero outside of machine guns. And the issue with machine guns, again, is indiscriminate fire, collateral damage. You can't aim it. And these are the opposite. These are accuracy enhancing feature. And there's no history of banning firearms because they're accurate.
If you feel that a firearm is wrongly included in this piece of Maryland legislation. Why don't you can bring an as-applied challenge to that. But as I have indicated earlier, what troubles me is that this is a facial challenge, this is a sweeping challenge, this is to wipe the efforts of the Maryland legislature in toto off the table. And it seems to me that this is an analog to the facial challenges that are lodged under the First Amendment, and that those facial challenges are met with disfavor. And yet we're seeing it again. What you are asking in your request for equitable and injunctive relief is something quite dramatic, which is to take a whole category of weapons and place them beyond the reach of any kind of state legislation, no matter how reasonable or well-founded.
Your Honor, we've limited our challenge to semi-automatic rifles that are there's a list of them, yes, but they're all the same type of firearms. And if those firearms are protected, they can't be banned. We're not saying they can't be regulated, but they cannot be banned.
You don't know that. There may be significant differences between them. Who knows?
And it would be the state's burden to show that any particular one was dangerous and unusual. But these are all of the same. Again, it would be the same as if in Heller, DC had listed every make and model of handguns. I submit that would not have made a difference to the outcome of that case.
Mr. Patterson, how do, if we were to agree with you, and I think earlier remand it back, how do the district courts determine what's common use?
Few points, Your Honor. First, if there were to be a remand in this case, I would urge the court to direct the district court first to focus on common use, because what we've seen in a lot of cases is that states come forward with basically the same evidence they came forward with before Bruin and about, the dangers and misuse, and they bring forward 10 expert reports, and none of that is relevant.
I'm just curious as to how that would look. How would a district court determine what's common use?
Well, we would look at the evidence available, and we've basically put forward 3 buckets of evidence to this court. One is user surveys from the Washington Post, Professor William English, and the NSSF. The Washington Post, for example, showed that 16 million Americans own these. 91% said self-defense was a reason that they own them, just for an example. So that's one bucket. We also have production data. The latest production data shows that there are over 28 million of these firearms in the nation. And then we also have firearms retailers data. And that data shows that for the past decade, these have been approximately 20% of all firearm sales in this nation, behind only semi-automatic pistols, handguns.
So 20%, you think 20% is common?
Well, it's the second most common in the nation. So unless only semi-automatic handguns are protected, yes, that would be common.
So whatever is, I think you used the word popular earlier.
Yes, whatever is not highly unusual in society at large. And for example, I was, looking something up last night, actually. There are 2.5 million approximately estimated electric vehicles in this nation that are registered to drive on the road. I don't think people would say those are highly unusual in society at large. Those are common vehicles.
So
and
if
yet
it's
there are
popular,
2.5 million. Yes, if it is.
So popular and common is the same thing.
If law-abiding citizens possess it, what Heller says is what's not protected is what's not typically possessed by law-abiding citizens for lawful purposes. So if it's something that's common, if it's something that is not highly unusual, then yes, it's protected.
Mr. Patterson, so you indicated, you just described what the test should be for common use. So, but the state still can come back and present evidence, if it can, that notwithstanding its common use, even for the core reason of self-defense, that the particular weapon at issue is either unusual and dangerous, right? You agree with that?
I do not agree with that. If something is common use, it is by definition both not unusual, but it's also not dangerous, because it has to be dangerous compared to what? And it would be dangerous compared to what is common. And if something is in common use, it can't be unusually dangerous.
So to give the example of your the machine gun example,
Yes.
which we alluded to earlier, if for some
Yes.
reason that had become unregulated, you told us earlier that the problem with that handgun, that weapon, is that it's not easily managed and it can
Correct.
cause indiscriminate
Correct.
firing. But under your view, that wouldn't matter. A state couldn't legislate that if it were in common use for a lawful purpose.
If it were in common use for lawful, it's a conjunctive test. The state has to show dangerous and unusual. And if it's in common use, it can't be unusual. And again, it also can't be unusually
Okay, so
dangerous.
let me, the last thing I'll ask you, and
Yes.
of course, my colleagues may have other questions. You pointed to media stories about the commonality of these weapons, and that may be in fact true. But what about, would the state be able to look to the media stories of its increasing use in mass shootings?
No, and actually, once it's in common use, if we look at the dissenters in Heller and Bruin, and there was a amicus brief in Heller, Violence Policy Center, that was basically the exact same arguments the state is making, except with respect to handguns. Same thing in Justice Breyer's dissent, and Bruin went through mass shootings, urbanization, increased lethality of firearms. The majority didn't talk about any of that
But
in
how
either of the
can
cases.
common use in mass shootings be for a lawful purpose?
That's not for a lawful purpose, but that is a
Huh?
very rare use of these firearms. First of all, handguns are the weapons of choice in mass shootings. That's what the state's own information shows. Handguns, actually, the use of these firearms in mass shootings are not associated with increased lethality. The use of handguns is. That's what the Blau study found. That's in the Coper's report that the state cited. But in any event, if we look at all rifles in this nation, there are approximately 350 people are murdered with rifles a year in the nation. Of course, every one of those is a deplorable event. We don't support it, of course. But if we were to say every single one of those rifles was one of the banned rifles and was a different one of the banned rifles, that would mean that 99.9% over of these rifles are not used for that purpose. And it pales in comparison of handguns, which is over 6,500 murders a year in handguns. So as Justice Kavanaugh said, if we were going to use the language of assault weapons, it really would be handguns, because that is what is the preferred firearm for both regular criminals and mass shooters. And if that could not support a ban of handguns in Heller, the lesser use of these firearms for those purposes can't support a ban in this case.
All right, thank you very much, Mr. Patterson. We're going to come down and greet counsel, and thank you both for your able arguments, and then take a brief recess before we move on to our second case.
This honorable court will take a brief recess.
Wants America to know the truth. He can explain how the Russian stimulated conspiracy theories and lies that he promoted with Rudy Giuliani live on in the tiresome fabrication spread by Alex Smirnoff and now repeated by this committee like Pavlov's dog. At every turn, my colleagues cry Russia hoax, even in the face of repeated warnings from Donald Trump's own Treasury Secretary and Secretary of State, from the intelligence community, from Robert Mueller, and most recently from Special Counsel Weiss, who was named to office by Donald Trump. As Secretary Mnuchin stated, quote, Russian disinformation campaigns targeting American citizens are a threat to our democracy. That's Secretary Mnuchin, someone that you guys usually defend, but my GOP colleagues continue to cry Russia hoax like cult members selling flowers at the airport. Our colleagues are the ones loyally amplifying the actual Russian hoax, not the Russia hoax, the Russian hoax, the one that Giuliani and Trump and Smirnoff have eagerly adopted from Putin and his agents. They participate in this hoax while they shamefully block $60 billion in military assistance to President Zelensky and the besieged Ukrainian people, 5 years after Trump and Giuliani tried to shake President Zelensky down for counterfeit dirt on Joe Biden. And while they continue to parrot these transparent Russian lies, Vladimir Putin wages his bloody aggressive war on Ukraine, filled with atrocities like the mass kidnapping of children and the rape and slaughter of civilians. The MAGA right's wholesale adoption of this Russian hoax and their sellout of the Ukrainian people by the MAGA right is an historic betrayal of democracy, freedom, and the rule of law. But the defense of democracy begins with fidelity to the truth, and the oversight Democrats, America's truth squad against this disinformation, is here today to set the record straight. I yield back to you, Mr. Chairman.
I would now like to introduce our witnesses. Mr. Tony Bobulinski, Mr. Bobulinski was a business partner of Hunter Biden in a joint venture between a Chinese energy entity, CEFC. Mr. Bobulinski sat for a transcribed interview with the committee on February 13th, 2024. Mr. Lev Parnas. Mr. Parnas was not a business associate of the Biden family. Mr. Parnas is an entrepreneur, a political activist, and an author. And Mr. Jason Galanis. Mr. Galanis was a business partner of Hunter Biden. Mr. Galanis sat for a transcribed interview with this committee on February 23rd, 2024. We asked the Bureau of Prisons to make him available in person today. They would only provide Mr. Galanis for virtual testimony. Notably, Mr. Galanis applied for CARES Act home confinement, and after a lengthy approval process, was approved for home confinement on June 9th, 2023. On June 12th, 2023, I issued a subpoena to Devin Archer for testimony. On the following day, June 13th, 2023, Mr. Galanis' approval was reversed as a result of Department of Justice's intervention. So Mr. Galanis has remained in a federal prison facility. He is currently in Montgomery, Alabama. Mr. Galanis, can you please state for the record who else is in the room with you?
Yes, Chairman Coleman, my counsel and advisor, Mark Paletta, and Nicholas Wise.
Thank you. Pursuant to Committee Rule 9G, the witnesses will please stand and raise their right hands. Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. Thank you. You all may be seated. We appreciate you all being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statements and they will appear in full in the hearing record. Please limit your oral statements to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. And when the red light comes on, your 5 minutes is expired, and we would ask that you would please wrap it up as quickly as possible. I now recognize Mr. Bobulinski for his opening statement.
Should I allow Hunter to give his opening statement first?
Doesn't appear Mr. Biden showed up for his public hearing, so we'll recognize you, Mr. Bobulinski.
Thank you, Mr. Chairman. Chairman, ranking members, and members of Congress, good morning. Thank you for this opportunity to speak with you and present my truthful testimony to the American people. I sit here today under oath for one reason and one reason only. The American people deserve to hear the truth. Though the truth involving the deep corruption of the Biden family, including the malfeasance of the sitting president of the United States, might be raw and unpleasant, the American people must hear it. You're presented here today with two narratives in this investigation. A false one being pushed by Joe Biden, a serial liar and fabulous, now under this impeachment investigation for public corruption. His brother, Jim Biden, a 75-year-old man who can't keep his lies straight, including under oath, and his son, Hunter Biden, a chronic drug addict facing 2 indictments with 12 counts. You also have before you the truth, confirmed by multiple Biden family business partners over many years and backed up by mountains of irrefutable evidence, including text messages, emails, documents, recordings. I am the only Biden family business partner with an impeccable military record. I'm grateful that this country has given me the freedom to be successful. I worked hard to become independently wealthy. I've taken several businesses public, sold multiple businesses to some of the world's best private equity firms. In fact, my business success is why they sought me out. People without hesitation and remorse. Rep. Dan Goldman and Jamie Raskin, both lawyers, and Mr. Goldman, a former prosecutor with the SDNY from New York, will continue to lie today in this hearing and then go straight to the media to tell more lies. Hunter Biden's defense attorney, Abby Lowell, weaponizes letters to Congress to try to smear my name
Mr.
and
Chairman.
misstate the cold hard facts
Mr. Chairman.
in an attempt to save his powerfully connected client
Wait.
and his father. I challenge Mr. Lowell to make those claims on national television so he can be held accountable for his lies. Prior to my successful business career, I was an officer in the United States Navy. At Navy's Elite Naval Nuclear Power Training Command, I later served as the command's chief technology officer.
Please proceed. I apologize for the disruption from the.
Okay. Am I supposed to say it's my time, Mr. Raskin?
Yeah. But please, Mr. Bobulinski, please
Okay.
come to order. Mr. Bobulinski, please
Oh, I'm sorry.
proceed.
Okay.
Please proceed. I apologize for the disruption from the minority.
Okay.
Well, Mr. Chairman, save his time, but he called members of this committee liars, and I just want to know whether the order and decorum requirements of House Rule 11 apply to witnesses appearing before the committee. Does it apply or does it not?
Should I address? I don't.
There's decorum from the members. We've asked for that. There's no language that I'm aware of pertaining to a witness.
Thank you.
So don't make sure we didn't waste any of his time on the opening statement. Mr. Bobulinski, I'm sorry for the disruption. Please continue your opening
Yeah,
statement.
I think you, Mr. Raskin, used.
We'll make sure it's right. We'll
Oh,
make sure.
okay, great. I just want to restate, make sure the American people hear all these facts. Abby Lowell weaponizes letters to Congress to try to smear my name and misstate the cold hard facts in an attempt to save his powerfully connected client and his father. I challenge Mr. Lowell to make those claims on national television so he can be held accountable for his lies. Prior to my successful business career, I was an officer for over 6 years in the United States Navy's Elite Naval Nuclear Power Training Command as a decorated master training specialist. I later served as the commander's chief technology officer, where I held a Q security clearance from the Department of Energy and the NSA. When I left Nuclear Power Training Command, I was the #1 ranked direct input officer in the entire command. And then I jumped into the business world and public markets. While I have made a few contributions over the years to Democrats, such as Representative Ro Khanna, I don't see him, but I hope he shows up today. He sits on the Democratic side of the Oversight Committee. I'm not a political person. I come from a family with a long history of distinguished service in our nation's military, including my father, both of my grandfathers, and my brother, all of whom were willing to sacrifice their lives for this great country. My sister serves our military vets for 2 decades at the Veterans Administration. We've lived our life as a family in service to this great country. I hope the American people will pay close attention to this hearing. I also hope they will understand that some members of this committee will engage in absurd attacks and efforts to try to deflect attention from the facts. And I will present today by questioning my integrity and my patriotic duty. You may see me speak passionately at this hearing, but for good reason. Not only was I willing to die for this country, every single male member of my immediate family was willing to die for this country. I want to be crystal clear. From my direct personal experience and what I've subsequently come to learn, it is clear to me that Joe Biden was the brand being sold by the Biden family. His family's foreign influence peddling operation from China to Ukraine and elsewhere sold out to foreign actors who are seeking to gain influence and access to Joe Biden and the United States government. Joe Biden was more than a participant in and a beneficiary of his family's business. He was an active, aware enabler who met with business associates such as myself to further the business, despite being buffered by a complex scheme to maintain plausible deniability. I ask this big question. If there's no evidence of corruption here today, if Joe's conduct and the conduct of his family were fully legal and proper, then why are they so dishonest about it? Not just slight misrepresentations of fact, but deep untruths about the entire corrupt enterprise. Hunter Biden gave his transcribed interview on February 28th and lied throughout his testimony. Here's just one egregious example of Hunter's perjury. He lied to the committee on important details concerning his money demands and threats to CFC in text messages on July 30th and 31st, 2017. He leveraged his father's presence next to him in that infamous text to strong-arm CFC to paying Hunter immediately. Jim Biden also lied extensively throughout his transcribed interview on February 21st and perjured himself. An example of that, on page 100 of his transcript, Jim is asked specifically, Do you recall having a meeting with Hunter Biden, Tony Bobulinski, and Joe Biden? Jim's response, absolutely not. The committee was so shocked by his perjury that they asked him the same question multiple times. Each time he denied meeting with me and Joe Biden. After the committee showed him text messages confirming that I met with Joe Biden, Hunter Biden, and Jim Biden at the Beverly Hilton in May 2017, Jim Biden, with a former U.S. attorney lawyer sitting next to him, still denied that meeting took place. Hunter Biden, in his own transcribed interview, confirmed that that meeting took place. Hunter confirmed his uncle perjured himself in front of this committee. I'm simply here to tell the truth to the American people, and I hope each and every one of you, congressmen and women, give me the opportunity to do that instead of focusing on Russia or smearing my family's name or focusing on facts that are irrelevant today. I yield back.
Thank you.
Mr. Chairman, parliamentary inquiry?
Yes.
Just 2 points. One is, I believe Mr. Bobulinski went over 2 minutes, 14 seconds. I hope the same courtesy will be
We will
extended.
give Mr. Parnas equal time.
Thank you.
that we
And
gave Mr.
secondly, I see that we now have a witness appearing remotely, and I thought that witnesses were required to appear in person under the rules adopted by the majority at the beginning of the Congress. And do we have a new practice with respect to that rule? Because I know that members on our side were denied the ability to participate in hearings that were conducted in Florida and Mississippi and Alabama. We wanted to participate by Zoom. So I hope.
And I'll answer that. It
Yeah.
requires to be able to testify remotely requires a letter from me and an approval from the majority leader, which we have. And I'll enter that
Good.
letter into the record without objection.
Thank you, Mr. Chairman. I hope we'll extend the same courtesy to members of this committee when they can't get to a hearing as in Mississippi or Florida.
It's a collateral law enforcement. At least this is what I'm wondering, whether it could be just a collateral law enforcement device in order to help the order in solving of misuse of firearms.
So, Your Honor, it is true that that serial numbers are helpful for the purpose of solving crimes. I don't think that's how serial numbers originally came to be. They were put on firearms by many private manufacturers more than a century before they were required by the Gun Control Act of 1968. So they serve other useful purposes for the manufacturer and for the owners of the firearms to ensure that their firearms can be recovered if stolen, to know the provenance of their firearms, et cetera.
But why was the statute adopted that made it a crime to file the thing off?
It was for the very reason that Judge Niemeyer just suggested. It was to ensure that firearms that were used in crimes could be traced. It was a law enforcement purpose.
To help find the crook.
That's correct, Your Honor. And again, if we're looking at this from the sort of common use perspective, as we pointed out.
If you're going to rob a bank or be an assassin or something, you don't want a firearm with a serial number.
That's correct, Your Honor.
The question remains is whether that is a Second Amendment aspect, something that's under the umbrella of the Second Amendment. In other words, true, it's attached to a firearm, but the nature of the firearm, the way it functions, whether it's useful, whether it's common, whether it's bearable, all those things are not implicated by the serial number. The serial number seems to be somewhat collateral. I don't know what a good analogy would be, but there's something intuitive to suggest that government can regulate firearms in order to assist law enforcement, quite apart from the Second Amendment right to bear arms.
Absolutely, Your Honor. And the government, to be clear, the government hasn't made the kind of argument that you're suggesting that the Second Amendment simply isn't implicated here. I think, and the reason is that this is different, say, from a silencer or something else that can be attached to an arm but isn't actually itself part of the arm. Here, one of the elements of the offense is that there is a firearm on which the serial number is obliterated. And so the government can't prove the offense without proving that there's a possession of a firearm. And a serial number is not something that's sort of, entirely removed from, or can be entirely removed from the serial number, from the firearm in the same sense that a silencer can. But again, it is odd because, as you point out, the removal of the serial number doesn't affect the functioning of the firearm.
Let me ask you something about the sequencing of proofs. And the question is, do we are we bound to decide the common use question prior to addressing historical limitations? And I was wondering if we had some flexibility with respect to that, and whether one can assume arguendo that they might be in common use, but that the historical limitation is so clear. And so we can, if that would resolve, I wonder if courts of appeals are permitted to pursue the most direct way of resolving the case. And I thought maybe the Seventh Circuit did something along those exact lines and proceed directly to, the Supreme Court's always given us a little bit of leeway on how we order sequences of proof and in how we order the steps. And so I'm wondering if, and I think I'm interpreting the Seventh Circuit opinion correctly, but I'm wondering if it would be feasible, in your view, for a court of appeals to say the historical record and purpose is so clear that the limitation is permissible.
Absolutely, Your Honor. It would, the court could go that route if it preferred. And in fact, of the district courts that have considered Section 922K's constitutionality post-Bruin, there have been 14 district court decisions. 2 of them did that exact thing. They assumed that this was a firearm that was in common use.
What I'm saying is I don't think this court is in a straitjacket.
Absolutely.
As
Absolutely
opposed
not.
to, and it would be, there are many cases which would seem to indicate that the Court of Appeals can proceed directly to what will dispose of the case, because that's our job, is to resolve cases. And one other thing that concerned me here is that, there's this aphorism about all roads lead to Rome. And in this case, there is a phalanx, a Roman phalanx of district court opinions barring the appellee's entrance into Rome. There must be, I can't count the number of district court opinions, which as an appellate judge, I still greatly respect, but they've upheld this almost uniformly. And what we had here was a single district court that varied from not just a consensus, but from an overwhelming consensus that other district courts all across the country did not want to start unraveling Section 922. Section 922, more than any other section of the U.S. Code, is probably essential to federal law enforcement. We all have, it prevents domestic violence, it prevents felons from being in the possession of a firearm. And we start knocking down Section 1922. Who's to know where that's going to end? The next thing we'll have is a challenge to 922G. And so, I can hardly even begin to imagine the number of dominoes that could begin to fall.
Yes, Your Honor, and there have been challenges to Section 922G1 and other provisions within 922G.
How many district courts are there that agree with you?
On 922K, Your Honor, there are 14 district court decisions that have agreed with us. And if I can, just to defend the district court.
How many consistent with this?
This is the only decision. And to defend.
I want to ask you a question. Have you ever heard of Ashwander? Okay.
Yes, Your Honor.
Ashwander case.
Yes, Your Honor.
You know what it stands for?
It's been a long time, Your Honor. I think law school.
It stands for the proposition that if we, the court here, a reviewing court, can decide a case on a non-constitutional ground, we never go to the constitutional question. We only decide the constitutional issue as a last resort.
Yes, Your Honor.
So is there a non-constitutional ground here
Your Honor, I don't see a non-constitutional ground for reversing the district court's decision, finding the statute unconstitutional on its face. I think the court does need to address the constitutionality of Section 922K, at least as applied to this defendant, and thereby by concluding that it's not facially invalid. If I can, to just briefly defend the district court, this was the first district court decision reaching 922K. So we think it's wrong, but it was the first one to do it. Now, there have been 14 district courts, 13 district judges subsequently who have considered the constitutionality of 922K with the benefit of the district court decision below and have unanimously disagreed with it. So the district court, we just think, got this wrong, and other district courts have recognized
Did you go
that.
back to him and ask him to reconsider and vacate the thing?
Your Honor, this court, I think the constitutional question is squarely before this court. And if the court doesn't decide it now, it will likely be deciding it in a different posture when a defendant whose motion to dismiss has been denied appeals. So I think the court might as well go ahead and decide it now. But if I can return to Judge Wilkinson's question about sort of the most straightforward way to resolve this case, there are at least two different ways the court can resolve it. One is to sort of look at our historical analogs and conclude that they're close enough that they satisfy Bruin. But another way is simply to conclude that firearms with obliterated, removed, or altered serial numbers are not in common use for lawful purposes like self-defense. I think that it's the latter that is the most straightforward, the in common use question. We certainly would have no problem with the court going either route.
That arises because when we get in the business of talking about this dangerous and unusual, at least the dangerous nature of it, Allah made it clear that all these weapons are dangerous. Particularly, it said that handgun is dangerous because it's lightweight, can be moved a whole bit. So that cannot be the determinative factor. Otherwise, then we're left in the untenable position, if the word is untenable, of differentiating between a handgun and a machine gun and figure out, well, when does it become dangerous and unusual? But it uses that language, and I don't think Bruin gave us that standard, gave us that language, that statute that says, is it in common use for a lawful purpose? And I think your focus is right. Step one under Bruin, which comes under the plain text of it when you analyze in the words of the Second Amendment, that brings those things under Bruin before you go into that second step of shifting the burden to the government.
So Judge Wayne, as you know from our supplemental brief, and I realize there's disagreement maybe among the members of the court, but we think that the common use question does belong under the first textual step. But again, I don't think it matters because the Supreme Court said that common use limitation, it said in Heller, that common use limitation is fairly supported by the historical record that supports banning dangerous and unusual weapons.
But it may matter in terms of the narrowness of our interpretation. Once we go in step two, we're in a whole different world. If we're talking about plain text and does it fit within the lawful purpose of common use, that's a burden that, at least in terms of the determination of plain text, is pretty straightforward. Straight textualism dealing with that base step. When we slide into the other section, we're in a whole different world.
Generally speaking, you are, Your Honor, but I don't think you are in the context of common use because the Supreme Court has said that the common use limitation on the Second Amendment accords with the historical understanding. And in fact, Bruin repeated that. So Bruin at page 47 of the U.S. report said that the Second Amendment, quote, protects only the carrying of weapons that are those, quoting Heller, in common use at the time, as opposed to those that are, again, quoting Heller, highly unusual in society at large. So
counsel,
Bruin,
doesn't it matter if it's at step 1 or 2 because the burden of proof differs? Is it your position that even if the burden of proof is on the state, you have satisfied that burden?
yes, Your Honor, it does affect the burden. I think that's fair to say, but it doesn't affect the burden sort of on whether the common use limitation is consistent with history, because Heller and Bruin decided that. It only affects whether this particular firearm is in common use. And again, that's part of the reason we think it fits better in the first question, in that it's very odd to be sort of looking at the historical tradition of firearm regulation.
Were you in the courtroom during the last argument?
I was, Your Honor, yes.
Well, it seems to me if we go down that trail, if you look at the plain text, it has nothing to do with that. The plain text, they said, is unrestricted, and the restrictions come in by showing the historical notion. The language, I'm trying to think of the exact language, but it's basically the suggestion that it's any weapon that's a bearable arm. And if we get into that discussion, it seems to me your suggestion that we go right to one of the historical things that you suggest the best is that it was not in common use for lawful purposes. It seems to me that is a much more constructive suggestion than the enormous debate about what we engaged in during the last argument.
Yes, Judge Niemeyer, and again, to sort of circle back to Judge Quattlebaum's question, if we bear the burden of showing that these firearms are not in common use, we think we can meet that. It wasn't even until the supplemental brief that Mr. Price's counsel attempted to demonstrate that firearms with obliterated serial numbers may in fact be in common use, and I don't think even embraces that position fully.
Well, wouldn't it have to also be for a lawful purpose? And we're talking about a regulation imposed by the state to assist in law enforcement, which is not even directed at the nature of the firearm and how it functions or whatever. It's as you pointed out, it's how to solve these bank robberies and these murders and
exactly,
et cetera. And it seems to me this would be a lawful purpose. The person who obliterates doesn't have any lawful purpose except to avoid evidence that points at him.
That's correct, Your Honor. So I think that the ATF statistics that both parties cite in the supplemental briefs actually demonstrate that firearms with obliterated serial numbers are not even probably in common use for unlawful purposes among crime guns. So the ATF statistics indicate that only 2.5% of the crime guns that are submitted to ATF for tracing have obliterated, removed, or altered serial numbers. So it's
what was the percentage?
2.5%. So the number that's submitted to ATF is about 5,000 to 6,000 per year. And those are crime guns. So that means that even among criminals, these are not the preferred weapon. And
Can I ask you a
sure.
clarifying question? Earlier, you said there could be two ways that we could rule in your favor. You said one was the historical evidence that you put forward about markings on guns, and an alternative way was not in common use for a lawful purpose.
Correct.
You said your markings are kind of historical analogs, and the other is the common use question. Why are those different? I thought the question whether a gun is in, or a weapon, excuse me, is in common use for a lawful purpose. That's the historical analog, is it not, that dangerous and unusual weapons can be banned?
Your Honor, I think they are different questions, and the reason is that so take for example Bruin. Bruin concluded handguns are in common use today for lawful purposes, no question. And so then Bruin started looking to those historical analogs to determine whether a limitation on the public carry of firearms was.
Question of where did the court come up with the idea that the government can ban weapons that are dangerous and unusual? Did they look to history?
So, Your Honor, yes, Heller.
That was the historical analog. So isn't one of your analogs here that these weapons are not in common use for a lawful purpose? And historically, the government's been able to regulate and ban those sorts of weapons?
Well, Your Honor, I don't think that's actually a historical analog question. So we have our historical analogs, and then we have the sort of separate question that's a question, present day question, as to whether or not a firearm is in common use.
What's the principle that your historical analogs are getting at? What's the historical principle I'm supposed to draw from the markings on the firearms?
So, Your Honor, if I can answer that in two ways. So I think there's one historical principle that the Supreme Court has resolved, which is that as a historical matter, firearms that are not in common use can be banned. A second historical principle that we've
so that first one is a historical principle.
Correct.
That's a historical analog that you could try to draw comparisons to today.
Yes, Your Honor, and we argue they're not in common use. And then the second historical analog that I think is the sort of more traditional Heller Step 2 test is where we say, let's assume that they are in common use. The Section 922K is nevertheless consistent with a historical tradition of regulating commerce in firearms and specifically preventing the obliteration of markings on firearms and on inspected gun fire.
Potential historical justifications.
That's correct, Your Honor, if you conceive of the common use as a historical question. I think it doesn't matter whether you conceive it as historical or plain text, because the Supreme Court has resolved it either way and said it exists, it's consistent with history. It may be a textual question, but whether or not it is, it's done.
So if I don't find your, markings on gunpowder or whatever totally persuasive. But I do think that this is a step 2 question. Can you still prevail because there's a historical analog to weapons that are dangerous and unusual?
Your Honor, we can, but I don't think we need to, because Heller cited, I think, 8 or 10 different historical sources right after that line that it said the in common use limitation is consistent with the
Right.
historical tradition.
You don't have to repeat all of that in your
Right.
brief. I'm just asking.
Sure. So we can satisfy that historical part of it. And then all we have left is the present day question of whether or not these firearms are in common use for lawful purposes. And again, as I was addressing earlier, they simply aren't, even for unlawful purposes, but particularly for lawful purposes. There's just no reason why a law-abiding citizen would want to possess a firearm with an obliterated serial number. Again, the statute doesn't apply to firearms that were manufactured before 1968 without serial numbers. All the firearms that are presently manufactured and imported into the United States come with serial numbers. So the only way a firearm can end up like this is if someone takes a file to that serial number. And Mr. Price's view is that this court should assume that the obliteration of serial numbers happens sort of at the same rate in the population as a whole as it does among those 5,000 to 6,000 crime guns per year that are submitted to ATF. We just think that there's no basis for reaching that conclusion. And again, we rely on the Third Circuit's observations that, setting aside whether these were in common use for sort of any purpose, there's just not a lawful purpose to possess them. So we think that
The obliteration, the obliteration statute didn't take effect until the late 60s, is that right?
that's not quite correct, Your Honor. So the 1938 Federal Firearms Act had a prohibition on the receipt of firearms in interstate commerce with an obliterated serial number. And then in 1968, that was sort of passed again, taking away the presumption that the 1938 statute had that if you possessed a firearm in interstate commerce, you had actually been the one who obliterated it. And then it was in 1990 that Congress added the possession of a firearm that has previously moved in interstate commerce.
Is there a statute that requires firearms to have serial numbers?
Yes, Your Honor. That was part of the 1968 Gun Control Act.
So before 1968, there was no requirement to put a serial number on?
That's correct. There was no requirement, but it was extremely common, done voluntarily by private manufacturers dating back to the 1800s.
It seems to me that that's such a de minimis regulation of a firearm to say it has to have a serial number that you could, the common use is the flip side of that. It's even more uncommon to have the firearm removed, and the only core purpose for removing it is to protect a user from his uncovering his misuse.
That's right, Your Honor. I agree.
And so there's sort of a de minimis notion here. I mean, we're talking about, this goes back to the notion that are serial numbers really the regulation of firearms? When we're talking about you have to have a serial number, and if you obliterate a serial number, it's a crime.
So yes, Your Honor, we made a separate argument that there's no infringement of the Second Amendment right. That was potentially foreclosed for a little while by the Maryland shall issue case. I think that we certainly aren't backing away from those arguments.
No, but you have a district court that approached it under the Constitution, and your argument is that it's an outlier and we should correct that.
Absolutely, Your Honor. And if the court has no further questions now, I'll save my time for rebuttal.
Thank you, counsel.
Thank you.
Mr. Coleman.
Thank you, Your Honors. Lex Coleman on behalf of Randy Price. As far as the issue that's going to decide this case, it's going to be whether you choose to apply Bruin as it's written or do something else. And that's in part what the United States is encouraging you to do. Instead of a phalanx of cases, I would characterize Judge Goodwin as the 300 Spartans at Thermopylae. He was the first, and he did apply Bruin as it was written. He looked at the text. He looked at the Second Amendment. What did it say?
Well, in Bruin, there was no question that the parties in that qualified as part of the people for Second Amendment purposes.
Correct.
And the first case we had here, I don't think that's an issue either. But here, tell us why Mr. Price is part of the people. He's twice convicted of violent felonies. Why is he part of the people?
Because Scalia in defining the operative clause defined the people the way it is in the first, fourth, in saying under the Second Amendment. Remember, he went to different parts of the Constitution. Judge Niemeyer, you're right. It wasn't a dictionary definition. A lot of the dictionary definitions were consistent, but Justice Scalia looked at those parts of the Constitution that looked at it as a, what did he call it, a citizen or a status type right unrelated to the individual.
A member of the political community.
And then under the first, Fourth, and Second Amendment, right, you're a member of the national politics, the national
Do you
community.
think we interpret those, the Article 1 and the Second and Fourth Amendments in peri materia in that regard?
We don't say that anyone convicted of a felon doesn't have their free speech rights. We don't say that their past conviction deprives them of the right to be free from unlawful search and seizures.
That's true to a limited extent. And I've read the other circuit opinions, particularly the Third Circuit, when they go through and make these comparisons. But I'm doubtful that they're accurate. Under Article 1, the members of the House of Representatives are elected by the people, but felons don't vote in that. Second Amendment and the Fourth Amendment will cover convicted felons, illegal aliens. But arguably, under the Second Amendment, they aren't law-abiding responsible citizens, and illegal aliens are not entitled to a gun. So it doesn't seem like to me that they're necessarily the same in each amendment.
Well, when we're looking at Bruin's first step in the textual analysis, there's no distinction in the Second Amendment as to law-abiding people and non-law-abiding people. To any, it's the people, just like it's the arms. And it's necessarily general at that stage because keep in mind what happened. Heller identified the individual right for the first time. Justice Stevens and Scalia went back and forth for 67 pages. And in the end, the result was not these details we're working out now through the courts, but is there even an individual right at that point?
Where, in your view, does the constant refrain in Heller, Bruin, McDonald of law-abiding responsible citizens, where does that fit into the analysis?
Well, in two places. The first, it's the apex. That's the top. That's where the right, back when we were going, certain people can get part of the right and not all the right, which I never thought was correct, but that's what the courts did for almost 15 years. And then Bruin comes out and says, well, no, we're not doing means and scrutiny. We're not using your status to give you a partial right here and then subject it to intermediate scrutiny. That's the first.
I thought they said it was one step too many.
He did. And then we go to the next point is that it fits in the historical analysis. It's the idea. You do the generality to get the presumption. It's only prima facie. And then it's up to testing what with history with a well-established representative regulation either disqualifies it because of who someone is, what a gun does, how it's used. All three, well, let's see, in common use was used in Heller 7 times -2 in the syllabus. In Bruin, it was 5 -2 in the syllabus. And then it's kind of the same situation with law-abiding citizens. And again, there are several cases that refer to that, and some in this court and others as more dicta, because those determinations weren't essential to the finding of the court, which was whether it was an individual or a collectivist right. So it's in the mix, no doubt. I don't think it prohibits the Bruin step 1 at all, but it definitely comes into play in the second step. And that's being litigated now. 922G, Judge Wilkinson, I've got 2 cases before this court, and I know Canada has already been argued. I'm not sure how that's going to come down. But this is being litigated around the country as it should be. I mean, Bruin did act kind of as a sea change in a way and saying, no, everything else we're doing, we got to go back to Heller and do it the way Heller did it.
Mr. Coleman, can I ask, do you believe that the law that requires manufacturers to put a serial number on a firearm is unconstitutional?
I think it's got a lot better chance of surviving as a commercial regulation.
So let's take that as a
than
yes.
possession.
Do you, then it's further, so, okay, so the gun has to have, if it's manufactured after a certain date, it has to have a serial. Do you agree that it's a crime to literally take a file to the barrel and obliterate the serial number? That there's a law that's illegal to do that, right?
That's what Congress has passed. Yes.
Do you believe it is unconstitutional to forbid people from removing serial numbers?
I think I've got a better argument than I would the manufacturer being required.
I'm not asking if you think you have a better argument. I'm asking if you think that is unconstitutional. Because you see what I'm saying? I guess I'll just lay this out. If it is lawful for Congress to require serial numbers, and it's lawful to forbid you from removing the serial number, I don't see how it's not then lawful to prohibit the knowing possession of a gun with an obliterated serial. So it seems to me, I don't see how you can possibly win this challenge unless it is also unconstitutional to forbid someone from obliterating a serial number.
Well, the reason I don't believe the three are the same.
I'm not asking if you think they're the same. Let me put it this way. If I think it is obvious that Congress can forbid you from obliterating a serial number, do you have any argument that remains that they can't forbid you from knowingly possessing a firearm with an obliterated serial number?
It goes to the burden on possession in the text of the Second Amendment. We've got burden, the manufacturer is required to put a number on it to sell it.
Right.
Okay, the Second Amendment doesn't protect my right to sell a firearm, it protects my right to bear and carry one. Same thing with an obliterated serial. Once you get it, you've got a stronger case. You don't have a constitutional right to obliterate. You have a constitutional right to possess and carry a weapon.
Sure.
So.
But it seems to me that the possession for unlawful purpose doesn't fall within the scope of the Second Amendment, does it?
Kind of got two things going here.
Well,
Your Honor, if I may.
I'm picking up on the argument that we're not talking about the obliteration. That's a law, an okay law, obliterate the serial number. We're assuming that.
Yes, sir.
The issue is whether possession of a gun that is obliterated is unlawful. And you say, well, the possession aspect is protected by the Second Amendment. To me, I would agree that it's presumptively covered by the Second Amendment. But then you get into the notion that that is the possession of a firearm for an unlawful purpose.
Well,
Because you're violating the law and possessing one, especially if you do the obliterating.
well, the unlawful purpose doctrine, as well as the dangerous and unusual doctrine or limit, that's better than a doctrine.
There are limits.
Goes to physical characteristics of the gun. It's still a handgun that's out there to be used as a handgun. If you look at the ASTF statistics, 1.5 million of the handguns with serial numbers are crime guns. So what's the more unlawful use? The serial numbered guns that measure 1.5 million or the 2.5%, which are right around 50,000, that they say have obliterated, and that's why they can't trace them back. There's also another assumption that I want to make sure the court's doing right about tracing. All tracing does, all these serial numbers do under the Gun Control Act is get from the original seller to the original buyer. Only 12% over 5 years got to the person who possessed it in connection with committing a crime. That's not 1%, but it's still out of almost 2 million guns. How much is that really? I mean, there's some help, and of course, we always want some help. But we're talking about a fundamental right under the Second Amendment, and by virtue of possession in this statute, 922K, possession of an arm, which is protected conduct, there's an assumption made, the only reason it doesn't have a serial number is for bad acting. And you know what? There are bad actors that take it off, but there are also people that come into possession that are not bad acting and simply have a gun that has a serial number. It doesn't even have to be obliterated. It could be damaged a little bit. There could be a ding on a letter, on a number. And the law of this circuit is that's enough to show substantial damage to enforce, if not a sentencing enhancement later, then certainly even a conviction under 922K. And that burdens a right protected by the Second Amendment, even if it's only for 2.5% of the population. And that's assuming they're only criminals have it. And it's still, this is a variation of function. And Judge Rushing, in the prior hearing, you asked the right question. If in common use goes to the first step, how does it possibly have an historical basis? When Heller says multiple times in Part 3, as well as in Part 2 of that opinion, that it's historical, historical, historical. That's Bruin Part 2. If it's in Bruin Part 1, it has no use in Part 2.
Is removing the serial number adapting the gun for an unlawful use?
Not in a functional context, no.
But if we have this evidence that the reason serial numbers are obliterated or removed or altered is to prevent tracing, so people's illegal acts can't be found out.
Well,
Is the filing off of the serial number adapting the gun to unlawful use?
There are certainly instances where it is, and there are certainly plenty, probably where there's not. Some
How
could be
do I know
incidental.
that?
Ma'am,
How do I figure that out?
the government should carry the burden of proof and show it to you under Part 2. That's how they should show it. There's a lot of assumption going around because we can't, what's the legitimate purpose? The purpose of that action is possessing a gun. That's the conduct.
But you have the gun. Before you file the serial number off, you have the gun. Now the question is when you take a file to the gun and remove the serial number.
But that's different than what's happening under 922K. They're not filing off, they're just possessing the gun.
Well, no, that's an important clarification. You're saying they're just, and the district judge mentioned this innocent possessor hypo. Just so we're clear, right, this statute doesn't prohibit the possession of a firearm that happens to have an obliterated serial number, right? The government has to show that I know it has an obliterated serial number, right?
Yes.
Okay, so the minute I know it has an obliterated serial number, I know I have a weapon, and it has to be a firearm that was required to have a serial number. So it can't be an antique, one of those that was made before, right? So I know that I own a firearm, that I've come into possession of a firearm that had a serial number, that someone took an act to remove the serial number, which was illegal when they did that, right? That's the hypothetical.
Sure.
Well, so then you say you have to surrender. It's contraband at that point. What's wrong with saying at this point it's knowing possession of contraband?
It's only contraband because of a 1968 statute that makes it contraband. Or I can go by the United States version by going back to 1938. It's only contraband because of a 20th century statutory act of Congress, whereas every firearm before then.
Except I thought we agreed that that statute was constitutional. And so it makes it for an unlawful purpose. And if you go back to the analogs, historical analogs, it all of a sudden now becomes subject to regulation. The imposition of the statute requiring a serial number is not a Second Amendment problem.
Well, the manufacturers don't have a right to possess a firearm, right?
Well, the government has a right to require it too, right?
I think that would fall under a commercial regulation.
Right, okay. So now we do make it illegal. You're suggesting that because historically it wasn't illegal, but that doesn't matter. The historical aspect is whether you can possess something that is for an illegal purpose, or you can use something.
Well, no, I can possess something without a serial number. The insertion is it's only for an illegal purpose, and there's no basis for that. That's an assumption. It's not an irrational assumption, and there are
The statute says if it's obliterated, it has to have a serial number, and you can't obliterate it. Now the question is, who do we impose that against?
We're one step removed with simply possessing, not removing. A gun came into Mr. Price's possession that didn't have a serial number on it. Under current law.
And presumably because of the conviction, he knew that, right?
I beg your pardon?
Yeah, because of the conviction, he knew that. He knew the serial number was obliterated, right?
I believe that's not in dispute. That's correct.
Okay, that's not in dispute. All right, now he's holding a gun illegally. He knows against the law. He's trying to possess a gun which is illegal, which has been made illegal.
It's not made illegal because he's a felon in possession.
No, it's made illegal because it's obliterated serial number.
Okay, and that's where we get to this lack of an historical analog. It's only illegal because of the 20th century legislation. Prior to that, every gun in America didn't have to have a serial number at all. And we still have a percentage that are in circulation that were manufactured before 1968. And there's nothing wrong with them. They're not unusual. They're not dangerous. So what does that make them? You recognize that yourself, the flip side of not being dangerous and unusual.
You know, it makes a difference here, the fact that this is a federal statute, because both Heller and Bruin dealt with state regulations. But what we have here is an act of legislation by the entire Congress. And I learned very early on in law school that there's a presumption of constitutionality that attends act of Congress. It may be one thing to strike down a state regulation because sometimes is in the New York regulation or the DC regulation at issue in Heller and Bruin, sometimes a state by definition might be able to get out of line. But it's quite another thing to say, well, the whole Congress got out of line. There's a presumption of constitutionality that attends to federal statutes and to what the Congress is doing. And again, in Heller and Bruen, those were what was presented to the court was a state that had gotten too far onto the restrictive end of the spectrum. But that's not here. You're asking us to take the United States Congress and a key law enforcement provision and say to the Congress, you don't know what you're doing. That's what it seems to me the bottom line is.
Judge Wilkinson, I'm sorry you see it that way, because the overarching consideration over all gun legislation, except for what was done in 2023 after Uvalde, was that we had a collectivist interpretation of the Second Amendment. We only needed to satisfy rational basis. If we could articulate a governmental purpose, it passed.
I know.
And then we had to have
there are all sorts of Second Amendment questions. We don't know whether common use refers, suppose you have a large number of people that is still a very small percentage of the entire population. Is that common use? Or if you have a large number of people and it doesn't matter what percentage of the overall population, it's enough that a large number of people you have a particular weapon. The point is, common use is vague, and there's been no attempt to define it with precision. And until we get something that is much more explicit, I can't see taking what I think is a draconian step in telling the United States Congress, which is trying to ensure the safety of people across this land, and we might as well look at the fact that, because it was a background to what Congress is trying to do, and this is a mass shooting epidemic in this country, and it could be with the amicus briefs have pointed it out. I don't know that they're accurate in every particular, but in the general picture they paint, it rings true. And the figures that they put out, there have been more than 2,500 mass shootings occurring in the United States since 2020. 610 in 2020, 689 in 2021, 644 in 2022, 656 in 2023, an average of nearly 2 per day. And here we are presented with a series of lawsuits, including yours, that says we're going to say in the midst of all this, that the Congress of the United States in this federal statute didn't know what it was doing or was trespassing upon constitutional values and inhibitions. I just don't get it.
Your Honor, there have been over, tragically, 1,000 mass shootings the way they define it now, just this year. What we haven't had in the 20th century is the deference to the Second Amendment. None of these lawsuits that I'm aware of, including my own and Mr. Price's, in any way speak to try and avoid protecting American people. But when you get into that type of position you're looking at, you're going right back to means and balancing. It's like diminishing this isn't much of an infringement on a right. Heller brought up Nunn versus State in its discussion of the operative clause and said it perfectly captured the way the operative clause enhanced the prefatory clause. And it did a long quote of what the Georgia Supreme Court said back then in the 1800s. But it said basically that this right shall not be infringed, curtailed, or broken in upon in the smallest degree.
Mr. Coleman, so just to follow up on, I'm over here, sorry, right in the middle.
I'm sorry, Your Honor.
That's okay.
I recognize the voice. It's my eyes.
Well,
Let me
thank
put
you
them
for
on.
that anyway. I appreciate that.
Yes,
So to follow up on Judge Wilkinson's question and to make sure I understand your position, because earlier you conceded, I think correctly, that Congress has the right to require gun manufacturers to place serial numbers on weapons, right?
Yes.
And then Congress also has the right to require, to prohibit the obliteration of those serial numbers from those weapons. So if someone takes a file to a weapon, you conceded, I think, that Congress could prohibit that.
Well, what I would concede is that it's a better case of the statute surviving review. It would depend on how it was tied to infringing on possession,
Okay,
but it's not nearly like possession.
right. Right, and I'll get so the third point I was going to make is, so, but when it comes to possession, not someone who actually obliterated the serial number, but simply possessed it, at that point, you say that the Second Amendment comes out in full bloom. And at that point, the legislature is hamstrung in what it can do. And essentially what you're saying is it has to actually wait until that particular individual uses that weapon for an unlawful purpose. And only at that point can the government then take action.
Well, maybe it's the defender in me, but I look at the Bill of Rights as always hamstrung.
I'm not sure you answered my questions.
No, I'm going to answer.
Okay.
Yes, sir. It's like I said in the beginning of my argument, it's applying Bruin.
So the answer is yes. The answer to my question is yes.
The answer is the way this is applied here, yes. I believe Judge Goodwin did it correct. He went to the distinctly similar analysis because it was an old problem. It wasn't new. And the technology for affixing die marks to barrels existed in the 1700s. They could be done sequentially. Anybody questioning that, look at how they used to do a printing press.
Can I ask you a question about the actual statistics? So if we started to say, we want to understand whether these are in common use, we've sort of really focused on, I think, two studies the government provided us. One is the ATF study, and that's has some selection problems because that's only the guns that law enforcement submitted for tracing that ATF was unable to trace, right? So it doesn't include the hidden serial numbers that are included on lots of guns now, almost all the Colts, High Points, et cetera. Nor does it include those that were forensically recovered, which ATF has an entire branch that was done. So the 2.5%'s missing in three different ways. At least three different ways. They also cite to the Boston study, though, and it sort of seems to solve some of those problems, right? Because that's all guns that are seized, so not just those that are submitted for tracing. And the Boston study found that 20% of guns in that particular study had obliterated serial numbers. Is that your understanding of the Boston study?
I'm sorry, I haven't looked as hard as that as I did the ATF numbers.
Okay, if maybe I'll ask your colleague this on remand if you're not familiar with the Boston study.
Not like I'd like to know.
Then I don't think your answers will be helpful.
Let's say it is, you're still.
Well, just accept for a minute, hypothetically,
correct.
That it says that 20% of the guns that were found had obliterated serial numbers. That would tell us something about like that's a relatively prevalent or common thing to be carried, at least in Boston during this particular time period. Fair?
Right, for Boston and crime guns, correct.
And then if the study, and just accept as hypothetical that it does, that with respect to whether the guns that had obliterated serial numbers were more likely to have been used in substantive crimes, the study actually showed that most of the guns, it was 50% less likely to have an obliterated serial number if you committed a substantive crime. So if you had murder or robbery or assault, that you were actually less likely to have an obliterated serial number than if you just merely had the gun and were not committing an independent crime, a non-possession crime.
Exactly, and that's been true with 99% of the mass shootings in the past decade.
Right, which sort of would suggest to us that, in fact, whatever number of guns, if it's a small percentage like the ATF study suggests, or more like the 20% that the Boston study suggests, that you're more likely to have a gun with an obliterated serial number if you're not committing substantive crimes, right? That is, you are engaged in lawful conduct.
Certainly,
right?
that's an inference, yes.
Right, and that inference is what suggests to us, or ought to suggest to us, that when we look at whether obliterated serial number guns are in common use, right? Whether they're common. We can conclude just actually looking at statistics, not trying to surmise why somebody might prefer one thing or the other. We can actually conclude that they are common, right? At least based on the limited data that we have here.
Absolutely.
Well, let me ask you, it seems to me that the class of guns being discussed in those studies are guns seized from criminal conduct or submitted for tracing. But that doesn't take into account the millions of handguns that are in circulation lawfully. And so this probably less than 1%. I'll bet you it's a fraction of a percent when you consider the how many handguns are there in the country? 200 million or maybe more.
Well, that's not allowing for the ones that aren't submitted for tracing.
No, I'm talking about in common use. I mean, when you're talking about common use, wouldn't you be talking about societal use?
Well, generally, Your Honor, but forgive me, I don't remember if it's Judge Agee or Judge Wilkinson. We don't have a test, which is unfortunate.
No,
but that's not the
I
definitive
know,
problem.
but some things are common sense. And it seems to me that if we've seized X number of thousands of guns during crimes, and we compare that number against all the guns that are in circulation, it's going to be a very small number. In other words, the common use is a common notion. It's not breaking down classes of guns that have been submitted to the ATF or that have been picked up in crimes. It's how many guns in society have obliterated serial numbers. And it seems to me whatever number you pick is going to be a small fraction of 1%.
Well, that gets back to several points I raised earlier. One, it suggests it's a de minimis infraction on the right, which is contrary to Heller.
Don't you think that may be true, that it's de minimis?
I don't know, but I'd certainly not de minimis, Mr. Price.
None of the data we have suggests that it's de minimis.
Correct.
Right?
Correct.
We only can rely, maybe not only, but the data suggests it's not de minimis, that it's
Correct.
not less than 1%, that you can make that number up if you choose. But if you actually look at the data, that's not what the data tells us.
Correct. And more importantly, it's not consistent with Heller.
So following up on that, then there are instances in which Congress could enact a statute if the data supports it. Shelby County being one in which the court invalidated Section 5 of the Voting Rights Act, because it said you don't have that information, that background evidence to show us the numbers and the data is not there. So are you suggesting to us that there's an affirmative here too, because Congress in enacting this particular statute right here did not have this data? Now, we can look at the Boston report and whatever, but none of us are really statisticians and really don't understand. We can take judicial notice of it for some purpose here, but we're not a trial court in that instance in terms of what it all means. We can throw these numbers around and come up with, well, most people who had a gun didn't, without an obliterated number on it, didn't commit a crime. That would lead you to believe, well, don't put in obliterated numbers on the guns. That means the crime's going to go down. That doesn't follow. Doesn't make any sense at all. So are you suggesting at this point that with the situation we have in the data discussion, that perhaps even if we go in your direction, that we could indicate to Congress that you could make this constitutional if you conduct the hearings and information on this that would support the data to support that making this an offense that would be in common use for an unlawful purpose?
No, sir, I'm not. I'm acknowledging with Judge Richardson that the data supports
So
the
even
argument
if the
under
data,
Bruin.
even if data Judge Richardson suggested was 20%, if it turned out to be 80% or 90%, under your view, it doesn't matter.
Because in common use has to do with a functional characteristic. It has to do with, is the gun gonna, what are we using? I mean, think about the
And it
discussion.
doesn't
with
matter,
Miller.
the question of whether for lawful purposes in that analysis doesn't factor in. Just the functionality. It can be for an unlawful purpose, and it's okay as long as it doesn't deal with functionality.
It can be for.
What is the answer to that?
Some are.
That answer to the answer to that question. You understand what I'm going with that? Is
I'm
you
not
it's
saying
functional.
ignore lawful purpose. I'm not saying that at all.
Okay, well then tell me, how does it factor in with an instance in which is common use for an unlawful purpose? and yet it doesn't affect functionality.
What do we have establishing the unlawful purpose beyond the assumption that possessing a gun?
We don't need that if we already can say the functionality kicks it out. My question is, if it is unlawful, does that factor into it, even if it doesn't affect functionality?
It's not unlawful on the basis of the fact you have it without a number. It would be unlawful if you were using it to commit a murder or a crime or a violent offense. And that's going to be case by case.
Let me make sure we're talking the same. Common use for a unlawful purpose, not the gun itself being unlawful, not that. Common use for an unlawful purpose. If it is in common use and the evidence and the data shows people are possessing it for an unlawful purpose, your statement is it does not matter because the functionality is not impacted on the gun.
Going off
Is that
Miller-
true or false?
That's false, Your Honor, for this reason. Because of how Scalia discussed Miller and compartmentalized the discussion to functional characteristics. That's the only reason it's true. All this has been on how the Heller Court decided to frame the issue and how we've had to work with it since. So
Miller's a
the
sawed-off
idea,
shotgun case. We're dealing with a totally different type of issue.
well, yes and no, because the court gleaned the whole analysis from Miller in arguing with Justice Stevens, who said that Miller justified a collectivist view for the militia and got into a discussion of what kind of guns are not protected. You, in the past argument, have focused on short barrel shotguns. Are you familiar with the Shockwave? I didn't brief this. It's not, the Shockwave is manufactured by Mossberg and Remington. It's a 26.3 inch length shotgun with a 14-inch barrel. It's been manufactured and was approved by the ATF in 2017. It looks just like a sawed-off shotgun.
Is it in common use for a lawful purpose?
It sure is, for home defense. And it's selling like hotcakes. I don't have the stats in the brief. I'm briefing it for another case you may see in 6 months or a year. But I was shocked at first. I had to go ask an ATF agent, how the heck is this legal? I had to go ask a gun dealer. It is. So Miller makes that point. That's something we can litigate later. This has to do with the number on a gun and somebody being exposed to 15 years in prison
So
for having the
Lydia,
number.
obliterating serial numbers is in common use for a lawful purpose. That is your statement.
Possessing a firearm, in this case, a 25 caliber pistol, is what is in common use at the time for a law.
Except that's not the criterion for the crime. The crime is possessing a firearm with an obliterated serial number. And that distinguishes it from any other firearm. Now, I suggested earlier in the argument with my questions to counsel whether this is even regulated by the Second Amendment, because the question is, this is sort of a law enforcement tool that exists. It was enacted to help law enforcement, I would think, and it's there and doesn't implicate the right to bear an arm. It says the right to bear, it denies the right to bear an arm that has an obliterated serial number.
But it's still Bruin step one.
Well,
and when we get to Bruin
it
step
might
two,
be step one, but my point is, I agree on that, because step one is, they say in the statute, it's unlimited. It's the regulation has to come under the historical analog.
right, you're just right. And once you get to that,
But then
We're not looking
you're
at the
stuck
normal
with the
burden.
for lawful purpose.
I beg your pardon?
Then you're stuck for, it's not for a lawful purpose to have an obliterated firearm.
Well, again, only because of the 1968 statute.
So what? That
Because
doesn't,
Bruin
you don't need
says-
the analog for that. The analog tells you that unlawful purpose is a right structure. But the fact that it's unlawful and constitutionally unlawful to not have a serial number on,
Your
or have an
Honor,
obliterated serial
if
number.
that's how Bruin worked, then Bruin would not have been decided the way it was, and neither would have Heller. The illegality now is a modern convention in the 20th century. And that's what we're opposing. I mean, yes, it's illegal now. That's why my client's here. That's the only reason I'm speaking to you.
All right, thank you, Mr. Coleman.
Yes, sir. My time's up. I appreciate your.
And then
attention.
some.
I'm sorry.
Yes, sir.
Mr. Glasser?
May it please the court, just a few brief points on rebuttal. The real question that the court needs to decide is whether or not firearms with obliterated, removed, or altered serial numbers are in common use for lawful purposes. Judge Richardson, I apologize, I did not print out the Boston study, so I can't respond in detail to that. But my understanding was that study was of juvenile offenders and the guns that were seized in connection with the juvenile offenders.
Right, but the point of that is, so this is a little bit to Judge Niemeyer's point. You can't say it's for an unlawful purpose when the only unlawful purpose is the outlawing of possession, right? So that's circular, right? That doesn't get you anywhere, right? And so the point there was that of the guns that were seized, right, 20% of those involved obliterated serial numbers, right? And so that's a assortment of guns that were seized. 20% involved obliterated serial numbers. But of those, right, substantive crimes were less likely, those that were used in substantive crimes, instead of mere possession, right, which is circular, to say that that's an unlawful purpose merely because that possession is outlawed doesn't get you anywhere. But those that were used for substantive crime were less likely to have obliterated serial numbers than those that were not used for substantive crimes. And that suggests that your statistics have it backwards, right? Because you want to say, I think, maybe by some sense of logic, that since there's so few used for crimes, there must be even fewer that are used for lawful purposes. But the very study you give us tells us that's exactly backwards.
So, Your Honor, I don't know the explanation for why that study came out as it did. As I think
No,
we
maybe
agreed,
because
surprised.
that's the facts, right? The
You're-
reason it came out that way, perhaps, you submitted it, right? It's not my study, right?
Understood.
You're the one that chose to put it in. In fact, it was the primary study you relied on. The ATF study, you don't bring in until the supplemental reply brief.
Yes,
right?
sir.
So it's the primary study. It finds 20% are, and then of the 20%, it's more likely to have an obliterated serial number if you're not committing a crime.
Your Honor, I just, there's no possible way that it can be the case that firearms with obliterated serial numbers are more common for lawful purposes among the law-abiding population than they are among criminals.
Because why, what possible basis do you have to suggest that? Because the only data that you gave us told us the opposite.
So, Your Honor, again, I don't have the study in front of me. I can't give you the explanation for that result. That certainly seems anomalous. But if I can explain it this way, there is no possible way to measure the sort of exact number of firearms with obliterated serial numbers that are out there today. And the reason is that, first of all, surveys don't work because nobody's going to voluntarily, say that I possess a firearm that's outlawed in 41 states and by the federal government. Secondly, we can't actually find, sort of every gun that, law-abiding or non-law-abiding citizens have. So what we have to do is we have to rely on those guns that are seized from crimes. And again, I take your point that the Boston study you think points in a different direction, but I think common sense, the Third Circuit's decision that backs that up, even the law review article that cites the Boston study that we cite indicates that actually the only reasons for possessing those firearms,
I understand that that's what people say, right? But the data points the other way. Can I ask you one other question? And you may not have the answer to this question either, but the ATF study seems confusing to me. And it may just be that it's a typo, but the fact that there's this kind of typo suggests maybe the ATF study is not worthy relying on. But it indicates I think it's page 39, but it may be later, that there were 365,000 traced crime guns with obliterated serial numbers that were recovered, right? So and yet earlier in the report, it said there were 80,000 that were not able to be traced because of obliterated serial numbers. Those two numbers are obviously massively different, right? And change fundamentally the way of thinking about this, right? And it might be that it refers to hidden serial numbers. It might be that it refers to recovered serial numbers through forensics. But do you have any explanation for why in one place they're suggesting 80,000? And then if you look on page 33, I'm sorry, I had the wrong page.
Sure.
Right? It says, in the last sentence of the paragraph at the very top, similarly, 25%, 365,000 of the trace guns with obliterated serial numbers were recovered.
Your Honor, I'm sorry, do you have part 2 or part 3 of the ATF report?
Part 3,
Okay,
on the line right above the figure 1FC-14.
got
The
it.
sentence begins with similarly, 25%, which is 365,000 of the trace guns with obliterated serial numbers.
Yes, so Your Honor, that sentence talks about the recovery within 3 years of purchase. So that's talking about the time to crime.
Right, but that means there were 365,000 traced crime guns with obliterated serial numbers. You understand? I mean,
Yes,
that means,
yes.
but if we look earlier in the report, I mean, maybe the point is we shouldn't be relying on the ATF for this stuff. But earlier in the report, they say there were only 80,000. Right? So those two numbers both can't be true unless one of them is measuring something odd.
Your Honor, I agree, and I apologize. I don't have an explanation for that. And Your Honor,
Do you have an explanation for any other statistics that you might have submitted that would help us?
Your Honor,
Because the two statistics that you've given us both seem to cut against your position. And I understand you want to rely on common sense and logic, and that's great, but typically we look at actual data.
Your Honor, I don't think the ATF report cuts against us. I think there are some anomalies that I can't explain right here from this lectern in the report, but I don't think it cuts against us because I think
What about this consideration? You're looking at guns and you find out the number without the number on it says, well, only a percentage of these were used. What about all those ones that had the numbers on them? That people kept those numbers on them because there's a law that prohibits you from taking that number off. You're a criminal, and you decide, well, if I take this number off, that's a crime. If they kept my gun, they're gonna have it. So most crimes, if we go with this law as it's going now and end this, why would anybody leave a number on a gun? Even a lawful citizen. If your gun is stolen, that number traces it back to you. Why would I do that? Why would any lawful citizen, if this statute is not constitution, have a gun or any weapon for any reason? If you had any belief that you're not going to commit a crime, but you could leave it someone could pick it up, use it, and it comes back to you where there could be some liability or whatever. So when you look at these statistics here, all well and good as you say, who's going to come up and say, I got a gun without an obliterated number on it? When you see it, you're seeing the obliterated numbers, and that's a tough word to pronounce. You're seeing that number off of there. He says, well, only this percentage was used in crime. But what about that? That's not the point. There's a law that kept you from even having those guns, so the number is suppressed like machine guns. The number is suppressed because we have a law against it. If you say everybody can have a machine gun, you'll probably have a floodgate. And I'd like to know when it's going to happen because they're going to invest in the stock on it when it happens. And so here we got an instance of you got this data here, and maybe, as you said, it's good news because what it's telling you is that we can trace those numbers on the guns for criminals. The guns that are used, most of them have a serial number. And the reason they got a serial number because we have a law that prohibits them from taking it off.
So, Your Honor, I can't speculate exactly as to what law-abiding citizens would do if 922K were not on the books. What I think is clear is that stolen firearms would almost invariably have their serial numbers removed. It would be very difficult to recover stolen firearms because anyone who steals a firearm would have an immediate incentive to file it off because there would be no punishment on the back end for possessing that firearm.
You know, it strikes me that much of what we're discussing about common use and lawful purpose, it strikes me that at bottom, these are empirical questions. And with these data points, they're empirical questions. And the question is, how do we go about accessing the information? And it strikes me that many of these questions that we are debating here might be a proper subject for legislative findings. And what I worry about is that the role of the legislature, the role of the states are being supplanted by these lawsuits, and that legislative findings are being supplanted by judicial findings, which are installing us as the new enactors of a substantive code of firearms regulation. And the question is, where is all this leaving the political branches of our country, the legislature, the national legislature, the various states? Are they just all being read out of the picture by a series of judicial findings? You see what I'm saying?
I do, Your Honor, and I think there's a legislative consensus that has existed for almost a century that these are the kind of firearms that firearms with obliterated serial numbers should be regulated. So states started enacting statutes.
The legislators, they are elected officials. They are in tune with the needs of the people they represent. They know what their fears are. They know what their feelings are, and they're responsive to those constituent concerns. And isn't it a danger to supplant the input that legislatures through their ears and eyes get through the people in a community? Isn't it a danger of supplanting that whole process with a judicially insulated set of findings? Is that where we're going?
Your Honor, I would agree that this court shouldn't strike down a congressional statute for constitutional reasons without compelling reasons to do so. The Supreme Court has said that. Again, there is a legislative consensus. The state amicus brief points out that 41 states have these. Congress has determined since 1938 that the firearms with obliterated serial numbers should not be possessed. And although there have been some minor changes to sort of comply with modern Commerce Clause jurisprudence, that's been Congress's determination since 1938. And that arose in response to the real problem of firearms with obliterated serial numbers being left at crime scenes, similar to the way that Congress responded to machine guns, sawed-off shotguns, et cetera.
But counsel, if we look at Bruin, Bruin tells us how we look at these sort of regulations. And you started with saying that the common usage would be the easiest way for us to address that. And that seems to be the only easy, depending on who we place the burden of proof. I mean, the debate or the discussion you had with Judge Richardson seems to illustrate that. And a lot of people have said that's an easy question. It's just it's a unlimited first look at plain text. And other people have said, well, it includes some historical information. It seems like the answer to that question makes a big difference in this case.
So, Your Honor, I don't think it does, because despite the issues with our statistics that Judge Richardson has pointed out, there's really nothing pointing in the other direction to suggest that firearms with obliterated, removed, or altered serial numbers are in common use for lawful purposes.
You've heard of Mark Twain, right?
Yes.
He's got a quote about your statistics.
Yes, Your Honor. So Judge Quattlebaum, if that's a concern for you, that you can't reach a conclusion based on the facts that you know about common use, then again, we think we have good historical analogs for Section 922K. For example, the laws from Massachusetts and Maine in the early 1800s, immediately after the period of the founding, prohibiting the removal of proof marks from firearm gun barrels.
Thank you, Mr. Glasser.
Thank you.
Judge Richardson stole my closing line. I was going to use it. So with that.
My deep apology, Chief.
You owe me one. I want to thank both counsel for their arguments this morning on these very difficult issues. We'll come down and greet counsel and adjourn for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
President of the United 2017 when everybody knew he was planning to be president of the United States. Do you see that to be a serious problem, Mr.
I
Bobulinski?
do, and I wish this committee would thoroughly investigate it and focus on all the evidence that the SDNY has on CFC. They had FISA warrants, so they were recording conversations, and I wish they disclose all that data and fact to this committee.
Thank you, Mr. Bobulinski. I yield, Mr. Chairman.
Gentlelady yields back. Chair now recognize Mr. Krishnamurti for 5 minutes.
Thank you, Mr. Chair. Mr. Parnas, Rudy Giuliani tasked you with, quote, a mission to travel the globe to find dirt to damage the Biden's reputation in the 2018-2019 timeframe, right?
Correct.
And
Yes.
this was in an effort to secure Trump's
Re-election. bid in
re-election
2020.
as president in 2020, right?
Correct. Yes.
And by dirt, you mean evidence of wrongdoing or criminality, right?
Yes, sir.
And in your travels, you found, quote, precisely zero proof of the Biden's criminality, right?
Correct.
And there was no evidence of the Biden's corruption in Ukraine because, as you said, there truly was none, right?
Correct. Yes, sir.
Now, interestingly, you have looked for dirt around the world about the Bidens and specifically Joe Biden in particular, and you say the FBI, CIA, NSA have all failed to produce any evidence of criminal wrongdoing, right?
Correct.
Not only that, but former Ukrainian President Petro Poroshenko stated, quote, there's not a single word of truth to these allegations about Joe Biden, right?
Absolutely. Yes, sir.
Now, there's a guy named Yuri Lutsenko, who's the former prosecutor general of Ukraine, and he also, quote, confirmed that nothing ties the Bidens to criminal activity in Ukraine, right?
Correct.
And then there's another prosecutor general named Viktor Shokin, who also said he conceded, quote, that he had no evidence that either Joe or Hunter Biden had ever interfered with Ukrainian law, right?
Yes, sir.
And the reason you know this is because you talked to each of these people, right?
Yes, sir.
And your job was to try to dig up dirt or manufacture dirt, right?
Yes, sir.
And yet we have conducted months of hearings, and because there's been no evidence of wrongdoing, you've called this whole impeachment inquiry a, quote, wild goose chase, right?
Yes, sir.
Now, interestingly, we've heard from the other side that, quote, the real quid pro quo wasn't Donald Trump. It was Joe Biden when he tried to hold up foreign aid when he was vice president in exchange for firing the federal prosecutor in Ukraine that was investigating the corruption from his son. Now, you, again, looked for evidence to support this claim. There is no evidence, correct?
Correct. That was false.
In fact, firing the prosecutor would make it more likely that they would go after the company in question, Burisma, not less, right?
Well, the ironic part is the reason why majority of the world and Ukraine and the Obama administration wanted to get rid of Viktor Shokin because he was corrupt, not because he was investigating Burisma, because he was stalling investigations for UK that was looking into a $23 million they wanted to get out from Zlochevsky, and Shokin stalled that investigation.
So it was the logic is just the opposite of what the majority claims is to be the case, namely that they say that somehow Joe Biden was out to fire the prosecutor to reduce the chances of a prosecution of Burisma. But actually in firing that prosecutor, he increased the chances of in prosecuting Burisma, right?
Absolutely correct. Yes.
So let me just talk to you about what some of the other witnesses in this impeachment inquiry have said. Jonathan Turley, the constitutional expert the Republicans brought forward, said there's no evidence of which he was aware to support impeaching the president. You agree with that, correct?
100%.
Garrett Graves, a colleague of ours, said just last week, quote, have I seen anything that is impeachable? No, I haven't. You agree with that statement as well?
Yes, sir.
Last year, our Republican colleague Ken Buck, who's about to retire, said that evidence of wrongdoing by
The United States Court of Appeals for the Ninth Circuit is now in session.
and welcome to San Francisco. This is the time set for oral argument in the case of Virginia Duncan versus Rob Bonta. The parties are ready to proceed. You may come forward.
Good morning, and may it please the court. Mike Mongan for the Attorney General. With the court's permission, I'd like to reserve 5 minutes for rebuttal. The Supreme Court has recognized that not every type of weapon is protected by the Second Amendment, and that certain weapons, like M16s, may be banned. The statute challenged here restricts the capacity of magazines to 10 rounds without putting any limit on the number of lawful magazines or the amount of ammunition that gun owners may possess and use. That statute is constitutional at both stages of Bruin's framework. At the first stage, it's plaintiff's burden to show that large capacity magazines are presumptively protected under the original meaning of the Second Amendment. And that inquiry includes consideration of the objective character of the device and whether it's a self-defense weapon. The record here establishes that large capacity magazines are not self-defense weapons. These are especially dangerous devices that allow an attacker to maximize casualties with a huge volume of rapid and uninterrupted fire.
So which party bears the burden of proof at the first prong of the Bruin test?
I think we're in agreement here, Your Honor. The plaintiffs agree that they carry an initial burden. I think we disagree about what the scope of that burden is. That's consistent with sort of normal standards of civil litigation, and I think it's inherent or implied in the Bruin decision itself, which is quite specific that the government has the burden at the second stage. I think that implies that it's the plaintiff's burden at the first stage, Your Honor.
Counsel,
I'm sorry.
I just was specifically with respect to the question of whether or not LCMs are arms. Who has the burden of proving that?
I think both parties agree that that burden is on the plaintiffs in the first instance, Your Honor.
I was going to ask, why isn't the first step a simple textual step? And the question for us, whether a magazine or a large capacity magazine is an arm at all, or whether it's an accessory or something else.
Sure, Your Honor. I do think that that's part of the first step, but it's not the only part of the first step.
Why don't the other issues belong in the second step?
So, two answers to that, Your Honor, precedent and history. So as a matter of precedent, I think Bruin is quite clear on this. At page 32 of that opinion, it says you have to look at, is this device in common use today for self-defense, before it held at page 33 of the opinion that the plaintiff's proposed conduct was presumptively protected. This circuit's precedent said the same thing. And I believe that the dissenting judges on this panel at the stay stage recognized that common use for self-defense and the dangerous and unusual tradition go at the first stage because they bear on the original meaning of the Second Amendment. And
But how do they bear on whether something is or is not an arm? Which seems to me the sort of going in question, or whether it is an accessory to a firearm.
Right, Your Honor. So I think we do look at the definition of arm, but as Heller and Bruin recognized, the Second Amendment codified a pre-existing right, and it's clear in the Heller decision itself in discussing the founding era conception of that right that it excluded certain types of arms. So I think that the common use for self-defense and dangerous and unusual inquiries are relevant in understanding what the original meaning of that right is.
Well, I'm still not sure you've answered Judge Gruber's question. At least you have. I'm still confused. Second Amendment does not protect non-arms, does it?
Well, I think it does not protect non-arms.
Well, does it protect this?
I think what this circuit has said in Teixeira and other cases is it protects arms and it protects certain other things if they are necessary to the realization of the core right to
fair
self-defense.
enough. So I guess I'm stuck on what Judge Graber was asking you. If we were to determine that a large caliber magazine by itself is not an arm, it's not used to attack anybody else, and it's not necessary for the operation of a semi-automatic weapon, do we have to go further than that?
Your Honor, I don't think you do have to go further than that. That is our argument. I think that it may make sense to go further, as some courts, the Kotek District Court in Oregon, for example, answered that initial question exactly.
Well, sure, we can answer all sorts of questions, but I think what Judge Graber was asking you, at least in my mind, was whether or not that textual analysis requires us to look at history or common understanding or anything else, or whether it just allows us to look at the characteristics of the implement at issue.
I understand and I agree. I think that at that first part of Bruin's first stage, you can look just at the definition of arm.
But I want to be clear about your answer. If we answer at that first part of Bruin's first stage that this is not an arm, need we go any further?
I don't think you need to as a matter of the framework, no. But if you were to answer that it is an arm or falls under that ancillary protection, which is not our argument, then that would bring you to the other considerations, common use for self-defense and dangerous and unusual, which I do think are properly considered part of that first stage.
Dangerous and unusual, as it first appeared, and I think Heller, it said something like dangerous and unusual weapons, which I would have taken to mean dangerous weapons and unusual weapons, not necessarily dangerous and unusual weapons. Has the court backed off that and made clear that it has to be both?
Your Honor, I don't think that the Supreme Court has ever elaborated on that in a way that would suggest that it should be understood in the sort of strict numerical way that my friends have suggested, i.e., their view is no matter how exceedingly dangerous a weapon is, if it is numerically prevalent past a certain point, then it's no longer unusual and it's outside that tradition.
So the common use criteria is really the unusual criteria. Those are the same.
I think they're closely related, Your Honor, but I'm not sure that they're exactly the same. And if I can elaborate, I mean, what Heller was trying to do was to invoke a tradition that was well known and discussed by commentators and treatises at the founding. And so I think it would be a mistake to look at those words dangerous and unusual, or dangerous or unusual, as Blackstone put it.
Dangerous or unusual, exactly. I mean, that's kind of puts a finger on the scale, because and seems to mean and. But instead, the original phrase was a adverbial phrase for a noun, and the and just seemed to me was to say that it amounts to or, but it's not because and is or, it's because this was just a shorthand way of saying dangerous weapons and unusual weapons.
Well, Your Honor, if I can offer two responses. I think even if we were just parsing it sort of linguistically, I don't think it needs to be read or should be read in the conjunctive way that my friends have suggested. But I think the better understanding is that this was meant to refer to a historical tradition. And Heller said that, look, we're not exhaustively covering the history here. So if we today want to understand what dangerous and unusual refers to, we should look to the history. And it was always understood by those founding era treatise writers as referring to especially dangerous weapons. Sometimes, often in fact, the government acted after those weapons had become numerically prevalent, because of course that's when they start to create real world harms. That's exactly what happened, I think, with crossbows, which is one of the leading examples that treatise writers like Sharp were pointing to. These were especially dangerous weapons. They became prevalent in England, and at that point, the king, Henry VIII, decried them and said, now that they're creating real problems within the realm, I'm going to prohibit the possession by most of my subjects. And so I think that that's contrary to the interpretation that's been offered by plaintiffs, and we have to understand the Second Amendment in light of that original conception of the pre-existing right that it codified.
Counsel, as I see it, I think common usage is in both step 1 and step 2 of Bruin. I agree with you that common usage should be taken into account of what is an arm, but do you agree that it also has a place in step 2, where if a state proffers a historical analog that prohibits something that's dangerous or unusual, do we then say, well, if it might have been dangerous or unusual back then, but given that it's common use today, it's not a proper analog? That's what I think Bruin was telling us.
Well, Your Honor, I'm not sure that I would characterize it that way, but I will grant you that especially in a case like this one, where we're dealing with a dramatic new technology and a problem that didn't exist in the relevant historical periods, that you have to have a nuanced understanding of the history. I think if you get to this stage 2, we have a long tradition before and after the founding of governments heavily restricting and sometimes banning especially dangerous weapons. And Bruin teaches that you need to take a nuanced view of that history in a case such as this one. I think that the type of restriction that we're dealing with today falls comfortably within that tradition. And certainly if you proceed to the other questions that Bruin says we have to ask, does it comparably burden the right to self-defense? Is it comparably justified? I think we satisfy those points. I mean, the First Circuit, I think, just addressed this recently, but when you have a law like ours that does not restrict how many magazines, lawful magazines, somebody can carry, it does not restrict the amount of ammunition they can use and possess or how many shots they can fire, it just limits the capacity of a particular magazine. I think that in comparative terms, the burden on the right to self-defense is much less than some of the historical analogs where governments looked at particularly dangerous weapons and banned their possession
Counsel,
altogether.
I have a question about the analogous issue. There is a case in front of the Supreme Court now, Rahimi, that does not concern the nature of the weapon or its accessories, but concerns who can possess firearms, and it deals with domestic violence, as I'm sure you're aware.
Yes.
But in that context, in your view, should we wait for the Supreme Court's opinion on the theory that it might shed light on just how analogous the analogs have to be?
Your Honor, certainly that case addresses some of the aspects of the analogical framework established by Bruin. I think it could shed light on the analysis here. I think we can safely expect that that decision will come down by the end of June. And yes, it may be sensible for this en banc panel to await that decision before finally deciding this appeal, whether that's done informally or through formal abeyance. I would defer to the court. But yes, I think it could shed some light.
Counsel, can I ask a question? You agree that we've already issued a decision in this case in 2022, this en banc court, right?
There was a prior appeal, and that case was decided, yes, and then it was.
And this is a new decision that we're issuing in light of Bruin, correct?
This is a new appeal in the same case or controversy. Your
Okay.
Honor.
And that seems to be the problem with your argument under Section 46 is you only look at the language about case or controversy. But the case or controversy language seems to be a prerequisite, true, but then it says the same panel, senior judges are only able to serve to issue the decision. And as you just acknowledged, this is a new decision. Section 46 does not say senior judges are able to serve on all subsequent decisions in the case. Why doesn't that answer the question about whether this en banc panel has statutory authority?
Sure, Your Honor, and we've studied this closely since the court's briefing order. We do think that the en banc panel's decision and its application of General Order 3.6b is consistent with the broad authority granted by Section 46C. Let me address directly your point about that final clause in, I think, subsection 2 of 46C. I think that that language has to be understood in context. So if we get down there, we're in a case where a majority vote of the active judges has already happened within that case or controversy. An en banc panel has been constituted. And then what subsection 2 says is that a senior judge who was active at the time of that initial vote here in 2021.
That's not what the statute says. The statute doesn't say active at the time. The statute says active at the time that the case was heard or reheard. This is a rehearing of the same, of a prior case. So I think we need to stick to the statutory language and explain to me how this is not a rehearing and why the judges don't need to be active at the time this case is reheard.
Well, Your Honor, I think that just focusing on the text of the statute, it says that the en banc panel shall consist, in this circuit, there's an exception under 92 statute 1633 of a number of judges as prescribed in accordance with that law, except that any senior circuit judge of the circuit shall be eligible, and then to subsection 2, to continue to participate in the decision of a
Isn't
case.
that the point? Continue to participate in the decision. And you just acknowledged that if anybody had taken senior status, and I think they did, before the first decision was taken, that would be covered by the statute. But this is a new decision, as you just acknowledged. So
Could you
how
continue-
can
could you-
senior judges continue?
Could
to
you
serve?
continue with the rest of the subsection 2?
Sure, Your Honor. And with respect, I think I just read this differently, and I'll try and explain how I come at it. So subsection 2, to continue to participate in the decision of a case or controversy that was heard or reheard by the court in bank at a time when such judge was in regular active service. I'd like to address both the decision, the singular that you focused on, and case or controversy. So case or controversy is a term of art. It has broad meaning to extend to the entire adversarial dispute between the parties, not just an appeal. And I think that when Congress says the decision, it's common that there may be multiple decisions or orders or actions in the context of deciding a case or controversy. Indeed, Your Honor, as plaintiffs have noted, in the prior appeal, there were multiple decisions. I don't think it's sensible to read subsection 2 to say that a senior judge only gets one shot to serve on an en banc
No, it's
panel.
not
I have,
one shot. It's till the
excuse me,
decision is
I
final.
have a follow-up question that I'd like to ask, actually, both counsel to answer. Clearly, this is a very important case, and we actually have never taken a case to the full court en banc. But that would appear to be under our general orders the next potential step. What is your view as to whether we ought to do that in this case? And that would moot this issue that has been raised, and it would ensure that whatever decision comes out would reflect accurately the entire court's view.
Your Honor, we haven't taken a position on that. It's certainly an option. If the members of this court thought that was appropriate to consider full court en banc, I would defer to the judgment of the court on that. I think
If we did that, counsel, would the senior judges currently on this panel be able to serve on that full en banc panel?
Your Honor, I don't know. We haven't briefed that.
I think the answer has to be no, because we'd have to take a new vote and they wouldn't be able to serve, which begs the question, how does a limited en banc court get composed of judges who couldn't even sit on the full en banc court? It seems to undermine the entire statutory construction of the en banc process.
So, Your Honor, we haven't briefed that. We weren't asked to brief that. I'm not sure that I read the general orders that way, although, obviously I'm a little bit hesitant to describe your own general.
We don't need to go to the general orders. The statute says the only time that a senior judge can serve on the en banc court is if they were on the 3-judge panel. None of these senior judges were on the 3-judge panel. So if we go to the full en banc court, I don't know what the statutory basis would be, other than just ignoring the statute, to allow the senior judges on this panel to serve on that panel.
Can I ask a question?
Yes, of course.
Why do you say that there was a decision in this case? There wasn't a decision in this case. There was a decision, but it was vacated, so there was no decision. It was then remanded essentially as what we call a limited remand to get some information so we could continue to make a decision. But there was no decision by this panel that actually concluded.
Well, Your Honor, I will grant you that. I guess I was referring to the initial decision, which was vacated, and then the subsequent decision for the
answer to
remand.
whether there's a decision is there hasn't been a decision by this court on this issue.
I guess that could be debated. I guess the point that I'm trying to make as I come afresh to this statute and issue is that I don't think it makes sense to say that by referring to the singular, the decision, that means that only one decision is in play. It's referring to the...
There has not been a decision binding on this court on this case or controversy.
Sure, Your Honor, and I think even if we take that view, the interpretation that I'm advancing, it would still suggest that the en banc panel's decision to keep this case is consistent. And Your Honor, I guess the other point that I would make, I think if you look at the history of the statute, I mean, obviously we have different interpretations of it, but I think what is clear under Western Pacific and other cases is that this was meant as a grant of authority to the circuits to devise policies and procedures that they view as sensible.
Well,
And so
I don't disagree with that. It has certainly expanded what existed in 96. The question is how far it expanded it. And I have a hard time envisioning that Congress sat there and thought that when this comes back from the Supreme Court, if we get reversed again, that we're going to sit here and we're all going to, be these 11 judges are going to be the arbiters of the Second Amendment forevermore in this court. That doesn't make sense. And it seems very inconsistent with how the en banc process was set up. As you acknowledge, it is intended to allow the active judges to set the policy of the court.
Well, Your Honor, I guess if I can just make 2 points,
Sure.
and I do want to make sure that I save some time for the other constitutional questions in this case. I think first, it is envisioned in the statute that the circuit would set policies and procedures. 3.6b has been part of the general orders, but of course the court in its normal procedures could address some of the concerns that have been raised by some members of this en banc panel and change that. We've just been asked to brief the statutory question. And second, Your Honor, I think if you're asking, well, why would the court or why would Congress want to have a scenario where an en banc panel can keep a comeback case? I think that this case is a pretty good illustration of that. I think we understand that there are efficiencies sometimes to have a panel keep a case, and here we've got an appeal arising out of the same motion on the same claims, same parties, substantially similar record.
I would agree with you if case or controversy were the only language, but I think we've probably gone.
Can we go back to the to the first point?
Yes, of course, Your Honor.
Yeah, and this is an interesting question, but I'd like to get back to the merits. So one of the arguments that the plaintiffs make is that these magazines are integral to the operation of a semi-automatic firearm, right? And they also point to California's statute that apparently requires that a user, an owner of such a weapon, has to have a device that allows the magazine to automatically be disconnected. So in that context, why isn't the magazine sort of like entitled to some sort of corollary Second Amendment protection, or why isn't it all sort of fit together?
So, Your Honor, I want to answer that, and then I do want to address some of the objective characteristics that we think are relevant here. So we would agree that for most semi-automatic firearms that accept detachable magazines, they need a magazine in order to function. And so, as this court has recognized in Teixeira and FIOC, that some type of detachable magazine would come within that ancillary protection. I think where we part ways with the plaintiffs is that we think the record here is undisputed that every semi-automatic that can accept a large capacity magazine can also accept a 10-round magazine and function
Can I ask
as
you a question
intended.
about that? Because
Yes, Your Honor.
so the way you're treating magazines, it seems like you could use the same sort of rationale as between a non-semi-automatic firearm, say a lever action or a bolt action or a revolver type action, and a semi-automatic firearm. So I'm trying to figure out if you're saying, well, what we do is we say, have people ever banned particularly dangerous rounds? And now we're saying large capacity magazines are particularly dangerous. Why couldn't that same reasoning be used to ban semi-automatic firearms altogether? To say, because I mean, think about it, like during the Revolutionary War, if the United States had had semi-automatic firearms that only held 5 to 10 rounds, it'd have been about 10 minutes and it would have been over, right? As against muskets. So clearly the semi-automatic mechanism is way, 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 way more particularly dangerous than the difference, the delta between a 10-round magazine and a 15-round magazine. So why does your reasoning not mean that if this reasoning works, why does your reasoning not mean that a state could just ban the semi-automatic firearms altogether?
So if we're just start talking, Your Honor, about this initial sort of textual question, I think if you're dealing with a semi-automatic, that would fit the definition of an arm.
No, but that semi-automatic could be a revolver. Like it could be, I mean, just like this, that high capacity magazine could be a lower capacity magazine.
Right, Your Honor. So I think that would fit the definition of arm, and then you'd move on to the other aspects of the Bruin analysis. At stage one, is a particular weapon that's being addressed by the law in the tradition of dangerous and unusual? Is it in common use for self-defense? And we think Heller is clear that that has to consider the character as well as
I'm not
the
understanding
numbers.
I think I'm missing your response to it seems to me that just as you could say, are you saying that yes, so it would be an arm under, you're not conceding that it would be an arm under stage one. So why are you saying it wouldn't be an arm, but the semi-automatic versus revolver, say, distinction is something that we're stuck with? I mean, you would agree that you can't ban the automatic mechanism.
Well, an automatic mechanism, I think that you can ban. I think the Supreme Court has
No,
recognized
no,
that
the
as
automatic
semi-
mechanism is a term that semi-autos and full autos use an automatic mechanism.
Sure, Your Honor. I'm sorry for the
Yeah.
confusion. No, I don't think that we could ban all semi-automatic weapons. I think Heller makes that clear. The point I was just making is with respect to accessories, I think we have a difference of opinion where my friends suggest any accessory that is somehow helpful to armed
So that's
self-defense.
important because your argument turns on whether you can characterize accessory. So you would say that the revolver versus semi-automatic is not an accessory, but that a magazine is this accessory. So what would you think about like a red dot sight, electro optics, which many firearms are going to electronic optics nowadays. They're obviously an accessory because you could have iron sights. Could you ban those?
Well, so Your Honor, I'm not intimately familiar with that. And I do want to answer this question and make sure that I save time for rebuttal. I think that the question at the outset would be, is that, if it's an accessory, is it within the Teixeira principle that it's necessary to the realization of the right to self-defense? And you'd have to build a record and analyze it in that case.
So counsel, you're saying
Briefly
that
address the history questions on the assumption that this is an arm.
Yes, Your Honor. So we have a long and established tradition in this country, and before and after the founding, that with respect to especially dangerous weapons, those have been heavily regulated and at times banned. And that often comes about after they have become sufficiently prevalent in numerical terms that they start to create real world problems.
So what do you end up doing with the common use notion? I mean, whether it's in the front end or the back end, is your essential answer is that it cannot drive the conclusion, or what exactly?
Right. So I think that
There are lots of these things, okay?
Yes.
So but it seems like they are in common use. Maybe they're not in common use for self-defense. That's one possibility. But what else?
We think that numbers alone are not sufficient, Your Honor, and I think that this follows from Heller. That Heller said you have to examine the character of the weapon, not just the numbers or subjective statements about people's preference. And when it looked at handguns, it actually focused on the objective features of those weapons and what made them helpful in ordinary self-defense situations. And I think it's a fair inference from Heller that with respect to something like a fully automatic machine gun or an M16, the court was inferring that the objective characteristics of those weapons were not self-defense weapons. They made them offensive attack-style weapons that maximize deaths and fatalities and casualties in an attack situation. And I think that that has to be considered because if you just looked at the numbers alone, it would, as the Seventh Circuit has indicated, create some real circular and absurd consequences. I mean, just take machine guns. I still haven't quite heard an answer as to whether my friends think that machine guns are constitutionally protected. Heller said it would be startling to think so. But if we accept their sort of numbers-only approach, I think there's only two possible scenarios. One is they already think that these weapons are protected because by some measures there's 176,000 of them in civilian hands. Or the other alternative is they are not yet protected, but on the cusp of protection. And the only thing that's keeping the federal ban on machine guns constitutional is that ban itself, which prevents more civilians from purchasing machine guns. That is not a sensible way to understand the Second Amendment. It's not consistent with what Bruin did, because Bruin didn't look at numbers when it said that sawed-off shotguns and machine guns can be banned. And it's not consistent with the history, because if you look at the founding era treatises and historical examples, those aren't saying that the ability of the government to regulate or ban especially dangerous weapons just disappears when they become more prevalent in society. Your Honor, I do want to make sure that I have some time to...
Yes, I'll give you some time, but before you step back, let me just ask Judge Ikuda if she has any questions for you.
I do not. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court, Erin Murphy, on behalf of the plaintiffs. Tens of millions of law-abiding citizens across the country keep and bear magazines capable of holding more than 10 rounds for lawful purposes like self-defense. Under the Supreme Court's decisions in Brewer and Heller, that forecloses California's effort to ban them because the court has been emphatic that our tradition is one of protecting the right to possess arms that are in common use today. The state's efforts to resist that conclusion are fundamentally incompatible with what Heller instructs and Bruin instructs are the definition of the term arms and the historical tradition about what kinds of arms the state may ban consistent with the
Is
Second
your
Amendment.
position that the number of these that are out there now is the answer? That's simply once there is past a certain number, whatever that number is, they're in common use and you cannot ban them. Is that your ultimate conclusion, no matter what else may be true?
They have to be commonly possessed by a common number of people for lawful purposes like self-defense. So there is
Like self-defense or for self-defense?
The language of Heller is like self-defense. So self-defense certainly counts.
But I thought self-defense was the whole premise of the Second Amendment protection.
Yeah, and I'm happy to, I think here it doesn't really matter whether you can go beyond self-defense because these magazines are just unquestionably in use for self-defense in the manner that Heller contemplated and Bruin after it, because Heller analyzes that question in terms of whether something is typically possessed by law-abiding citizens for the lawful purpose
So
of
if the
self-defense.
Brady bill had remained in effect and there were the number of these weapons, of these magazines had atrophied and they were no longer in common use, then they would have lost their protection?
No, I don't think that's right because I think that law was unconstitutional when it was passed. And if you take something that's already in common use.
Somebody had passed a national law in the 1930s, that would have been the end of it?
No, I think that if you look historically at how this actually worked with respect to machine guns, it's a great example. Machine guns didn't come on the market until 1921, and people didn't really want them. The state's own expert talks about how the company that made them was only able to sell about a third of them, and within 4 years, states were banning them all over the country. And by the time the federal government came along in 1934, more than half the states had already enacted bans or severe restrictions. And I think that goes to show that this idea that there's no content to the common use test is belied by history. People actually do make decisions about what comes on the market. And when that came on the market, the widespread reaction throughout the country was, this is different than the semi-automatic firearms that have already been on the market for 40 years. We can articulate what is different about this technology.
Counsel, what's your response to your friend's argument that there's, I think 700,000 machine gun licenses out there in the world right now? That seems like a pretty big number.
It's a decently big number. I mean, obviously it's bigger than the number Justice Alito talked about in Catano. We don't have any real analysis of the manner of the kind of typical use question there. How many of them are really owned more as kind of a novelty or something that can only be used under very, very strict circumstances at particular places, as opposed to actually being kept and used by people for self-defense. Nobody's tried to make a record on that.
So, counsel, it sounds like you're agreeing that common use is connected to self-defense. It's not just that they're common in number, but they're commonly used for self-defense. So, and there is a record about that, and there's evidence about that.
So I think the state and I have a fundamental disagreement about what use means when it comes to use for self-defense. Heller speaks of use as possession. It ties use to the concept of the Second Amendment itself, which the Second Amendment itself doesn't protect the right to engage in self-defense. That exists independent of the Second Amendment. The Second Amendment protects the right to keep and bear arms,
right?
To have them at the ready
well,
for self-defense.
Yes. So if someone is trying to attack your home and you are holding a semi-automatic weapon with a magazine of 10 rounds and someone else's home they're holding a magazine with 20 rounds, in terms of how the intruder visualizes that deterrent, how is that any different? Do you understand my question? In other words, merely carrying the weapon with a magazine in it, ready to fire, is the deterrent. I don't think the intruder is looking at the number and counting them out.
I mean-
So why isn't it equally usable for self-defense with a 10-round magazine?
Well, I don't think that's the relevant legal question, is whether it's equally usable. It's an arm if it's usable at all, and it's in common use if you're keeping and possessing, if you're keeping and carrying it for self-defense, to be ready to engage in self-defense. If you tried to have a
But
test,
it isn't the size of the magazine that makes it a deterrent.
it
It's
may or
the
may not be.
existence, isn't it?
I mean, it all depends on the circumstances. It could make a big difference in some circumstances.
Counsel, if
to have
that's
a
the
larger
analysis,
magazine.
why wouldn't you be able to ban semi-automatics? Because as long as somebody has a revolver, I'd say you're pretty scary if somebody's trying to break into your house.
And I think the problem gets even more significant than that, because as we know from the studies that are in the record, I mean, there's about 1.65 million self-defense incidents a year. In more than 80% of them, no firearm is fired at all. And so if all that counted was, that you actually fire a certain number of rounds at somebody, I mean, once you even get inside that 18%, it's a very small number that involves rifles. And once you take out the semi-automatic rifles that California thinks are not covered by the Second Amendment anyway, I think you end up having to follow that train of logic to say that non-semi-automatic rifles aren't commonly used enough to be covered by the Second Amendment, which cannot be consistent with Heller and
Counsel, does
Brewer.
it matter how dangerous and unusual it is, in your view?
If it's dangerous and unusual at the historical tradition test, that necessarily contemplates it's not in common use today. I mean, that's what unusual means, not in common use. The court specifically contrasts the language when talking about dangerous and unusual of in common use as opposed to highly unusual in society at large.
So, I want to make sure I understand. Are you saying dangerous and unusual together, or dangerous and or unusual?
So I think Justice Alito's right that it's a conjunctive test, dangerous and unusual. It has to be both of those things.
And do you have any other?
That's not, as I said before, where this language generated from. The language generated as a adjective for weapon, and it essentially meant, or could easily have meant, dangerous weapons and unusual weapons.
Sure, but I do think we have to take what the Supreme Court has said about it. And
That's
the
what I
Supreme
said.
Court,
Yeah.
the Supreme Court has articulated, when the Supreme Court talks about the dangerous and unusual test, it contrasts the concept of in common use today with highly unusual in
I
society at
understand
large.
that's the unusual part, but it doesn't mean it has to be dangerous, both dangerous and unusual.
I don't
Now,
see.
is there anything in the Supreme Court opinions that says that?
Well, what the Supreme Court said, I mean, it was critical to the holding of Heller that the court said that the state cannot ban arms that are in common use today. That had to be resolved because there was a debate in the
You're
case.
not standing on the notion that it has to be both dangerous and unusual.
Yes, in order to be banned, it has to be dangerous and unusual.
But what's your authority for that? I'm trying to figure out what the authority is for that, because from what I can tell, besides Justice Alito's concurrence in Cetano, I'm looking for some other authority. Do you have it?
Sure. I mean, the Supreme Court didn't address specifically that question of whether it's a conjunctive test in Heller and Bruin, but the language that they use when they're describing the tradition, what they say is we derive from the tradition of the ability to ban arms that are dangerous and unusual, that you can't ban arms that are in common use at the time. That's the principle they're deriving from the tradition. And so the way the court is understanding the tradition is, even if they might be dangerous, if they're in common use today, you cannot prohibit them. Now, I would also happily talk about the problem is, even if you didn't think that question was already answered, the state would need to demonstrate a historical tradition that justifies banning arms that are in common use today. And they just haven't done that work.
Counsel, I would like to ask you the same question I asked opposing counsel. Should we await the Supreme Court's decision in Rahimi, which may further illuminate just how analogous an analog has to be instructive in this context?
So I don't think it's necessary in this case because
I didn't say necessary. Is it a good idea?
Here's why I don't think it would be as useful in this particular case as in others, because we believe that the Supreme Court has already told us what the historical tradition is when it comes to the ability to ban arms. And that's not a question that's going to be addressed in Rahimi. And because the court has already said what the
But,
tradition
but there is considerable uncertainty, at least in my view, as to just how similar a historic practice has to be for it to translate to the current day. And domestic violence, it seems to me, would raise that question also, because I don't know that we had those laws, at the founding, and we do now. So wouldn't it illuminate at all this issue of how close the analogy has to be?
I think it could illuminate that. The sole point I was trying to make is our position in this case is that you don't actually need to get to go look at analogs, because we believe the Supreme Court has already done that work and told the courts what the historical tradition is when it comes.
So are you saying this historical tradition comes in at step one?
No.
So let me just pose a hypothetical for you. Let's assume it was 1965 and the California legislature, in an unusual burst of prescience, enacted the same legislation we now have in front of us when large caliber magazines were not in common use.
Yeah.
Would that be okay?
So I would say no, and here's why, because
what I'm having trouble with is, it seems to me that a constitutional act can't become unconstitutional by virtue of subsequent common use. So I'm trying to figure out why common use
Yeah.
solves both problems.
And
for you.
I'd like to make 2 points. I mean, first, just on that very specific point, I mean, Bruin pretty much says the opposite. Bruin says even if this 1860 or 1686 New Jersey ban on pistols really was a ban and was permissible because they were dangerous and unusual then, that wouldn't make the law
let's go back to
constitutional
let's
today.
go back to machine.
But
Let's
to
go back to
your-
machine guns to make the question easier.
Well, actually,
Answer
so
the
on
que-
your 1965 question, here's why I would say that that's still unconstitutional. In order for the state to come in and ban something that's new, that isn't,
It's not in common use.
It's not in common use just by virtue of it being new. I think the dangerous and unusual test is best understood as the state also has to show that what it's banning is materially different in some way that makes it unusually dangerous vis-a-vis the arms that are already in common use today. And so if, all the arms only had 10-round magazines because no one could figure out how to make 11, and tomorrow, someone figures out how to make 11, I don't think that means the state can just come in and say, well, 11's higher than 10, so we'll ban them immediately. No one can ever have them. They need to demonstrate that an arm with a magazine that holds 11 rounds is actually somehow meaningfully different from
So
an arm that holds 10.
if machine guns today became in common use for self-defense, would the congressional ban of them become unconstitutional?
If we actually had some movement to lift all the machine gun
No,
bans.
I'm not just talking about any movement.
Well, there has to be, though.
There are
because-
700,000 machine guns legally possessed in the country today. There's the capacity for many more people to get them because they can be licensed to get them.
Well,
So-
actually, at this point, that you really can't. I mean, it's really.
Okay,
pretty
so what if
much
those
impossible
700,000
more.
people commonly use them for self-defense? Would the statute become unconstitutional
I think
because,
then it-
no, let me finish because of subsequent use of self-defense, common use?
As I read the specific statement in Bruin, when they say, even if handguns were dangerous and unusual in 1686, they're not today, and what matters whether they're in common use today, that is what the court said. They were confronting that very question and saying, if something actually becomes in common use that didn't used to be, it does become protected. Now, I think there's a reason this is a
Counsel,
hypothetical. These bans have
Can
been
I
in place
ask,
for a century.
according to your briefing, sorry, can I ask a question? According to your briefing, as I read it, common usage is only applied in step 2 of Bruin. Is that right? Because I think I might disagree with that. I think it seems like Bruin says that common usage could be used in the definition of what's an arm, and it could be used in whether or not it's a proper analogy to historical legislation.
I don't think that's right,
Okay.
because the court speaks very specifically about the definition of arms.
Yes.
And the first test is just plain text, and the court's definition of arms, just as its definition of bear didn't admit of any distinction between public and private carry, its definition of arms, which is just something you can pick up and use for self-defense, doesn't admit of any distinction between how commonly something is used for self-defense.
But then if you
But as a historical matter, the only arm protected by the right is those that are not dangerous and
that's-
unusual and in common use,
And
right?
that, I
So why
think-
wouldn't it go into what's the definition of arm?
Because I think at that point, you're baking the historical tradition into the front end of the analysis. The court instead, if you look at when Bruin is articulating how to do historical tradition, it talks a few times about the dangerous and unusual test. And it specifically says, I mean, it uses the phrase historical tradition to refer to that repeatedly. It says, we found it fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons, that the Second Amendment protects the arms that are in common use today. It then goes on later and says, drawing from this historical tradition, we explain that the Second Amendment protects the arms that are in common use today.
It's a very strange historical tradition that changes depending on what people's personal choices are over time. That doesn't sound like history or tradition. It sounds like people's contemporary decision-making.
With respect, I disagree. I mean, the reason I think the court was able to coherently say what it said about the 1686 law versus today is the historical tradition is the principle, the rule of law that arms that are in common use today are protected. The application of that rule of law to the facts of today may have different consequences than it did 100 years ago or
What about all
200 years
the
ago.
Bowie knife statutes, which I gather were pretty prevalent when the knives were pretty prevalent?
Here's the problem with the Bowie knife statutes. There are not possession bans. They are the way that states regulated in response to concerns about Bowie knives was concealed carry laws. And many of those are the same concealed carry laws that by their terms also apply to pistols and handguns. And
This
pistols
is
and
not a
rifles.
possession ban of an arm either. It's a possession ban of an accessory, isn't it?
No, we do not agree that this is an accessory. A magazine is a functional component of a firearm.
But a large capacity one is not. A 10-round one will make all of the, according to what I understand from this record, it is almost universally true that a weapon that will take a large capacity magazine also will take a 10-round magazine.
I'm happy to accept that because I don't believe the test is essential. It's a functional component. Just because a magazine is it's what actively feeds the ammunition into the firing chamber so that the firearm can fire. Pretty much all firearms, ever since we got past one shot, have some sort of ammunition.
Well,
feeding
they all
device.
have ammunition too, but we have bans on certain types of ammunition. For example, you normally can't hunt in certain areas with lead shots and hollow point bullets and that sort of thing. And it's required for it to be a firearm, but it doesn't mean, does it, that there's no regulation?
Well, for purposes of this discussion, I think we're just talking about the threshold textual inquiry of whether something qualifies as an arm. Of course, you'd then have a historical tradition analysis of the regulation, but a magazine doesn't cease being a functional component of the firearm just because it has 15 rounds instead of 10.
What about an ammunition belt?
It's still, it's an actively
So-
functioning
so,
part
Sam,
of.
let's assume that you're right, that there's no historical tradition of regulating this sort of thing. So is it your position that an ammunition belt that held several hundred rounds of ammunition
Probably
could not be banned by the state?
No, I think it probably could because as a practical matter, you're going to have, at a certain point, types of ammunition feeding devices are not in common use because they're impractical. People can't actually bear them and use
Well,
them.
but under your answer to my previous question, as long as people started buying them today and bought enough of them between now and the time the state banned them, it would be okay.
As a legal matter, yes, but I think there's a reason. These are always hypothetical questions. These types of technology exist, yet people don't choose to arm themselves with grenades. Like, people don't all have 100-round drums that are super cumbersome and tend to jam a lot. People tend to make reasonable choices. Technology has been around for 100 years that people don't choose to keep and use in their homes for self-defense. So it's all well and good to talk about a hypothetical world where they don't, but.
My understanding is that one reason that these larger magazines are so prevalent is because when you buy the gun, it comes with those magazines. So people aren't making choices necessarily, they're just getting them.
That's only accounts for some of it, because typically people, I mean, if you look at the study by Professor English, typically people have more than one magazine, so they're making choices about what additional magazines to get. And there are firearms where you could ask for it to be in a smaller round, or you could purchase a different firearm, but people choose.
It appears that the marketing has a lot to do with these choices.
I don't think that's really
Is that generally true, that marketing will have a lot to do with the choices?
I mean, marketing has something to do with the choices, but they can't, the manufacturers can't force people to go out and buy AR-15 rifles. People choose to buy them, and part of the reason they choose to buy them is because in states that don't have restrictions like California's, they come with 15 or 30 round magazines, and people want that to defend themselves in their homes. Same with many of the popular handguns on the market today. Many of the most popular ones, people choose them because they have higher capacity, not magazines, not in spite of the fact that they do. But I also think, if you look at Professor English's study where he's looking at also people buying additional magazines, and people can buy different things, and this is what people, given the freedom that they have in most of this country to make their own choices about what they want for self-defense, I mean, roughly half the magazines that people purchase in this country, well over 100 million, are magazines that are unlawful under this law. And I don't think at that point you can really dispute that those numbers, wherever the limit, the cutoff is for common use, when you're talking about something hundreds of millions owned by tens of millions of people for the purpose of keeping them in their homes for the lawful purpose of self-defense, I don't see how you can really dispute that that satisfies common use. And in a sense, I don't think the state really does. It just wants to change the meaning of use
So,
and not focus
counsel,
on any of that evidence.
So going back to the dangerous and unusual, trying to decouple that. If we decoupled it, then you get rid of the unusual, I guess, and then you get into the just dangerous. But of course, every firearm is dangerous, so it seems to me like you'd have to have some threshold of dangerousness. And I'm struggling to think of how that's done in a way that doesn't involve some sort of balancing that starts to feel like the test that the Supreme Court threw out in Bruin. So can you speak to that? It seems like if you're going to decide that a certain type of firearm is too dangerous, say a semi-automatic, right? And a revolver is not too dangerous, even though both are dangerous. And the state is going to have to say why the one is dangerous enough to satisfy their view of how Second Amendment scrutiny works. And that starts to feel just like the same old balancing we used to do in the bad old days.
I think that is the problem with trying to focus on it independent from common use and say that even things that are being commonly used are too dangerous for the people to have. The other thing that is particularly problematic about the argument that's being urged here is, for the most part, the state is not arguing that these are unusually dangerous in the hands of law-abiding citizens. Its argument is that they're unusually dangerous in the hands of people who want to commit mass murder and other horrific acts. But every firearm is incredibly dangerous in the hands of someone who wants to misuse it.
Yeah, so under
you
that sort of
take that
analysis,
logic, and I don't know what's
right.
left.
So under that sort of analysis, assuming that these horrible mass shootings went down, but crime went way up, it seems like you could rely on that as making just regular firearms.
And I think it's quite notable that if you go back to Heller, I mean, these aren't new arguments. These are the arguments that were being made in Heller. There were even amicus briefs there making the argument that one of the reasons handguns shouldn't be protected is because handguns are the weapon of choice for people who want to commit mass murder. And of course, much of the case was focused on criminal use. And the Supreme Court didn't deny any of that. It didn't say you're wrong. We don't think you've made a good record that people use handguns for criminal purposes. It said the Second Amendment has struck a different balance, and
Counsel,
it takes
can-
off the
can
table
we-
arms bans.
Can we turn attention to the jurisdictional question?
Absolutely.
So as I understand your briefing, the case, you argue that this is a new case or controversy, mainly because there's a new case number. That's somewhat unsatisfying as a cutoff. How did you get to that definition?
I think that really what the dialogue that was occurring earlier about the decision, the hearing and the decision is key to it all. The
But
statute,
there wasn't any decision.
there was a decision. This
It
court
was
issued-
vacated by the Supreme Court, so.
Was no, this panel does not have, or this court does not have a final decision on the question of whether this California statute is valid or not valid.
That is certainly correct, but that doesn't mean this court didn't issue a decision. This case came back to this panel. This panel debated whether to decide it on the merits. We actually urged the panel to decide it on the merits.
Did you urge us, did you tell us that we didn't have jurisdiction?
We didn't think you did, we're lacking jurisdiction at that point.
But isn't the answer to that the mandate hasn't had.
The mandate had.
So we
there
could
was-
have,
and
we
there
could
was-
have decided it coming back.
Well, I can take it in order. So there wasn't a once there was a GVR, there was no decision because the court vacated the decision. And so at that point, the hearing is still pending with no decision. But then this court issued, I absolutely appreciate that this court chose not to decide the case on the merits. But this court.
So had we simply retained jurisdiction and remanded rather than giving it a new appellate number, would the answer be different?
I don't think it would have been consistent with Rule 46, Section 46C for the court to do that.
We often do that when we send something back to a district court.
I appreciate that, but I do think in the context of Section 46C, since it contemplates that all decisions about whether to have a hearing en banc need to be made by active judges.
It was long ago. That's what we issued in 2021. But let me ask you the same question I asked opposing counsel. What is your view on whether this should, due to its importance and to your concerns about whether we ought to hear it as a limited en banc, whether this should be a full court decision?
I mean, I certainly enjoy participating in the first ever full en banc sitting, but I don't know why the court has to go to that step.
I didn't say we had to. I'm asking your view as to whether it's a good idea.
It seems to me the logical course would be to start with the ordinary procedures of take a full court vote.
That sounds a lot like judge shopping. If you had a full court en banc, you would get by definition the real view of this entire court about this question. Why isn't that a good idea?
I mean, it's perfectly fine and it's the prerogative of this court. I've just happened, as a historical matter, the court has never done that and gone straight to that. And so I would think in the ordinary course, I wouldn't consider it judge shopping. I would just consider it following this court's ordinary procedures to start with the 11-judge panel.
If we were to have another vote of the active judges and they voted to take it on bank, would this be the panel or would it be a different panel?
No, I think you'd have to have a new panel.
Why is that?
For one, I mean, I think that the voting contemplates that then you have a new panel, but I do think that independent of the issue about the vote, the final clause of the second sentence of the statute precludes the active judge, the senior judges from participating in the hearing because the senior judges can only participate in the decision if they were active when the case was heard.
Of a case or controversy, there hasn't been a decision of the case or controversy.
There is.
It wasn't heard. No, there hasn't been.
But
there might have been a decision on, well, there wasn't a decision on the last appeal. We just remanded it. But even if you consider that a decision, there wasn't a decision on the case or controversy, which is what started in the district court and is still ongoing.
I don't think that conception of case or controversy really fits with all the rest of the text in subsection in 46C, because the statute doesn't just speak of case or controversies in the abstract. It talks about how cases or controversies shall be heard and determined by this court. And then it tethers throughout the statute the notion of a hearing and a decision, and even the first provision that talks about when senior judges can participate because they were in a panel, an earlier panel. It contemplates that you're reviewing a particular decision. It has to be a decision that's under review that they participated in.
But let me take you to the last part of the sentence, which nobody's talked about yet. It says the decision of a case or controversy that was heard or reheard by the court in an en banc at the time when people were not yet senior. So your position is that that final language only when, and it says reheard, heard or reheard, you're fine. So obviously something has happened before under that language. That case or controversy was heard or reheard by the court before. And what you're saying is that language only applies if that prior panel never reached a decision?
Correct. I think it ties together a hearing and a decision. The statute clearly
So
contemplates.
if we had held on to this case pending Bruin, the panel would be the appropriate panel.
Look,
would
I
it not?
think that would have
Yes.
been
Yes.
a circumvention of the rule.
Let's assume that we knew Bruin was pending. And so we said, we're just going to sit on this case until Bruin is decided. The case had not been, would we be okay to hear it, wouldn't we?
I mean, if you hadn't issued a decision and a mandate, like we'd have a different argument here. I still tend to think the better reading of the statute is, unless you're doing like an actual limited remand in the sense that we need you to answer one other question because it's critical to our ability to
That's
decide
basically
anything.
what we did. That is what we did.
No, that's not at all what we did. We
court
sent it
vacated
back
and-
to decide the whole case again.
Why do you think this is unusual? We've been doing it this way for over a quarter of a century in countless cases. Senior judges stay on after a remand, either from the Supreme Court or from the district court.
Not on an
good
en banc panel. I
no,
totally disagree with the premise of the
well,
question.
let me go on. Let's take one of our more recent Second Amendment cases, Young versus Hawaii. We remanded it. There was a new decision, and two senior judges remained on that panel. In fact, Senior Judge Bybee wrote the majority opinion, and Senior Judge O'Scanlan wrote the dissent. We've been doing it this way for 25 years. I can give you countless examples of that where we've remanded to the district court. It's come back, and even though somebody's taken senior, in the interim, we hear the case with the senior judge.
It's worth noting that Judge O'Scanlan was on the 3-judge panel in Young. So with all due
I
respect
do
to
recall
Judge
that.
Thomas.
I do recall that. I would simply note,
Well,
we
you take
were asked to
DNC
brief-
versus Hobbs. I mean, DNC versus Reagan, where he was not on the panel.
We-
And it came back 2 years later and it was seated. So,
The question for us is that we were asked by this court to
Yeah, I
brief
know.
is whether this
We
is
asked you.
consistent with the statute, whether this court has been violating the statute for a long time or just once.
and
I
every
don't
other circuit
know,
does it the same
but
way. Every
reading the
other circuit
statute-
does it the same way.
Well, every other circuit,
Yeah.
I mean, this court obviously has a very different dynamic, given
I'm
that
sorry, did you
this
say
court-
every other circuit what?
No other circuit has the same dynamic that this circuit has of not having all active judges participate in en banc proceedings.
Right, we have a limited en banc, but in terms of where the case goes back, who hears it, and whether senior judges stay on it, every other circuit does it pretty much the same way.
Every other circuit doesn't do it our way.
Judge
That's
Nelson,
the point.
Judge Nelson, I'm sorry, you can ask the question, but I think it was
I'm
asking a
responding
question.
to a statement by
Right.
another panel
We
member
can
that's
do that
not
at
accurate.
We have had a difficult time finding that there's any rule or anything that contemplates that that would be the way that the way this court operates is how it would operate in other circuits. But of course, it doesn't really come up quite the same way.
Well, but it does come up in other circuits. My recollection, and I must admit that it's dim, is that the Second Circuit, although it sits totally en banc, if a judge was on the panel, he sits on the en banc panel. And then when the cases came back to that, they came back to the same panel, including the senior judge. I mean, I may be wrong. I may be wrong about that.
I will note that the language with respect to kind of the hearing and decision and all that, it's different in the provision that deals with a judge who was on the 3-judge panel. That provision that says a 3-judge panel, a judge who was on the 3-judge panel may participate, it doesn't speak about like being active at any particular time.
It seems unfair in a Second Amendment case to make you spend 10 minutes on this, but we made the
I
other.
find it fascinating.
We
so
made
it's
the other
fine.
side spend 10 minutes on it. But I'm interested. So you think that there's a different, so let's assume a judge was on the 3-judge panel and by virtue of that was on the en banc court. And then exactly the same thing happened. Your view is that judge would be able to serve.
So I think the best reading in that circumstance is that they can't, because their decision is no longer under review when you get to the comeback case. But if their decision still is under review, if they stay on, it goes back to a 3-judge panel and all that. But that first provision specifically ties it to the decision that's being reviewed. So, it just is going to depend a little bit on the factual circumstances. But the second provision very specifically ties it to being active when the hearing takes place. And this case is being heard en banc right now.
Let me ask Judge Ikuda, do you have any questions for counsel?
Thank you.
Thank you very much.
Thank you.
So we went over, so I'll give you 5 minutes total.
Thank you, Chief Judge Murguia. I'll try not to use all that time. I'd just like to make 3 quick points about the Second Amendment. Understanding of the Second Amendment that you've heard from plaintiffs today and in their briefs can't be squared with precedent, and it's not supported by history. So first point, in plaintiff's view, at the first stage of Bruin, anything that fits their definition of the word arm is presumptively protected by the Second Amendment without any other consideration of objective characteristics or dangerousness. So we're not just talking about large capacity magazines, mind you, but M16s, sawed-off shotguns, hand grenades, all presumptively protected. But Bruin is clear on this point at pages 32 to 33 of the opinion that a plaintiff at least has to satisfy the common use for self-defense inquiry before any weapon is presumptively protected. And Heller said you have to examine the character of the weapon and whether it's a self-defense weapon, and that certain types of weapons like M16s are not eligible for protection. That's based on history and the original public meaning of the Second Amendment, which codified a pre-existing right that plainly excluded certain types of weapons. Second, at stage 2, plaintiff's view is that the only question that a court can ask is the number of a particular device that's possessed today by civilians in states that don't prohibit it. And if that number exceeds a certain threshold, then the device is categorically protected, and every state law banning it suddenly becomes unconstitutional. Again, without any history, my friend said, without any consideration of history or objective characteristics. And I'd note, I think it's very surprising, since this is sort of the sole determinative factor that plaintiffs point to, that they haven't said what that threshold is or even how a court would go about determining it. But what they've suggested in the past is that maybe it's around 200,000, which would mean if 1 in every 1,600 Americans possess this device, it would satisfy their test. Your Honors, if that were the law, then the Supreme Court absolutely would have considered the numbers of sawed-off shotguns and M16s before it announced that those weapons are unprotected and may be banned. And if the focus really is on history, then plaintiffs would need to identify some historical evidence supporting their view that the government may only ban exceedingly dangerous weapons when those weapons are exceedingly rare, and that those bans somehow become impermissible when the weapons become sufficiently prevalent that they start to create actual real-world problems. Your Honors, the actual history from before and after the founding shows exactly the opposite, that especially dangerous weapons and devices were heavily regulated and banned after they became numerically prevalent. And my last point, I think...
What is your best example of that?
Well, Your Honor, I think that if you want to look before the founding, you can look at crossbows. If you want to look after the founding in the kind of relevant early 19th century period, slingshots and Bowie knives are prime examples. And the last point I'd just quickly make, perhaps because of their choice of how to argue this case, you haven't heard much of anything from my friends in their briefs or today about sort of the actual characteristics and dangerousness of large capacity magazines.
Doesn't that go into the how and why analysis by which trigger, which informs our understanding of what regulation is relevantly similar? I haven't heard any of that discussion here today.
Sure, Your Honor. I'm happy to address that in the time that I have remaining. I mean,
but it seems to me very relevant to, because there is no regulation on point. So we have to look to regulations that are relevantly similar. And doesn't that require us to look at how and why these weapons are actually used?
I think that it does, and take a nuanced approach, because we're dealing with a dramatically new technology and unprecedented societal concern. And if we look back at the historical precursors, we see a number of instances over time where governments have regulated heavily or banned the possession of particular types of weapons or devices that are especially dangerous and pose a dire threat to public safety.
That's why the numbers, the sheer raw numbers, is not really that relevant in terms of the Bruin analysis.
I don't think it's sufficient, Your Honor. I think that Heller talked about numbers and subjective preferences, but it didn't make that the only thing that a court has to look to. I see that my time is up, and with that, Your Honors, we'd ask the court to reverse the district court's judgment and remand for entry of judgment in favor of the Attorney General. Thank you.
Mr. Mongan and Ms. Murphy, thank you so much for your helpful oral arguments today. This is obviously a very significant case for us, and we appreciate the answers to all the different questions that were presented. Thank you very much. We are adjourned.
All right.
If Hunter Biden were here, we would be able to ask him some questions, maybe clear this up. But he's not. He's not here. And what's interesting is that just yesterday, Peter Navarro reported to federal prison in Miami for 4 months for not showing up in front of the January 6th committee. And I want to point out to everybody that the January 6th committee was procedurally defective under House rules. It was procedurally defective because the minority leader did not get to appoint members to that committee. The United States House of Representatives Oversight and Accountability Committee is a procedurally perfect committee. And we have authority to subpoena Hunter Biden, and he has to show up. He has to answer these questions, and he has to tell the world that his father didn't leverage U.S. foreign policy so he would get $3 million. This is no different than what Senator Menendez did. And look, the American people are not buying this nonsense y'all are selling. We must restore their faith in our institutions. And we have to stop this ridiculous two-tiered system of justice where the Department of Justice persecutes President Trump and hides Hunter Biden behind every corner. I mean, this is not the United States of America that the American people deserve. And we have to get our country back on track. With that, Mr. Chairman, I yield back.
Mr. Chairman, parliamentary inquiry. Did the committee subpoena Hunter Biden today?
Chair recognizes pursuant to the previous order and at the request of the minority witness, the chair declares the committee in recess for 10 minutes. Then we're going to come back in here and then we may have to recess again for votes.
Good job. We're all saying the same thing, just a little different.
Agreed. Now Democrats say, how dare Republicans investigate Joe Biden? How dare they look into the money, the business, and the brand? Millions of dollars, as the chairman said, millions of dollars from foreign entities run through 20 different companies for what? 20 different companies for what? Devin Archer told us what it was for. Access to the brand. And the brand was Joe Biden. The brand that played rounds of golf, took calls and meetings, attended lunches and dinners with Hunter Biden and his business partners. The brand that conditioned $1 billion of American tax money on the firing of the prosecutor pressuring the company Hunter Biden sat on the board of. And oh, by the way, was getting paid $1 million a year. Today, we're going to learn more about that brand. We're going to learn more about what Mr. Galanis called the Biden lift. We'll learn about the plausible deniability that Jim Biden talked to Mr. Bobulinski about. And we'll hear about the statement, the rule that governed how the business operated around Joe Biden. The rule that said, say it, forget it, write it, regret it. So I want to thank our witnesses for coming here today. They, like the whistleblowers who came to the Ways and Means Committee, are doing it simply because they want the American people to have the truth. I yield back.
Gentleman yields back. Chair now recognizes the ranking member for 12 minutes for his opening statement.
Mr. Chairman, thank you very kindly. With any luck, today marks the end of perhaps the most spectacular failure in the history of congressional investigations, the effort to find a high crime or misdemeanor committed by Joe Biden and then to impeach him for it. In prior hilarious episodes of this long-running madcap series, America got to see the following. One, nearly 20 fact witnesses who could not identify a single act of wrongdoing by President Biden, much less a high crime and misdemeanor, and who overwhelmingly testified that Biden was not involved in any of his family's business adventures. Two, 3 expert witnesses called by the majority itself who said nothing that they had seen in the tens of thousands of pages of documents adduced by the majority even remotely approached the level of a high crime and misdemeanor. Bank records which show exactly what all the witnesses told us, that Joe Biden was not involved in his family members' businesses. Repeated voyeuristic displays of pornographic images by the majority, completely irrelevant to any conceivable legislative or investigative purpose. A star witness, Gal Luft, who turned out to be a Chinese agent and an illegal arms trafficker on the run from American justice, and the key piece of evidence which launched the entire zany goose chase, an FD 1023 form in which the FBI duly recorded a completely fictional tip about a $5 million bribe to Vice President Biden, peddled by Alex Smirnoff, who has been criminally indicted by a Trump-appointed U.S. attorney, Special Counsel David Weiss, for felony counts of systematically lying to the FBI and constructing a false record about Joe Biden, and now sits in jail in California as a flight risk while the world studies his longstanding and extensive ties to Russian intelligence. Today, the good chairman and his ace MAGA detectives have finally jumped the shark. The comedy of errors comes crashing to an end as House Republicans in more than a dozen Biden districts beg for mercy, and the committee throws a flabby Hail Mary pass 3 weeks after the Super Bowl's over. So today, we revisit the fruitless testimony of 2 more fading star witnesses who have failed to testify to any presidential wrongdoing, much less evidence of high crimes and misdemeanors. Both of the majority witnesses are frustrated would-be business partners of Hunter Biden, who tried to leverage the Biden name, or the Biden brand, as they keep calling it. But they never got any business off the ground for reasons that will become painfully obvious to anyone watching the proceedings today. Even Hunter Biden, laboring at the time under a serious substance abuse addiction, could tell these were not the type of people he should be doing business with. So rather than representing the Biden brand, which was their ardent wish, they now show up today as loyal servants of Trump world, each of them proudly represented by their very own former Trump White House attorney. The first is Mr. Bobulinski, the bitterly disappointed wannabe Hunter business partner whose famously litigious history includes unsuccessfully suing his own dying father's charity for nearly $1 million. And just last month, suing Cassidy Hutchinson for $10 million after she reported that Mr. Bobulinski, wearing a ski mask, met with Mark Meadows, which Ms. Hutchinson has now backed up with actual documentary photographic evidence, something in very short supply in this investigation. Mr. Bobulinski made his hazy allegations against the Bidens public for the first time at a press conference choreographed by the Trump for President campaign, which provided him a venue, a gaggle of journalists, and even a dress shirt that they went out and bought for him to wear to the event. Hours later, Mr. Bobulinski joined the second 2020 presidential debate as Donald Trump's personal guest, where he was seated with Kid Rock and Mark Meadows. The other star witness, Mr. Galanis, who I believe is appearing by Zoom today, is a serial fraudster and convicted con man, a term I would charitably not use on a witness, except it was explicitly bestowed upon him by not one, but 2 different U.S. federal district court judges, including the one who sentenced him to over 15 years in prison for defrauding union pension funds, a Native American tribe, and scores of innocent investors. Mr. Galanis was sentenced to pay restitution of over $80 million to his victims. That's a lot of money. That's what Donald Trump was sentenced to pay E. Jean Carroll for in that civil litigation. The very first record of Mr. Galanis's claims against the Biden family appeared, check this out, in the clemency petition that he sent from prison to President Trump. But the key point is this: even if we were to believe every single word offered by these utterly compromised and biased witnesses, Mr. Bobulinski, Mr. Galanis, their allegations don't identify any wrongdoing, much less an impeachable offense by President Biden. With the impeachment bus running on empty, our GO colleagues now are apparently preparing to save face by ending the impeachment farce with criminal referrals. But criminal referrals require evidence of crimes. And the only crimes we have seen are those of the GOP's own star witnesses, like Russian asset Alex Smirnov, Chinese agent Gal Luft, Devin Archer, and Jason Galanis. The minority witness today, our witness, Lev Parnas, casts a piercing light on what's really taking place here. And Mr. Parnas has reason to know. He too used to be a mega sycophant peddling lies and disinformation to smear Joe Biden. Today, he joins a long line of self-exiles from Trump world who could no longer stomach all the corruption and deceit. People like Cassidy Hutchinson, people like Michael Cohen, Sarah Matthews, Alyssa Griffin, General James Mattis, the chair of the Joint Chiefs of Staff, Mark Milley, General John Kelly, and now Vice President Mike Pence, who refuses to endorse for president the man he served with. But we do have loyal sycophants still in the room, and one day I look forward to hearing their testimony about how they got sunk into this religious cult. Mr. Parnas wrote Chairman Comer and me a remarkable letter on July 23rd, 2023. This is the first time I'm meeting him today. He was Rudy Giuliani's right-hand man, his globe-trotting business partner and language interpreter in the mission to manufacture Ukraine and Burisma-related dirt and smears against Joe Biden in 2018 and 2019. He spent all of his time traveling around the world trying to stage evidence against Joe Biden. In his letter, Parnas explains that the desperate search to find evidence of any kind of Biden corruption was a complete and total bust because there was no evidence to find. He wrote to tell us that not only is there no evidence in Ukraine that Joe Biden did anything improper, but more darkly, the manic search for a smoking gun against Biden became a mission to invent and concoct evidence out of thin air with the active help of Russian intelligence assets and agents. A man, I'm getting to Russia. You haven't heard anything yet, Mr. Chairman. A man who has reckoned with his own moral descent into Trump world. Lev Parnas is ashamed of what he did to serve the interests of Russian propaganda and Putin's lies. And he wants America to know the truth. He can explain how the Russian-stimulated conspiracy theories and lies that he promoted with Rudy Giuliani live on in the tiresome fabrication spread by Alex Smirnov and now repeated by this committee like Pavlov's dog. At every turn, my colleagues cry Russia hoax, even in the face of repeated warnings from Donald Trump's own Treasury Secretary and Secretary of State, from the intelligence community, from Robert Mueller, and most recently from Special Counsel Weiss, who was named to office by Donald Trump. As Secretary Mnuchin stated, quote, Russian disinformation campaigns targeting American citizens are a threat to our democracy. That's Secretary Mnuchin, someone that you guys usually defend, but my GOP colleagues continue to cry Russia hoax like cult members selling flowers at the airport. Our colleagues are the ones loyally amplifying the actual Russian hoax not the Russia hoax, the Russian hoax, the one that Giuliani and Trump and Smirnov have eagerly adopted from Putin and his agents. They participate in this hoax while they shamefully block $60 billion in military assistance to President Zelensky and the besieged Ukrainian people 5 years after Trump and Giuliani tried to shake President Zelensky down for counterfeit dirt on Joe Biden. And while they continue to parrot these transparent Russian lies, Vladimir Putin wages his bloody aggressive war on Ukraine filled with atrocities like the mass kidnapping of children and the rape and slaughter of civilians. The MAGA right's wholesale adoption of this Russian hoax and their sellout of the Ukrainian people by the MAGA right is an historic betrayal of democracy, freedom, and the rule of law. But the defense of democracy begins with fidelity to the truth and the oversight Democrats, America's truth squad against this disinformation, is here today to set the record straight. I yield back to you, Mr. Chairman.
I would now like to introduce our witnesses. Mr. Tony Bobulinski. Mr. Bobulinski was a business partner of Hunter Biden in a joint venture between a Chinese energy entity, CEFC. Mr. Bobulinski sat for a transcribed interview with the committee on February 13th, 2024. Mr. Lev Parnas. Mr. Parnas was not a business associate of the Biden family. Mr. Parnas is an entrepreneur, a political activist, and an author. And Mr. Jason Galanis. Mr. Galanis was a business partner of Hunter Biden. Mr. Galanis sat for a transcribed interview with this committee on February 23rd, 2024. We asked the Bureau of Prisons to make him available in person today. They would only provide Mr. Galanis for virtual testimony. Notably, Mr. Galanis applied for CARES Act home confinement, and after a lengthy approval process, was approved for home confinement on June 9th, 2023. On June 12th, 2023, I issued a subpoena to Devin Archer for testimony. On the following day, June 13th, 2023, Mr. Galanis' approval was reversed as a result of Department of Justice's intervention. So Mr. Galanis has remained in a federal prison facility. He is currently in Montgomery, Alabama. Mr. Galanis, can you please state for the record who else is in the room with you?
Yes, Chairman, my counsel and advisor, Mark Paletta, and Nicholas Wise.
Thank you. Pursuant to Committee Rule 9G, the witnesses will please stand and raise their right hands. Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. Thank you. You all may be seated. We appreciate you all being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statements and they will appear in full in the hearing record. Please limit your oral statements to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. And when the red light comes on, your 5 minutes is expired, and we would ask that you would please wrap it up as quickly as possible. I now recognize Mr. Bobulinski for his opening statement.
Should I allow Hunter to give his opening statement first?
Doesn't appear Mr. Biden showed up for his public hearing, so we'll recognize you, Mr. Bobulinski.
Okay. Thank you, Mr. Chairman. Chairman, ranking members, and members of Congress, good morning. Thank you for this opportunity to speak with you and present my truthful testimony to the American people. I sit here today under oath for one reason and one reason only. The American people deserve to hear the truth. Though the truth involving the deep corruption of the Biden family, including the malfeasance of the sitting president of the United States, might be raw and unpleasant, the American people must hear it. You're presented here today with two narratives in this investigation. A false one being pushed by Joe Biden, a serial liar and fabulous, now under this impeachment investigation for public corruption. His brother, Jim Biden, a 75-year-old man who can't keep his lies straight, including under oath. And his son, Hunter Biden, a chronic drug addict facing 2 indictments with 12 counts. You also have before you the truth, confirmed by multiple Biden family business partners over many years and backed up by mountains of irrefutable evidence, including text messages, emails, documents, recordings. I am the only Biden family business partner with an impeccable military record. I'm grateful that this country has given me the freedom to be successful. I worked hard to become independently wealthy. I've taken several businesses public, sold multiple businesses to some of the world's best private equity firms. In fact, my business success is why they sought me out. However, what they have done is repugnant to me. I am here today because I'm a patriot and I'm a truth teller. We keep hearing from certain corners that our democracy is at risk and democracy is on the ballot in 24. Yet the same people preaching this mantra know better. They continue to lie directly to the American people without hesitation and remorse. Rep. Dan Goldman and Jamie Raskin, both lawyers, and Mr. Goldman, a former prosecutor with the SDNY from New York, will continue to lie today in this hearing and then go straight to the media to tell more lies. Hunter Biden's defense attorney, Abby Lowell, weaponizes letters to Congress to try to smear my name
Mr.
and
Chairman.
misstate the cold hard facts
Mr. Chairman.
in an attempt to save his powerfully connected client
Wait.
and his father. I challenge Mr. Lowell to make those claims on national television so he can be held accountable for his lies. Prior to my successful business career, I was an officer in the United States Navy. At Navy's Elite Naval Nuclear Power Training Command, I later served as the command's chief technology officer.
Please proceed. I apologize for the disruption from the.
Okay. Am I supposed to say it's my time, Mr. Raskin?
Yeah. But please, Mr. Bobulinski, please
Okay.
come to order. Mr. Bobulinski, please
I'm sorry.
proceed.
Okay.
Please proceed. I apologize for the disruption from the minority.
Okay.
Well, Mr. Chairman, it saved his time, but he called members of this committee liars, and I just want to know whether the order and decorum requirements of House Rule 11 apply to witnesses appearing before the committee. Does it apply or does it not?
Should I address? I don't.
There's decorum from the members. We've asked for that. There's no language that I'm aware of pertaining to a witness.
Thank you.
So don't make sure we didn't waste any of his time on the opening statement. Mr. Bobulinski, I'm sorry for the disruption. Please continue your opening
Yeah,
statement.
I think Mr. Raskin used.
We'll make sure it's right. We'll
Oh,
make sure.
okay, great. I just want to restate, make sure the American people hear all these facts. Abby Lowell weaponizes letters to Congress to try to smear my name and misstate the cold hard facts in an attempt to save his powerfully connected client and his father. I challenge Mr. Lowell to make those claims on national television so he can be held accountable for his lies. Prior to my successful business career, I was an officer for over 6 years in the United States Navy's Elite Naval Nuclear Power Training Command as a decorated master training specialist. I later served as the commander's chief technology officer, where I held a huge security clearance from the Department of Energy and the NSA. When I left Nuclear Power Training Command, I was the #1 ranked direct input officer in the entire command. And then I jumped into the business world and public markets. While I have made a few contributions over the years to Democrats, such as Representative Ro Khanna, I don't see him, but I hope he shows up today. He sits on the Democratic side of the Oversight Committee. I'm not a political person. I come from a family with a long history of distinguished service in our nation's military, including my father, both of my grandfathers, and my brother, all of whom were willing to sacrifice their lives for this great country. My sister serves our military vets for 2 decades at the Veterans Administration. We've lived our life as a family in service to this great country. I hope the American people will pay close attention to this hearing. I also hope they will understand that some members of this committee will engage in absurd attacks and efforts to try to deflect attention from the facts. And I will present today by questioning my integrity and my patriotic duty. You may see me speak passionately at this hearing, but for good reason. Not only was I willing to die for this country, every single male member of my immediate family was willing to die for this country. I want to be crystal clear. From my direct personal experience and what I've subsequently come to learn, it is clear to me that Joe Biden was the brand being sold by the Biden family. His family's foreign influence peddling operation from China to Ukraine and elsewhere sold out to foreign actors who are seeking to gain influence and access to Joe Biden and the United States government. Joe Biden was more than a participant in and a beneficiary of his family's business. He was an active, aware enabler who met with business associates such as myself to further the business, despite being buffered by a complex scheme to maintain plausible deniability. I ask this big question. If there's no evidence of corruption here today, if Joe's conduct and the conduct of his family were fully legal and proper, then why are they so dishonest about it? Not just slight misrepresentations of fact, but deep untruths about the entire corrupt enterprise. Hunter Biden gave his transcribed interview on February 28th and lied throughout his testimony. Here's just one egregious example of Hunter's perjury. He lied to the committee on important details concerning his money demands and threats to CFC in text messages on July 30th and 31st, 2017. He leveraged his father's presence next to him in that infamous text to strong-arm CFC to paying Hunter immediately. Jim Biden also lied extensively throughout his transcribed interview on February 21st and perjured himself. An example of that, on page 100 of his transcript, Jim is asked specifically, do you recall having a meeting with Hunter Biden, Tony Bobulinski, and Joe Biden? Jim's response, absolutely not. The committee was so shocked by his perjury that they asked him the same question multiple times. Each time he denied meeting with me and Joe Biden. After the committee showed him text messages confirming that I met with Joe Biden, Hunter Biden, and Jim Biden at the Beverly Hilton in May 2017, Jim Biden, with a former U.S. attorney lawyer sitting next to him, still denied that meeting took place. Hunter Biden, in his own transcribed interview, confirmed that that meeting took place. Hunter confirmed his uncle perjured himself in front of this committee. I'm simply here to tell the truth to the American people, and I hope each and every one of you, congressmen and women, give me the opportunity to do that instead of focusing on Russia or smearing my family's name or focusing on facts that are irrelevant today. I yield back.
Thank you.
Mr. Chairman, parliamentary inquiry?
Yes.
Just 2 points. One is, I believe Mr. Bobulinski went over 2 minutes, 14 seconds. I hope the same courtesy will be
We will
extended.
give Mr. Parnas equal time.
Thank you.
that we gave
And
Mr.
secondly, I see that we now have a witness appearing remotely, and I thought that witnesses were required to appear in person under the rules adopted by the majority at the beginning of the Congress. And do we have a new practice with respect to that rule? Because I know that members on our side were denied the ability to participate in hearings that were conducted in Florida and Mississippi and Alabama. We wanted to participate by Zoom. So I hope.
And I'll answer that. It
Yeah.
requires to be able to testify remotely requires a letter from me and an approval from the majority leader, which we have. And I'll enter that
Good.
letter into the record without objection.
Thank you, Mr. Chairman. I hope we'll extend the same courtesy to members of this committee when they can't get to a hearing as in Mississippi or Florida. Thank you much.
Mr. Chairman, parliamentary inquiry.
State your point.
Mr. Chairman, Mr. Bobulinski just referred to text messages that I believe he is referring to photos of a BlackBerry.
What's your parliamentary inquiry? State your parliamentary inquiry, because we've got a very important hearing here and we don't have time for stunts. What's your parliamentary inquiry?
It's not a
Mr.
stunt. It's I'm simply asking that Mr. Bobulinski.
You don't have a parliamentary inquiry. Chair now recognizes Mr. Parnas for
Mr.
equal
Chairman, does
time.
the committee have
Mr. Chairman,
possession
Chair
of text
recognizes
messages
Mr. Parnas.
Does the committee have the text messages that Mr. Bobulinski?
Mr. Chairman, we don't have time for games
all right,
by
listen.
Democrats today.
We have important witnesses here. This is a credible.
I'm asking a question about the important
You asked for a parliamentary inquiry. You will have 5 minutes whenever Jamie Raskins tells me it's your time to speak. Mr. Parnas, the chair recognizes you for equal time that Mr. Bobulinski had, which was 7 minutes.
Thank you. Hello. Honorable members of Congress, Chairman Comer, Ranking Member Raskin, and members of the Oversight Committee. I am humbled and thankful before you to show up before you today. I came to the United States from Odessa, Ukraine in 1976 when it was still the former Soviet Union. My mother and father and sister and I had left the Soviet Union, escaping anti-Semitism and persecution. While in Rome en route to Israel, my sister and I won the most important opportunity that we have ever been given. We won a U.S. green card lottery. My family came here with literally no more than shirts on our back and the hopes of rebuilding our lives in the land of freedom. I say this to you because I love this country. From shortly after my arrest on October 9, 2019 to now, I have been trying to share the irrefutable truth with you. The American people have been lied to by Donald Trump, Rudy Giuliani, and various cohorts of individuals in government and media positions. They created falsehoods to serve their own interests, knowing it would undermine the strength of our nation. From November 2018 to October 2019, I was a key participant and a witness to numerous efforts to prove that Joe and Hunter Biden were linked to corruption in Ukraine. Rudy Giuliani, on behalf of then President Donald Trump, tasked me with a mission to travel the globe, finding dirt on the Bidens so that an array of networks could spread misinformation about them, thus securing the 2020 election for Donald J. Trump. Ironically, when I was arrested, my original indictment linked me to an individual referred to as unindicted co-conspirator 1. We now know this individual to be Congressman Pete Sessions, who sits on this very committee today. Today, I ask you to consider the following. In nearly a year traveling the world and interviewing officials in different countries, I found precisely zero evidence of the Biden's corruption in Ukraine. No credible source has ever provided proof of criminal activity, not the FBI, CIA, nor the NSA. No respectable Ukrainian official has ever said that the Bidens did anything illegal, including former President Poroshenko and former Prosecutor General Yuri Lutsenko. Even when CEO of Burisma, Mykola Zlochevsky, was offered a deal by Rudy Giuliani in exchange for information on the Bidens, he provided none, because there is none. The only information ever pushed on the Bidens in Ukraine has come from one source, and one source only: Russia and Russian agents. The impeachment proceedings that bring us here now are predicated on false information spread by the Kremlin. Everyone involved knew they were sharing lies. From Trump and Giuliani's shadow diplomacy, through my missions to Ukraine and elsewhere, to members of a BLT team, a group convened for the sole purpose of investigating and damaging the Bidens. Everything was for the ultimate benefit of Donald Trump and thereby Vladimir Putin. Because the team's investigations were centered around Biden and Ukraine, I was designated the point person in every matter they pursued. That is how I know with certainty that these Biden stories are untrue then and are untrue now. Congressman Pete Sessions, then Congressman Devin Nunes, Senator Ron Johnson, and many others understood they were pushing a false narrative. The same goes for John Solomon, Sean Hannity, and media personnel, particularly at Fox News, who used this narrative to manipulate the public ahead of the 2020 elections. Sadly, they are still doing this today as we approach the 2024 elections. We cannot separate this conspiracy from the Russian-Ukraine war because Trump has no intention to keep aiding Ukraine. Without the support of the United States and NATO, millions in Ukraine will suffer and die. If we allow Russia to defeat Ukraine, eventually that suffering will reach American shores. Today, I admit my own wrongdoings. I have been a convicted federal election campaign and fraud crimes and served my sentence. I do not hide that from reality. It is part of my truth. Despite rigorous attempts by those in power to silence me, I will be silenced no longer. Thank you to the committee for allowing me to speak. I look forward to answering any and all of your questions.
Thank you. Chair now recognizes Mr. Galanis for his opening statement.
Chairman Comer, Ranking Member Raskin, and members of the committee, my name is Jason Galanis. I was a business partner of Hunter Biden and Devin Archer, among others, during the years of 2014-2015. Our business included the acquisition of 85-year-old Wall Street firm Burnham & Company, the $1.5 billion surviving division of Drexel Burnham Lambert. Our objective was to build a diversified private equity platform, which would be anchored by globally known Wall Street brand together with a globally known political name, Biden. Our goal, that is Hunter Biden, Devin Archer, and me, was to make billions, not millions. The entire value add of Hunter Biden to our business was his family name and his access to his father, Vice President Joe Biden. In 2014, we believed that the Burnham enterprise would be significantly enhanced by forming a partnership with Harvest Fund Management, a $300 billion Chinese financial service company closely connected to the Chinese Communist Party. This effort was led by Hunter Biden's contact with Henry Zhao, the Harvest chairman. Mr. Zhao was interested in this partnership because of the game-changing value add of the Biden family, including Joe Biden, who was to be a member of the Burnham Harvest team post-vice presidency. My lawyers provided the committee a drafted email dated August 23rd, 2014, drafted for Hunter Biden that reflects this understanding. It states, and I quote, "Michael, please also remind Henry Zhao of our conversation about a board seat for a certain relation of mine. Devin and I golfed with that relation earlier this week, and we discussed this very idea. And as always, he remains very, very keen on the opportunity," end quote. I'm certain that this phrase, a certain relation of mine, refers to Vice President Biden. Devin told me about this golf course conversation shortly after it happened. Ultimately, this paragraph was deleted from the final version, with Hunter following our general rule of thumb on business deals: say it, forget it, write it, regret it. Further to that, I recall being with Hunter Biden and Devin Archer at the Peninsula Bar in New York, where Hunter took a call from his father and told him things were going well with Henry Zhao and Harvest, and that he might need a little help getting across the finish line. It was not the only time I heard Hunter speak with his father for business reasons. I was present when Hunter called his father on May 4th, 2014 on a cell phone, put it on speaker mode to have him say hello to Yelena Baturina, a Russian oligarch and an investor in Rosemont projects, and her husband, Yuri Luskov, the former mayor of Moscow. Devin Archer was also there. Hunter said, "Well, I'm here with our friends. I told you we're coming to town, and we wanted to say hello." The vice president said hello, some pleasantries, and I hope you had safe travels, and then said, quote, "Okay, you be good to my boy." Hunter responded by saying, "Everything is good, and we are moving ahead." The vice president said something about, quote, "being helpful," and Hunter ended the call by saying he was going to call his father later. Before this call, Hunter sat next to Yelena Baturina at a table, and I heard him speaking on business matters generally. A few days after this May 4th party, an email my lawyer provided to this committee shows that Devin had confirmed Ms. Baturina was committed to a, quote, hard order of $10 to $20 million in a Burnham investment banking client. In an effort to build this financial platform, I engaged in unlawful conduct. Our companies were entrusted with $11 billion of union pension fund money, whose trust I betrayed. I pleaded guilty. I've had 8 years in federal custody to reflect on my actions. I'm profoundly sorry for committing these crimes. I deserve the lengthy sentence I received. Nevertheless, as I set out more fully in my full statement, I believe the SDNY prosecutors did not indict Hunter Biden on the same deal for political reasons, despite then available documentation that we were partners, were involved in decision-making that involved illegal self-dealing, and all of us had financially benefited from these schemes. In fact, Hunter Biden and Devin Archer's company, Rosemont Seneca Bohai, received $15 million from the tribal bonds fraudulent scheme to be invested in the Burnham Group. I've offered to slide this information to the government about Hunter Biden's crimes, but the prosecutors have been uninterested. And my request for commutation I filed in DOJ in December 2020 did provide information about Hunter's culpability. The DOJ has retaliated against me and vigorously objected to my being placed in home confinement pursuant to the CARES Act. I applied for home confinement on February 4th, 2023, and I was approved on June 9th. On June 12th, this committee issued a subpoena for Devin Archer, and the BOP reversed my approval on June 13th, with the SDNY prosecutors strongly objecting to my release. I've been appealing this reversal, and with each stage, the BOP reason for my denial has changed. During this period, the period beginning in January 2023, I was sexually assaulted by a member of the prison staff at FPC Pensacola. He persisted in sexually harassing me for many months thereafter. I had hoped to receive home confinement, which would remove me from danger. My judgment was clouded by the shame I felt for not being able to prevent the attacks. I was well aware, as inmates, all inmates are, that the Bureau of Prisons had a horrible record on these matters. I believe my disclosure would have made things worse for me. Unfortunately, the sexual harassment continued until early August when the prison correctional officer's comments became more threatening. I feared for my safety. I decided to seek counseling from Chaplain Dixon the next day on August 10, 2023. The chaplain was visibly upset by the events and asked to bring in Warden Salisbury, who quickly opened a PREA investigation, which is a reference to the Prison Rape Elimination Act passed by Congress. After further debriefings, I was immediately escorted to a vehicle and driven by senior staff hours to FPC Montgomery, a separate facility. I'm grateful the committee has opened up an investigation of these matters, and I appreciate Chairman Jordan and Palmer and Subcommittee Chairman Biggs signing the letter. I believe I've been a victim of a pattern of retribution by the Department of Justice. I believe I'm putting myself at grave risk within the BOP for providing information on these matters concerning the president and his son. I've been treated professionally at Montgomery. I want to thank Case Manager Coordinator Anthony Barnes and Warden Randy Keys for their help in facilitating access to my attorney prior to this interview.
Thank you, Mr. Galanis, and I want to thank all the witnesses again for being here today. We will now begin the questions, and I want to remind members on both sides of the aisle, each member has 5 minutes. I'm going to adhere to that and hit the gavel. If the question has been asked, then we'll allow the witnesses time to respond. But we are going to try to get in a lot of questions from a lot of members, and I will begin the questioning, followed by Ranking Member Raskins. Again, Mr. Bobulinski, thank you for your service to our country, your military service. Appreciate you being here. During the 118th Congress, this committee has investigated Joe Biden's involvement in his family's influence peddling schemes around the world. So let's start with that. Mr. Bobulinski, was Joe Biden involved with any of your business dealings with Hunter Biden and James Biden? Was Joe Biden involved in his family's attempts to sell their access to him? You set out a form to form a legitimate business. You set out to form a legitimate business with the Bidens. Did you come to find out that the Biden family had no interest in doing real business?
I did.
Mr. Galanis, are you aware of any times Hunter Biden used Joe Biden with Joe Biden's knowledge to benefit their business associates?
Yes.
Which business associates?
Yelena Baturina, Russian oligarch, testified about Russian, Chinese, Chinese fund manager, Henry Zhao, and Nikolai Zlochevsky, a Ukrainian oligarch, oil and gas oligarch.
Okay. Now that we've established that Joe Biden was involved in his family's business dealings, I'd like to turn to the financial records we've subpoenaed. One major point my Democrat colleagues downplay is how much money the Bidens accumulated from foreign business ventures in such a short period of time. We have over $24 million to the Biden family and their business associates from 2014, while Joe Biden was vice president, to 2019. Mr. Bobulinski, there came a time when you were attempting to raise $10 million from the Chinese to pursue an actual business deal, a real business deal. But it wouldn't be correct to say this was a $10 million deal, would it? What did the Bidens conceive of the business with the Chinese becoming?
The Chinese were committing to deploying billions of dollars in infrastructure projects here in the United States as well as around the world.
Mr. Galanis, what was the financial goal you, Mr. Archer, and Hunter Biden set out to achieve? Was it millions of dollars or billions of dollars?
Billions of dollars.
Billions with a B.
Yes, billions.
Now I'd like to turn to some of the statements Joe Biden has made during his presidency about the findings of this investigation. Mr. Bobulinski, Joe Biden has said he never interacted with his family's business associates. Did he meet with you?
He did.
In fact, are you aware that Joe Biden also met with...
I'm sorry, Mr. Chairman, he did
yes, go ahead.
multiple times.
Several, okay. Are you aware that Joe Biden also met with Rob Walker, Eric Sherwin, and Devin Archer too?
I'm generally aware of it.
Mr. Galanis, as you discussed earlier regarding Yelena Baturina, the Russian oligarch, you were present for Hunter Biden calling his then vice president father with the Russian oligarch, Yelena Baturina, present, correct?
That's correct.
You also were present for Hunter Biden's conversation with his father about a board seat on a Chinese company board. Is that correct?
I was present for a call when Chinese transactions discussed, yes.
So, Mr. Galanis, isn't it true that when Joe Biden said he didn't interact with his family's business associates, that's not true, is it?
I believe it would be misleading to the point of being an untruth.
I want to touch on the fact about the absent seat in the middle. Hunter Biden has chosen not to attend today's proceedings. I've given Mr. Biden exactly what he asked for before his deposition. It's clear that Hunter Biden knows his testimony would not withstand public scrutiny. Joe Biden has not been truthful about his participation in schemes to sell access and influence. And today's witnesses will show the American people a side of the story that the president and his allies on this side of the aisle are eager to hide. Mr. Bobulinski, can you tell us about your meeting at the Beverly Hilton with Joe Biden?
The short version or a long version?
Long version, but within a minute.
Okay. So Hunter Biden, Jim Biden, and Joe Biden were in Los Angeles for a variety of business discussions. Joe was there to speak at the Milken Conference in May of 2017. I had lunch with Hunter Biden at the Chateau Marmont, and he had asked me to meet with his father that night. He set up a meeting at the Beverly Hilton where they hold the Milken Conference, and I got there a bit early and sat with Jim Biden, Hunter Biden, and we're just talking about what we were doing with the Chinese and the legal documents I was working through. And they had sort of coached me before Joe showed up to listen, we're going to just keep things at a very high level. We're not going to go into a lot of details in this meeting. And I just remember that discussion generally because it just struck me as odd, honestly. Joe wasn't in the White House then, that they were sort of framing it that way. And then Joe showed up, walked through the lobby of the Beverly Hilton Hotel. I stood up to shake his hand, and we sat down and spent 45 minutes to an hour going through my background.
You met with him that long?
Yes. This wasn't a handshake, a 2-second discussion about the weather. This was a 45-minute long meeting to an hour where we talked about a lot of stuff.
Very good. Thank you. Chair now recognizes Ranking Member Raskin for his questions.
But we're actually going to go to Mr. Garcia to begin.
Great, thank you very much. And thank you again. I just want to, just for the record, be very clear that in Mr. Bobulinski's testimony, he has provided zero evidence of any sort of link between Hunter Biden and the president as far as it relates to the business dealings. And so once again, we're back to a hearing where no evidence is being provided of any sort of wrongdoing by the president. But I want to go back,
that's a
Mr.
blatant
Bobulinski,
lie.
actually it's my time, sir. Mr. Bobulinski, I want to go back to the private deposition that we had. I was one of a handful of Democrats in that private, on the record, under oath conversation we had. And during that deposition, I asked you a question of which you gave a false answer to, and I want to go back to that. I asked you specifically who got you into the presidential debate that was attended by you and others, and that, of course, was a huge moment in that campaign, and you could not recall. In fact, you said, quote, "I do not recall who got me into the debate." Do you remember telling me that, sir?
You were playing semantics, trying to ask me as if somebody called me directly and gave me a ticket like I was going to a movie
I
theater.
asked you, I asked you,
told you
I'm going to
that
reclaim
my
my time,
lawyers
sir. I'm
ordered
going to
me
reclaim my time. What I
Well,
said
you
was,
just asked me a question, Mr.
I'm reclaiming my time. Thank you, sir. What I asked you was, do you recall who actually got you into the presidential debate? You actually said, quote, "I do not recall who got me into the debate." You did not remember who got you into the debate between President Biden and between Joe Biden and Donald Trump.
That's
not
a true statement.
Sir, you quoted, "I don't recall who got me into the debate." It's on page 102 of the transcript.
You did not
Sir,
ask me
I asked
whether
you
I
that
was
question.
a guest of Mr.
Thank
Biden
you. I'll
or a
reclaim my
guest
time.
of-
I'm not asking you a question right now. Thank you very much, sir. In fact, here, as was shown by Ranking Member Raskin, we know that you were in the debate actually sitting adjacent and next to Trump officials. When we were confronted again on this same question, Mr. Bobulinski, if you were a guest of Mr. Trump's at the debate, you responded and you quoted, once the Wall Street Journal called you out, quote, "Is the Wall Street Journal God or something? Like you act like this is some encyclopedia of fact." And you refuse to still confirm that you were a guest of Donald Trump. So I want to ask you one more time, sir, Were you a guest of Donald Trump at the presidential debate?
Mr. Garcia, those were not the questions you asked me in my transcribed interview.
Wow.
You were trying
Were you,
to ask
answer the question, sir. Were you a guest of Donald Trump?
Of Donald Trump at the gate or at the debate.
You were.
That was obvious to everyone in the world at that point.
Oh, it's interesting.
You were asking me semantic.
Thank you, sir. So you were a guest. That you answered the question, because at the time you said in the transcript under oath, I don't recall who got me to the debate. So just to be clear. So I want to keep going. So you also call yourself, you're not a political person, yet you went to a presidential debate on behalf of Donald Trump. I also want to make it clear that you made numerous claims and allegations. You've made them today. You've made them before. And yet, even though you're not a political person, this is also another photo of you. You actually chose to show up at a press conference for Donald Trump prior to the debate because you're not a political person. Did you show up to a press conference for Donald Trump before the debate?
I can't qualify whether it was for Donald Trump.
Do you know who invited you? Sir, who invited you to the debate? Donald Trump, you said. Who invited you to the press conference?
Who invited me to get, my lawyers coordinated things and I showed up at a.
Well, sir, I will tell you, it was Jason Miller, who it's been very clear, it's been reported, who actually worked on the part of the Donald Trump campaign. Here you are at a Donald Trump press conference, and you can't remember how you got to the press conference. You refuse to answer how you actually got into the Donald Trump debate with Joe Biden. Do you remember speaking at the press conference?
I do very clearly.
You do. Do you know who Jason Miller is, sir?
I do know of him, yes.
Do you know that he was a Trump campaign staffer?
Mr. Garcia, you keep asking me semantical questions. You underestimate that I had 3 lawyers around me that were coordinating my travel, where I was going, and stuff.
Well, sir,
like that.
interesting.
So please stop.
Well, I'll reclaim my time. Thank you very much. It's interesting, sir, because you show up to a pre-debate press conference. You show up to a presidential debate, both invited to by a person running for the presidency of the United States. You know the stakes are high, yet you have no idea how you got to the press conference. You don't remember how you got to the debate. And here you are speaking at a press conference of which the national media, so how did you get to this press conference?
I flew on a plane.
Who invited you?
Are we going in circles?
Sir, who invited you to the press conference?
My lawyers told me I was invited to come to Tennessee. At that point, I was trying to get the truth and the facts out to the American people. At that moment in time, if I recall, I believe 80 million people watched that debate. And that was probably the
Thank you, sir. I reclaim my time. Well, with that, I think it's very clear for someone that can't remember how I got to a Donald Trump press conference or a Donald Trump debate, you're completely an uncredible witness, sir. Thank you, and I yield back.
Gentleman's time has expired. Chair now recognizes Chairman of the House Ways and Means Committee, Jason Smith, for 5 minutes.
Thank you, Mr. Chairman. We've previously heard from 2 IRS whistleblowers that Joe Biden was the brand being sold by his family members. One such example of this could be seen in a June 6, 2017 WhatsApp message where Hunter Biden told a business associate that he was not willing to, quote, sign over my family's brand, close quote, or give them, quote, the keys to my family's only asset. Mr. Bobulinski, can you confirm that President Biden is the brand being sold by his family members? Thank you. During his deposition, Hunter Biden repeatedly testified under oath that his father was not involved in his business in any capacity, and that there wasn't even a connection between his father and his businesses. Here is just one example. Quote, I just state for the record one more time, under oath and under penalty of perjury, my father has never been involved in my business. I have never asked my father to be involved in my business. My father has never benefited from my business, and I have never asked anyone or my father to do anything for the benefit of anyone I've ever done business for, close quotes. Yet the Ways and Means Committee released a WhatsApp message that were provided by the IRS whistleblowers showing that Hunter Biden wrote on July 30th, 27, quote, I'm sitting here with my father, and we would like to understand why the commitment made has not been fulfilled. I'm sitting here waiting for the call with my father. Moreover, you testified that Hunter was not shy about his ability to get his father on the phone And Devin Archer testified that there were multiple instances in which Hunter placed his dad on speakerphone. Mr. Bobulinski, was Hunter Biden telling the truth when he testified under oath that his father was never involved in any of his business dealings?
No, he was not. Those are all blatant lies.
We continue to hear claims that President Biden was not involved in his family's business dealings and that he did not benefit from illicit business deals. However, IRS Special Agent Joe Ziegler provided documents to the Ways and Means Committee, 327 emails, many of which involve Hunter Biden and Hunter Biden's business associates. Mr. Bobulinski, do you have any personal experience that leads you to believe that Joe Biden was involved with Hunter Biden's business associates and business dealings?
Yes, I do.
You want to say a few?
That to outline how Joe was involved?
Yeah.
Yes, different congressmen and women keep trying to say that there's no evidence and use the word involved, which is a very opaque language. If Joe Biden was not involved in his son's business dealings, why, after flying all the way across the country to the Milken Conference, where there is next to Davos, is probably the biggest conference in the world, why would he take 45 minutes out of his night? It wasn't a 10 a.m. meeting. It was 10:40 in the evening. He's an elderly man, flew all the way across country to sit with me for 45 minutes to an hour to discuss my background, the business we were doing with the Chinese, his family's background.
Speaking of the business with the Chinese, in October 2020, Joe Biden asserted that his family had not earned money through business dealings in China. However, IRS whistleblowers shared evidence that the Biden family made at least $1.1 million from their business with China, including $100,000 in payment from CFC, China Energy, and a $1 million payment in exchange for legal services that were never provided to a CFC official, Patrick Ho. Mr. Bobulinski, do you know whether the Biden family made any money from China?
They did, millions of dollars, I think approximately 8 to 9 million.
The Biden family has made millions of dollars from China, correct?
Correct.
And you said at least 9 million?
Yeah, I think it's actually over 10 million, but I'll leave those details up to you guys.
Thank you. I yield back.
Gentleman yields back. Chair now recognizes the ranking member.
Thank you, Mr. Chairman. Thank you, Mr. Parnas, for being here today. Your involvement with the real Russian hoax about Joe Biden began in 2018 when, as a big donor and a big supporter of Donald Trump's, you were introduced to Rudy Giuliani, and you began working with him to dig up dirt on Joe Biden, Ukraine. If you can just tell us quickly how you got involved in that.
Yes, I was a donor at the time. I became doing business with Rudy Giuliani. He got involved in a business I was doing called Fraud Guarantee. And in the midst, we started spending a lot of time together until eventually in November of 2018, he approached me and asked me about my connections in Ukraine. After telling him about people that I knew and things that I heard, at that point, then he wanted me to go to Ukraine to find Viktor Shokin, the prosecutor general.
And basically, he wanted to go from his fraud guarantee to guaranteeing a fraud on the American people. But after turning over every stone and going down every rabbit hole, including interviewing Viktor Shokin and Zlochevsky, the owner of Burisma, did you ever find the smoking gun or any evidence that Donald Trump was looking for to paste on Joe Biden?
On the contrary, Representative Raskin, not only did we keep hitting dead walls and not finding the smoking gun, but we kept running into sources of the information that was coming out of Russia.
In fact, Joe Biden was part of a global campaign, including by the United States, to oppose corruption and to go after the corrupt forces in Ukraine. Isn't that right?
Yes, sir.
At what point did the campaign to dig up dirt on Biden become a campaign to spread disinformation and lies about Biden?
At some point, when we hit a few brick walls, all of a sudden, then I saw the shift between the BLT group, which included John Solomon, the media personality, and Rudy Giuliani and other Trump lawyers, to start trying to push narratives that were we had they were not validated. We had no way to validate them. Basically, a letter would come over from somebody in Ukraine. I'd hand it over to John Solomon. Next thing you knew, he was on Fox TV 2 hours later with Sean Hannity.
At what point did Mr. Giuliani begin working directly with Russian agents and Russian assets, individuals who would later become sanctioned by Donald Trump's own Treasury Department for spreading propaganda and disinformation against Joe Biden?
It was sometime in probably around May, June of 2019.
Were you aware, was Mr. Giuliani aware that these people were basically just doing the bidding of Vladimir Putin?
Absolutely.
So he had no hesitation about spreading lies that were concocted by Russian agents?
As long as it fit the narrative, absolutely not.
How were you and Giuliani able to take these false allegations peddled by corrupt officials and Russian agents and promote and amplify them here in the United States, in our political system? Weren't media groups skeptical of your claims?
Most media groups, I'd probably say all except for Fox and a few other right-wing media groups, didn't want to take any of the information, and that aggravated Rudy Giuliani and John Solomon and other players. And the main group that was being pushed through was Fox, Sean Hannity, and some other media personnel over there. But then there was also other people that were doing the bidding for the Russian people in Congress, like Senator Ron Johnson, like Congressman Pete Sessions that sits here right now, that was with me from the very beginning in this journey into finding up digging dirt on Joe Biden.
Is Putin's war on Ukraine today, which has cost hundreds of thousands of people's lives, is that part of the vaunted Russia hoax? Russia hoax?
Absolutely not.
Is it real?
Yes, absolutely.
I want to ask you a more personal question, if I might, Mr. Parnas, because in my several years living through this extraordinary period of American history, I've tried to ask people like Michael Cohen and Cassidy Hutchinson. I've wondered about people like General Milley, General Kelly. Why did you break with all of the deceit and corruption and lies of Donald Trump? How did you get out of that culture?
I mean, it was very difficult. I actually had to hit a brick wall myself and get arrested, and to be able to get out of that cult. Because when you're in that cult, when you're around them, you have blinders on, and you're only able to see a certain amount of information. You're only able to hear the certain amount of information. You're not allowed to go out of the circle. And if you go outside of the circle, then you're not in the circle. So eventually, you brainwash yourself to believing certain things that are not true. When I was arrested and had some time to reflect and really understand what was going on, I started realizing, looking back and thinking back to moments in time where I started thinking myself that this can't be true, and we're doing something wrong.
Well, thank you for telling the truth and helping America to end this nightmare. I yield back to you, Mr. Chairman.
Chair now recognizes the chairman of the House Judiciary Committee, Jim Jordan.
Thank you, Mr. Chairman. The ranking member just said that quote, Joe Biden was opposed to corruption. Really? So opposed, he leveraged $1 billion of American tax money to fire the prosecutor in Ukraine who was investigating Zolochevsky at Burisma, the company Hunter Biden sat on the board of. Wow. And the prosecutor who replaced Shokin, that Mr. Parnas referenced in his opening statement, Mr. Lutsenko, guess what he did? He took Zolochevsky off the wanted list and dropped the charges. Wow, he's really, really opposed to corruption there. Mr. Bobulinski, who's the big guy? Are you sure about that? Because when
Jordan, Joe Biden.
Sure? You're sure?
I'm 1,000% sure.
Because when Hunter Biden did his deposition under oath, he said, I don't know who it is, even though he was copied on an email that said H will hold 10% for the big guy. You sure it's the big guy is Joe Biden?
1,000%. And there's other text messages that back that up, that the brave whistleblowers, Shapley and Ziegler, have produced. Not from my phones, not from my BlackBerry that I took screenshots from. They took them from subpoenas directly from Apple's iCloud that back up the fact that Hunter knew the big guy was Joe Biden.
The big guy is the brand. The big guy is the lift. The big guy is the one who showed up at golf outings, who took phone calls and meetings and lunches and dinners with Hunter Biden and his business associates. Is that right?
Correct.
Mr. Galanis, you referenced in your opening statement, May 4th, 2014, you were at a party at a restaurant in Brooklyn, New York. Can you tell me who else was there?
Yeah, it was a birthday party, so there were more than 100 people there, but amongst them was Devin Archer, myself, the host, Alex Kuklarski, Yelena Baterna, her husband, and then Hunter Biden joined.
And
after
tell us,
I arrived
I think you referenced a phone call that took place. Tell the committee what happened with that phone call. Who was involved in that phone call?
As I testified in my opening statement, it was Yelena Baterina, her husband, myself, Hunter initiating it, Joe Biden on the speakerphone, and Devin Archer.
So there was a little pull aside where that group of people you just described were pulled aside, and Hunter Biden called his fathers or called the vice president. Is that accurate?
That's accurate.
And then tell me what was discussed on the call.
The discussion that testified was a relatively short discussion, but it was a discussion about Yelena and Yuri coming to town. As they testified specifically, they talked about being good to his boy, and it was.
Well, let me ask you this.
Mentioning that,
Mr. Galanis, let me ask you this. Did you get the impression Joe Biden was expecting the call?
Yes, to me, it was clearly set up ahead of time. It was an arranged call.
So this was arranged, this was coordinated. Hunter Biden calls his father, then vice president. And I think in your deposition, he said this, I'm here with our friends that I told you were coming to town. So it's our friends, and I told you this was going to happen, which suggests that it was most definitely coordinated. Is that accurate?
That's accurate, yes.
And again, can you tell the committee who Miss Baterina is again?
A Russian billionaire, wife of the former mayor of Moscow, served for near 20 years as the mayor.
She's the wealthiest woman in Russia. She'd already given money. She'd already given money to Hunter Biden and his business before this meeting in May, and then subsequent to that meeting, she committed to give more money. Is that accurate?
That's accurate.
So subsequent to the coordinated call, the arranged call that Hunter Biden had with the vice president of the United States, the wealthiest woman in Russia commits to give millions of dollars more to Hunter Biden's business. Is that all accurate, Mr. Galanis?
That is accurate, yes.
And again, this was a pull aside done at this meeting, and you think and you know that it was coordinated. Is this what they call access to the brand, access to the Biden lift? Is that what you would describe it as, Mr. Galanis?
I don't think there's any doubt that was the intent of the call and the objective, yes.
And it followed the motto. It followed the statement that you all agreed to: say it, forget it, write it, regret it. This wasn't put in writing. This was a phone call on a speaker that was all, there's no writing about this. It was all done that way. That was how the business operated. Is that correct, Mr. Galanis?
Yes.
I yield back.
Gentleman yields back. Chair now recognizes Mr. Lynch from Massachusetts for 5 minutes.
Thank you, Mr. Chairman. I want to make an observation here. I've been on this committee, this investigating committee, for over 20 years. And as an attorney before that, I've had sufficient training and experience to say that with high confidence that when you review the entire record of evidence of these hearings going back over a year, you've actually provided more evidence to impeach Donald Trump for a third time than you have in so much as laying a glove on President Biden. We keep on hearing about the Biden family. When you hear someone say the Biden family, that translates into, we have no evidence on the president, so we're going to use the Biden family to try to implicate President Biden. But by the constant bumbling and continually shifting arguments here, you've done nothing more than exonerate President Biden. We heard initially for months, we heard about the Hunter Biden laptop. And, there were absolutely some embarrassing photos on that and some awful information about Hunter Biden's personal life. I will admit that. Then you bring in your own witnesses, your legal experts before this committee and have them testify. And what they said was amazing. They said there was no evidence to even suggest that there was support for articles of impeachment against the president. That was your legal experts, the Republican legal experts that said that. Then we have statements by Mr. Jordan saying that Mr. Smirnov was the most corroborating witness that the Republicans had, the strongest witness that they had. And of course, after that, we find out through the Trump-appointed prosecutor that all of the information that Mr. Smirnov had provided was fabricated, false, and submitted by the inducement of Russian agents going after President Biden and trying to undermine our democratic system. And now we come to a point where, since that witness blew up, now we're going to prison, and we're reaching out to witnesses who have been convicted and sentenced to prison for stealing $80 million from the pensions of innocent workers. We can't get any lower at this point. That's your star witness. I want to remind people, he's sitting in prison. That's why he can't be here today. He's sitting in prison for scamming workers' pensions. I mean, how low can you get? Then it's the Republicans' idea that this is the best guy they can get to testify against the president. This is the best guy they can get. A guy sitting in prison who can't even be here. Mr. Parnas, you've talked about your own direct involvement with Mr. Giuliani, and you said that your mission was to dig up dirt on President Biden. Can you talk to us about the coordination between yourself and Mr. Giuliani? Thank you for being here.
Thank you, Congressman. So basically, it was a shadow diplomacy run by Trump and Giuliani, where Giuliani was the shadow diplomacy Secretary of State. I was his right hand and basically the point person in Ukraine to not only dig up, validate, search, whatever needed to be done to try to find up some corruption against Joe or Hunter Biden to be able to present. Once I would receive whatever information I received, I would then meet with him, John Solomon, other members of the team like Pete Sessions and Derek Harvey or other people there to discuss what we found. At that point, from there, Giuliani would then go to the White House and share with the president. And that was the line of communication.
You said also in your testimony that members of this committee, the Republican leadership, should have known before Smirnov was indicted that this information was fabricated about President Biden. Could you talk about that?
Congressman Lynch, not that they should have known, they did know. They knew exactly what was going on. They knew that the evidence was not vetted. This information was just coming in from anywhere from left to right field, and it was being pushed straight to the halls of Congress without zero verification of it.
Okay, thank you. Mr. Chairman, my time has expired and I go back.
Gentleman's time's expired. Before I recognize Mr. Palmer, I'd like to enter into the record the testimony of Tony Bobulinski with the committee on February 13th, 2024. It corrects the record of Representative Garcia's, who did not provide your entire testimony. On page 147, you told the committee about your understanding of who invited you to the events referenced by Mr. Garcia. So without objection, I'd like to enter into the record the entire transcribed interview of Tony Bobulinski.
And Mr. Chairman, I'd like to enter for the record an article from today's Daily Beast entitled "Texts Reveal More Russia Ties for Key Anti-Biden Witness Bobulinski."
Okay, Daily Beast. Without objection. Chair now recognizes Mr. Palmer from Alabama for 5 minutes.
Mr. Bobulinski, I have very limited time and I want to get through a lot of information, so please answer these questions with a yes or no, if you don't mind. You have met Joe Biden, isn't that correct?
Correct.
In fact, you had a meeting with Joe Biden, isn't that correct?
2 of them.
One of those times was before the Milken Conference in Los Angeles, May of 2017, is that correct?
It was during the Milken Conference.
You provided a great deal of documentation to this committee. I want to show you some messages between you and Hunter Biden, be on the screen here, in May of 2017 before you first had a meeting with Joe Biden. These are messages between you and Hunter Biden dated May 2nd, 2017. Do you recognize these?
I do.
At the bottom, Hunter wrote, "Dad, not in now until 11. Let's me and Jim meet at 10 at Beverly Hilton where he's staying." Jim is James Biden, President Biden's brother. Is that correct?
Correct.
The next set of messages is, if you put those on screen, is between another business associate of Hunter Biden's and you. His name is James. Do you recognize it?
I do.
At the top, you write, "About to meet Hunter, Jim, and I guess Joe at Beverly Hilton Hotel." Joe is now President Joe Biden. Is that correct?
Correct.
This chat between you and Joe Biden, Jim Biden, Joe Biden's brother, you write to Jim, "Great to meet you and spend some time together. Please thank Joe for this time. It was great to talk. Thanks, Tony B." You met with Joe Biden, Hunter Biden, and Jim Biden the night before the Milliken Conference in 2017. Is that correct?
I did, and Jim Biden perjured himself by trying to deny that
Thank
meeting.
you, Mr. Bobolinsky. That was at the Beverly Hilton, correct?
Correct.
You can provide more details around that meeting. What was the purpose of that meeting?
I didn't ask for the meeting, so I wish Hunter Biden was sitting next to me and he could under oath describe it. But the only reason why I was meeting with Joe Biden and the only reason why I was there is because I was the CEO of the enterprise that they were putting together with the Chinese company CFC.
So can you give me a little more detail about what was discussed in the meeting?
Well, as I said earlier, before Joe Biden showed up, Hunter and Jim Biden coached me, asked, said a sort of outline that we wouldn't go into a lot of details. So through the 45 to 60-minute meeting I had with Joe Biden, I think it was about 10:40 p.m. after he flew across country, we talked about my background, my family's military background, the different business ventures I'd done around the world, the family I worked with. Joe spent time talking about his family, some of the tragedies that they had lived through. And at a high level, Hunter actually introduced me to Joe because before Joe came and sat down with us, Hunter said, "Hey, give me 5 to 10 minutes. I need to read my father in on it."
So when you're referencing Joe and Hunter's father, you're referencing President Joe Biden.
I am.
Correct. These 4 images, well, in this message you sent to James again, you said you spent more time with Joe and Jim this morning, and to be factually correct, that's President Joe Biden and James Biden, his brother. Also saw them last night, including Hunter. These 4 images show a pretty clear record of your meeting with Joe Biden in May of 2017, Mr. Bobolinsky. Hunter Biden, during his transcribed interview, testified that the meeting did in fact take place. And after being asked, did Mr. Bobolinsky meet with your father during the trip, Hunter stated he met with him in the lobby of the hotel. When asked who attended the meeting, Hunter replied, "My uncle and myself." But when asked whether the meeting at the Beverly Hilton between Joe Biden, Jim Biden, Hunter Biden, and Tony Bobolinsky took place, Jim Biden testified, "Absolutely not." These stories don't match up. Mr. Chairman, Jim Biden also told the committee that Joe Biden did not meet the Chinese businessman Xi Jinping. Rob Walker, by known as a friendly witness committee, said the opposite. So, Mr. Chairman, it appears to me that there are material inconsistencies between the witnesses' testimony. These witnesses' statements appear to me to be irreconcilable. In short, Mr. Chairman, someone appears to be lying to the committee. The inconsistent testimony seems to come from Jim Biden, the president's brother. Lying to Congress is a serious offense, Mr. Chairman, a criminal one, in fact. And if the Bidens or anyone else has come before this committee and lied to this committee, I strongly encourage the committee to pursue criminal referrals to the Department of Justice. One last thing that I want to ask, and Mr. Bobolinsky or Mr. Galinas, have either of you heard of any offer of a pardon for anyone involved or associated with or a partner to the Biden family enterprise corruption investigation?
I'm sorry, that was a question. Have I
Have
heard
you
anything
heard of anyone being suggested that a pardon might be in order for anyone associated with this enterprise?
I have not.
Thank you, Mr. Bobolinsky. Thank you, Mr. Chairman. I yield back.
Mr. Chairman, I just have a parliamentary inquiry. But we've heard for months now and seen that the photo of that BlackBerry with the cracked screen. Does the committee have in its possession the data from Mr. Bobolinsky's phone from which he's allegedly taken these pictures? Because I think we need the data that they keep referring to. And maybe Mr. Bobolinsky could just turn it over to us, or we could subpoena it today.
We have the images that we have shared with you.
Right, I saw the picture of the cracked BlackBerry, but do we have the underlying texts that are being referred to by my friend, Mr. Palmer?
Mr. Bobulinski previously said he'd be happy to turn over his phone.
We
so
have,
could just
we
ask
have
him.
pictures of all the text message screenshots that we've provided with everyone on the committee.
Okay.
And
all right, well, of course, he's just given us, obviously, the ones he's selected. I'm wondering whether we could get all of those texts, and I would move that the committee subpoena Mr. Bobulinski's BlackBerry phone on which messages with Hunter Biden and the Oneida Holdings partners are saved. He stated that he's willing to provide it to the committee, so it should be rather simple.
Mr. Chairman.
Yeah. Okay, there's a motion to subpoena Bobulinski's BlackBerry.
Yeah, with the texts that were just referenced by Mr. Palmer.
Chairman, I move.
Chair recognizes Mr. Jordan.
I move the table in motion.
There's a motion to table.
I request
The
a report
motion
of
is to table is not debatable. As many as
Mr.
in
Chairman.
favor of tabling may signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it, and the motion to table
Well,
is agreed to.
Mr. Chairman, what we're doing is we're tabling evidence here, which you keep relying on. So I'm going to ask for a recorded vote for that. That just makes no sense.
A recorded vote is ordered. We'll suspend for a moment. We don't, this is a
Because your people ain't.
committee hearing. We don't have the clerk. Will somebody go find the clerk?
He said it, did he say under oath in the, did he say?
Would,
Did he say under-
Mr. Speaker, Mr. Chairman,
Give it over in the-
Mr. Minority Leader, do you think it's possible that the witness would voluntarily just give it?
But I had understood actually that Mr. Bobulinski had volunteered when he was asked about this. It would simplify things if he would just turn it over the BlackBerry.
Well, he did very clearly say he's happy to turn over his BlackBerry to the committee. We then asked for it at the deposition. He didn't. We've asked the majority to
You're
ask for
Mr.
it.
Goldman, you're out of order. We're in suspension here waiting for the clerk to come so we can take the vote that your side of the aisle requested.
You can't make this stuff up.
You can't.
This is Jurassic Park. Gee.
Mr. Ranking Member. Mr. Ranking Member.
Yes.
I solely want to underscore the importance of this.
I'm sorry, gentlelady's out of order. You can come back here and talk to him if you want.
Mr. Chairman. Mr. Chairman,
Yes.
we don't even have,
You're gonna, I said Ms. Ocasio-Cortez would have to come up. You will as well. Sorry.